Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense. So
no, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the notion, I am inclined to believe that you are both the agent and the persons. And it's
I'm not a person, I am one of the people, thank you.
Okay, thank you.
I'm also one of the people, thank you. Welcome to the Court of Public Opinion. I am the recovery addict. Thank you very much for being here this morning. So many of you on time, early actually. I guess I'm early. But court is going to start soon, and we don't want to miss it. We've got our live feed all ready from the courthouse. Let's see if we can listen in. Ooh, nothing juicy yet, but it's coming. It's coming. Let's see. Do you think we'll have a verdict today? Yes, but before we do that, so we need to have something else. Let's see. It's missing. It'll just take a while. Just everyone pause. Pretend that this snafu did not occur. Hang on. There we go. Boom. There's one. Oh my goodness, I'm tiny. I moved my camera. I took my camera out on a field trip yesterday, and so I'm a little late. I've got a blurry camera up here. I've got the scratched one instead of the good one. Either way, we have got Kim here. Kim R is here again. She's almost an honorary owner of the internet, like by default, de facto. Kim, you are a repeat offender, habitual offender as far as being first in chat. It's wonderful. Thank you. We appreciate that. As such, you know the drill. The internet is yours to maintain throughout the day. We expect to have verdict watch today, so please keep it on its best behavior throughout the day. Appreciate you being first there. Nice shirt today. Thank you, Dr. Jennifer. I was taking calls last night, or yesterday, actually. Let me turn that off why am I so stinking tall? Hang on. Is that too short? Is that better? Now I'm blurry. Okay. Yeah, right there. Okay, so I've got my crisis cleanup shirt on. I was taking calls yesterday from the hurricane. It was... there's nothing quite so humbling as talking to people who have it really bad, and talking to families, especially down there in Perry, Florida, that was basically one of the areas that took the most damage in a concentrated area. They're a little ways inland, but that town was like the big populated area that took the first big hit, and talking to people whose roofs are missing. And they've got, luckily not a lot of flooding in that area. The wind was just, there's one lady who said, I'm at the end of the road and all my neighbors' fences, all their roofs, and all their trees are in my yard, and I can't even see my lawn. I think it's about a foot deep out there. I just need help. Just crazy down there. So keep them in mind as they're trying to deal with the new normal, which is a completely changed skyline, devoid of trees. This is in the way. Little racks in the way. It's always been there, but today it's in the way. All right. Where were we other than that? Let's see. We're getting ready for court, right? Let's take a quick peek. Yep, we are. Okay. A little off center, but we can live with that. Let's see. We want to be here. There we go. Let's see. This camera, it's not the prettiest. It's not the prettiest at all. As you can see, I've got my shorts on today because it's a No Pants Friday. Happy Friday. Happy Labor Day weekend eve. Is officially Labor Day weekend starts today, right? So it's not really eve. Yesterday was Labor Day weekend eve. So happy Labor Day weekend to all of you who are going to celebrate that. Will you be putting on eyebrows for the verdict? I don't think so, Dodie. I don't think so. Let's see. To all those who who encouraged and basically trapped me in requiring me to purchase ice cream and treats for my two littles who helped me on the hurricane flood watch live stream yesterday. The two of them, they thank you. We stopped at a restaurant and got some food and dessert for them. Thanks to the donations that went straight to them, and and now they want to do more live streams. Go figure, So look what you started. All right, let's see. Littles are adorable. They take after their mom. They really do. Whoa! 80s Music Man has a birthday this weekend. A birthday. So because we're not going to be live tomorrow, and probably not even Monday. Honestly, I'll tell you my plans for Monday in just a minute, but it's a holiday, so no court's going to be in session. I'm probably going to do my last big treasure hunting search of the season on Monday, but I'll tell you about that if I don't forget. 80s Music Man, however, has a birthday, which is awesome. Who shares a birthday either today, I guess from now till Tuesday? This could be a lot of people. From now till Tuesday, we're going to have to include all the birthdays there. Karen, welcome to the gallery. I love the Scottish flag there. I appreciate you being here. Karen Games. Is it Games or Gamez? Or Games. Those are your three options. Unfortunately, you can't have any other pronunciation. Those are the three I'm going to allow you today. But thank you very much. Appreciate you supporting us as a member there, and that's wonderful to see the courthouse change by your name. Okay, we've got. Let's see, this audio off. What do I need? I need something else right there. Hang on. I've got like a blank box on my screen, and we cannot have that. Let's put... Oh, man. Is JT awake this early? I just saw JT's up on Brandy's channel. Wow, I didn't know he knew what mornings looked like, honestly. I didn't. Don't tell him I said that, but he's looking good this morning. Looking great. Let's see. So do I. Sunday is my 60th. Okay, so Gally May and 80s Music Man. All right, did I miss anyone else? That's what we're going to do. That's what we're going to do. Okay. La 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 la. All right. Good morning, Vietnam. Thank you for that. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, 80s Music Man and Gally May. Happy birthday to you. 80s Music Man and Gally May. Today or this weekend, you are going to have a special day. Appreciate both of you for being here today and letting us share this day with you. The privilege is ours. I know there are a million places you could be this day to celebrate your another trip around the Earth or trip around the sun. I said Earth last time as well, but it's a privilege that you decide to spend it here with us, and hopefully we can make it a little bit lighter and wonderful for you. You guys, you both are amazing. Thank you very much. I said guys, but that's not always the case. All right. That is wonderful, wonderful. Happy birthday. We got that done before the judge came in, which is probably good. He doesn't want us singing in court. So, let's see. Your daughter looks and sounds just like Mrs. R.A. She really wants to do a YouTube channel. She really does. She wanted to do one where she just reads books to people, reads stories, because I'm not sharing something that she hasn't, my wife hasn't shared already, but my daughter's dyslexic, and reading was a huge challenge. I mean, if you're not familiar, for dyslexic people, oftentimes they'll look at a page and the letters just jumble. They don't make sense. It doesn't click very easily, and it was a real struggle getting her to the point where she wasn't just bursting into tears at the thought of having to read. And we worked. Mrs. R.A. has some great information that she shares on her channel about how we overcame that. But she now loves to read, even though it's still a lot of work for her, and she puts in the work and she loves to read. And so now she loves to be read to, and she wants to read to other people. And so she wanted to do this on YouTube. She's like, I can read stories to people that can't read, people that have trouble, and she's so excited about that. The only problem is it's not legal. Okay, almost every book that she can read is under copyright, and she can't do it. So she's sort of stymied at this, but she really wants to have a YouTube channel. Eventually, we're going to figure out how she can do that. Denise Feldman Ersland, has it really been 8 months already? I just totally jammed out dancing in my chair to you singing. Thank you, Denise. Appreciate that. Hope. Yay, although been around since March watching. Yes, Hope. Yes, you've been here much longer than your courthouse does reflect. I appreciate those who either lurk or do report for duty like you do publicly. All right. Where are we? Court. Let's bring this up so we don't miss anything. Thanks, the cameraman fixed my little OCD issue. Thank you for listening. See, Gally May and 4 months. Love you all. Happy birthday. Happy Friday. Happy 4-month anniversary. It's all falling on the same weekend. That is wonderful. Catherine, I hear you. Your daughter's dyslexic. It's a challenge. It's really a challenge, and she is such a smart girl. My daughter. I imagine yours is as well. She's such a smart girl, and her memory is incredible. Her imagination is just off the charts. But yeah, she does love to read now. Take her to the library, and she will check out every book in the library if they would let her. All right. Let's see. I went by Scottish Lassie before. Now just going by my boring old name. Karen, you don't have a boring old name. That is awesome. There was a ding. What was the ding? What happened? Oh, my phone is dinging. Okay. That's all right. I can fix that. I mean, that's not a problem, but... Okay, where are we? We're expecting court to start in the next minute or so, so we don't have much time to cover anything. Is there anything I need to talk about? Oh, yes, we need to talk about what's going to happen today. First of all, we have, I think, one more witness, and that would be Rita, the second defendant, the mother of the child that passed away after being left in the car. So Rita is expected to take the stand first thing today. It probably will be similar testimony in length and cross to what we saw with Larry King. And then following that, we should go either. I don't remember if Judge Newman does jury instructions first and then does closing statements, or if he does closing statements and then jury instructions. But those are both going to happen. If the jury will get charged, he's already picked a foreman. No, he didn't do that on camera that I know of. But there's a woman that he refers to as Mrs. Foreman or Madam Foreman. So that's already taken care of. And so they'll go right back to deliberations. And honestly, I'm personally, I don't want to let the cat out of the bag here, but I think that she is going to, or the foreman and all the other jurors that under her tutelage will reach to a quick conclusion on this one. Cass says, since she loves math, could she work through a math problem online with Mrs. R.A. just to get her started? We probably could. We are... yesterday, notwithstanding yesterday, we actually are fairly protective of our kids online. So in that setting, we were cool with them being online and everything that way. But normally, we're thinking of how to do this best, because letting kids loose on the internet for public, ridicule or commentary and things like that can be very, very damaging, honestly. And it's not something we take lightly. As far as, if people are able to comment and someone says something mean, a troll finds her channel or something, that can be soul crushingly devastating. So we're gonna play it slow, but we'll figure something out. 80s Music Man says, my birthday's Sunday. My courthouse is yellow. Yay! Going miniature golf. I wish you could sing. I wish you could sing, but dang, court. Yeah, I did sing. Did you not hear? Did you not hear? You have to rewind. I sang to you. Let's see. Jackie Ferrer. This puts us in a dilemma. It's going to be the biggest trial in the country, and it's packed full of everything but pickles. It's just straight politics. I don't know. We are all friends here, and I imagine I don't want anyone to put their hands up or anything, but let me just tell you, I can promise you that in this group of people where we are very good friends, we know each other, we are familiar with the big things that are happening in people's lives. If we were to ask the question, and I'm not, we would have people on both sides of the political aisle as far as the U.S. goes. It's very divisive. It's very divisive. So I'm not asking that. I don't want you guys to share that. I don't know, as much as I'd like to follow a trial like that, I don't know how we could do it and still and keep the vitriol, the bickering, the partisanship out. It would, I don't know how we could do it. Unless we had chat turned off and I didn't make any comments, and then it's no fun. I mean, why watch on the channel for that? Anyway, yeah, that's going to happen. Anything else? Let's see. Rita has had a couple days here to think over how she's going to testify and what she's going to say. So I wonder what she's going to do. What about her making up some stories? She reads those with her imagination. I'm sure she could make up some great ones. Dodie, she is very artistic as well. She loves painting. She loves like the diamond painting stuff. She's working on a couple of those projects. She's done some work with clay. So that's probably where we're going to go. It's just a mess. And honestly, doing art projects next to all this equipment is a little nerve-wracking for me. But we're going to figure something out. It's all right. We've got time. It's no rush. Mike W., hello. Welcome. Good to have you from Northumberland, UK. Wonderful to have you here, Mike. Thank you. Plus, we get 1,000 trolls a day. Oh, the trolls. It would be nonstop trolls from whichever side. And I'm not saying one side has more than the others, because nobody has a monopoly on trolls, unfortunately, when it comes to politics online. I agree. There are other trials less polarizing to watch. I think that's what we want to do, just to preserve all of our sanity. Kansas Sunshine, welcome to the gallery. Thank you very much. I love that green courthouse by your name. Appreciate your continued support. Look at this. Be Kind #1 for 5 months. I'm back from the abyss. My anniversary on Monday. Missed you all. Be Kind. Thank you very much. Good to have you here. Momo Shark is also here. 4 months. Great place to be. It absolutely is. But it wouldn't be the same without you. Appreciate you being here for that. Yes, let's all remain friends. This is the best advice for the day. Let's, if there was a sign that I see almost every day. It's actually in the neighborhood where I go to church. And as I drive out, these people have a sign that says, if you can be anything, be kind. And it's like, yes, that's just great advice for everybody. Although we need a bigger sign and put it right on all the busy roads. Let's see. All right, I'm disappointed the prosecution didn't spend more time with experts to talk about how the car works, shuts down, AC on, AC off, etc. And that was sort of weak because the one person that testified on it is just a police officer who's like, oh, I messed around with the car and I couldn't get it to work. It's almost like he's like, I couldn't figure it out, was the testimony. And he did later come around and say, we determined, and he tried to get in and we called the factory and they said, but I think that part got objected to and struck down. But basically he said it's impossible for the lights to flash and the car to be on. And the lights were flashing in the video, which means the car was not on. That's what we got. And we actually got better verbiage of him saying that on cross-examination than on direct, which was funny because they basically did more harm than good in trying to fight the little bit that did come in. Nope, hiccups again. Oh, Reverend Beasy. She's autistic as well. Got really excited, then figured out you said artistic. Yes. I don't. Let's put it this way. I don't think we have any children that are far enough on the spectrum to be considered autistic in any way. We've got a nephew who is nonverbal autistic and just a wonderful kid. Let's see. Where are we? Oop, somebody's standing. The judge might be coming in. Here we are. Look at that. We're getting started right away.
Good morning.
Okay, let's get some audio in here.
Any matters before the jury? Mr. Phillips.
Mayor, Your Honor, I think Sean Ford didn't want us to ask that as far as any of the arguments regarding jury instructions, wait until we finish with the witnesses or in hearing break.
Bring the jury. Any enlargement? Is that the word you said?
No, Your Honor.
What did you say?
I
It's like you said, any enlargement.
An argument.
Argument. Okay, I've got you. Okay,
But if we're all on the same page, we'll go ahead and keep it rolling.
sure.
Thank you, Your Honor.
All right.
Your Honor, if it's possible, prior to the jury coming in, if Your Honor has proposed some jury instructions I could review during the testimony, I'd love to have them.
I don't. Mr. Phillips has submitted some, and
The dude's like, I'm going to be bored during this testimony. Can you give me some reading material?
You can, if you like to review some from a previous case.
Your Honor, standard charge, yes, sir, that's what I'd like to review.
And some may or may not apply to this case because we haven't gone through them, but
I object.
Nancy, they're all fossilized
I
shark
don't
teeth.
intend to give them written charges.
And nobody knows exactly where they're like originating from. They haven't found like the mother lode that's being washed out. They just start appearing in the river in that area. And they always there's always more. I don't know how to explain it. But that whole area that I live in was all underwater a long, long time ago. And so sharks it was ocean, so sharks did swim there.
Let's give them back time.
About a magazine then. Just some reading material, anything to keep you entertained. It's very echoey today.
Copy those for you if you want to.
We've got
She can copy those for you.
Is that correct?
We've got what's called an onboard mic on the camera that is picking up all the sound. And it's I'm going to see if I can take just the top end off a little bit.
Strike through the word.
Yeah, I'll take just the very highest frequencies off. But they need some sound dampening in that room for sure. And better microphones. Reverend Beasy, thank you so much. You have been super generous, amazing. I've also got a zebra from you as well. I mean, don't discount what you've done. I appreciate you, and the kids absolutely loved it.
Bring the jury.
Oh, that was a good one. We want to replace that because the one I've got from him is.
Thank you. No, I'm good.
That's the one we had from him before.
You will bring the jury.
See, that's not nearly as enthusiastic as what we just heard. Bring the jury. So we'll have to get that. Let's clip that, somebody. Let's clip that. Bring the jury. Although we might need it straight from one of the other providers because I was talking over it. We're going to do a poll on verdict time as soon as defense number 2 rests. That's him right there. He's going to be the one asking the questions of Rita in just a bit. Who all believes the boyfriend? Great question, Holly. Did he come across as believable that the car was on?
And there you go. You can have these back. Good morning. Welcome back. Day number 4, defense's case. Mr. Phillips.
Good morning, Your Honor. Thanks.
Yes, sir.
Defense would call Jason Chapman.
Ooh, we've got another witness. It's an officer. They better know what they're doing here.
Good morning. Again, my name is Captain Jason Walker Chapman, last name Chapman.
Officer Chapman, you testified previously to the jury, well, on the first day of trial, is that right?
Yes, sir.
And you were sworn under oath.
I was.
And you specifically, under oath, told the jury that you cannot get that vehicle to flash the park lights when the vehicle is running. End of story. That's your quote.
Could not get the vehicle to flash the park lights when selecting lock or unlock. Those are my words.
Oh, okay. I went and watched the video, so I know you don't say unlock or unlock. Quote, you cannot get the vehicle to flash the lights when the vehicle is running. End of story. You said, we ran the test many times. Quote, if the lights are flashing, it can't be from that key fob. Those are your words.
If you say they are, I know that during that testimony at some point in time, I was very specific about the fact that that's in regards to lock or unlock.
All right, well, let's go through that because y'all spent painful detail to show this, and I know that's part of the argument. Dylan, we can do this one of two ways. I can either hook up my laptop or you can help if you don't mind. All right, if you go to...
They're impeaching him with his...
1645-33.
Oh, my goodness. This is not going to work.
To give kind of an overview of what we'll see on the video, essentially y'all went through the testimony after you watched the full surveillance cam video, that Night Owl DVR. And
Mr. Allen, are you posing a question?
Yes, Your Honor. So
you
we
must
understand.
Restricted to a question.
Yes, Your Honor. It's context for him, so he understands what I'm asking.
No, you must pose a question.
Yes, Your Honor. And so with that, and this is the 1645. All right, well, if you go ahead and play it. And so whenever Solicitor Stone played this video for you, we're seeing both Rita and Larry try to open the vehicle, and they have the key fob.
Judge is going to jump on him again.
She has the key fob, and she's hitting it towards the car, and you see that around 16:45:33, and basically nothing happens. In other words, like you said, that it won't flash when you're hitting unlock or lock.
I didn't understand the question.
Right here.
There wasn't
see her
one.
hitting the key fob?
I see her holding the key fob in her hand, but I can't testify that she's pushing the buttons.
All right, well, I mean, you can walk up there and look close if you want.
Trust me, Mr. Phillips, I have looked at this video extensively.
Understood. Can we roll it back? So you're saying that she wasn't hitting the button, she just stared?
No, sir, I'm not saying that. I'm saying she has in her hand what appears to be the secondary key fob that they retrieved from her residence off of Academy Road. I agree. And she does have it in her hand, and she does have it pointed at the vehicle, and she's making a motion with her hand, which would indicate that she may or may not be pushing the buttons. I just can't tell you she is.
Fair enough.
Thank you.
All right, so she comes back. Again, this here, she's pointing it. The jury can make up their own mind. They can see her doing what she's doing, and they need a chance at the appropriate time. They'll have the opportunity to stand right in front of the
Mr. Phillips, you must ask questions, not give commentary.
Yes, Your Honor. And so, at 16:46:08, Solicitor Stone asked you to go to 16:46, and that's when Rita hands Larry the key fob, and he's hitting the key fob repeatedly. And your testimony was, quote, cannot get the vehicle to flash the lights when the vehicle is running. End of story. Then you say, we've tested it many times, I can't recreate it. Quote, if the lights are flashing, it can't be from that key fob. That's your testimony. That's your words.
If you're saying that's exactly what I said without any of the context or post comments, then so be it. But I stand by the fact that you cannot, if the vehicle is running in direct correlation with lock or unlock, you cannot get the vehicle to flash the lights.
All right, so you'll concede that it will flash while the vehicle is running.
There are ways to make the lights flash with that key fob, but not in regards to pushing the lock or unlock button.
And we're about to see it in a second, and then we'll get there.
Are you asking me if we're going to see it?
Yes, sir. I promise.
Okay.
And so if you could go to...
He's doing such a bad job.
16:46:08. And this is where you said, look, the lights are flashing.
Sure.
The lights won't flash if the vehicle's running. So he hands, the key fob gets handed to Larry. Larry's fumbling around with the key fob, hitting all the buttons there, or maybe not. I know
Sure.
You'll fight with me on that. And then there's the lights flashing. You're saying there's no way those lights will flash like that if the car's running.
Now, right there is not the same point in time that Solicitor Stone and I discussed.
Oh, we'll get to it, and I got that.
Are you, hold on, you can't ask me something and run off from me. Do you want me to answer that question?
Go for it.
All right. Right there, those lights are not flashing in response to pushing the lock or unlock button. They're flashing in response to pushing the panic button on the side of the key fob. The difference is the style of flash and the pattern. The key fob, when the panic button is pressed, it will flash regardless of whether the vehicle is running or not running, as long as the vehicle has power. The difference is it is a very patterned, systematic flash. No matter how many times you press that panic button, it will flash in this pattern. You can't hit it 3 times and get it to stop and start again real quick. It will stop at the end of that pattern and pick up again at the next pattern. What you saw there was 1, 2, 3, I can't remember if it's 3 and 3 or 4 and 4. Those are responses from the vehicle and the fob to the panic button being pushed, not the lock or unlock.
And that's what you told this jury? Because I'm going to pull the video up of you testifying.
No one asked me that question.
Okay.
We were talking in regards to lock and unlock, and I encourage you to pull the video up because I'm very confident of what I said.
Okay. And so with that, the other time it flashes is when they pop off the handle when they're on with Stokes lock and key and manually turn it. It flashes.
There's another set of flashes between this set and when they actually get the door unlocked.
And your position is it's not the panic button?
That series after this, prior to the final set of flashes when the vehicle is unlocked, because you can physically put the key in the lock,
and it'll flash.
And when you lock or unlock the vehicle, it will flash, but that is not in response to pushing the lock or unlock button. That is physically turning the key. And we know by what they've stated and what we see on the video, the only time the key was actually placed into the key on the door, and that's the only key location on that 2012 Volkswagen. If you turn it left or right, yes, it will flash in correlation to lock or unlock. But the series after this and prior to that, my testimony was that cannot be done with the key fob because it is not the same systematic patterned flash that the panic button shows.
Actually, let's mark this as an exhibit.
I think she's still going to testify. Yeah, this impeachment, I think, is going to come back and bite him. He's expanded his testimony. It's more clear now than it was before that the car was not on if the lights were flashing.
Your Honor, what I've marked as a flash drive is the defendant's exhibit 15, 13. Sorry. And you were there when the tests were conducted. That's what you testified to.
That's correct.
Right. And y'all made a video of those tests.
We did.
She can change her mind if she doesn't want to testify, even right now. Do what I can, Ted. Hale Smith, welcome to the gallery. Thank you so much. Good to have you here. Appreciate your continued support.
All right, you can pause that for a second.
I wish you'd turn and talk to the microphone.
So you see how
He's going to get admonished by the judge again.
this right white part light out, right? It's not on.
Agreed. The daytime running light.
There you go. It's out on this side, right?
It is.
Okay. And so this is the looks like the video of the test y'all did on the video.
Yes, this is video of the very last test that we did prior to trial.
And the vehicle is running. We'll see.
Yes, it is running.
So you see the one light's out, the one light's on. Appears to be our hard reset. You see 12 a.m. on the clock.
Dead battery.
So this is, we get the entire front. This is going to go this way, right? So this is test hard running, lock running, vehicle not flash.
So that's what you just testified to. If you try to unlock or lock it, it won't flash while it's running.
That's correct.
All right.
With the fob and not using the hard key.
That's right. So just to make sure that everybody kind of understands it. Yeah, there you go. So while the car's running and you hit the key fob, unlock or lock or unlock, it's not going to blink.
That's correct.
It's not going to flash.
That's correct.
But when you hit the panic button, it will flash.
Regardless of whether it is running or not running.
So this is, we get the entire front. This is going to go this way, right? So this is test hard running, lock running, vehicle not flash. Unlock, will not flash. Panic button, will flash.
And when you turn it manually, it flashes.
That's correct.
All right, thank you.
Yes,
Your
sir.
Honor, at this time, I would move to admit defense exhibit number 13.
Any objection?
Without objection. Judge.
It's admitted.
Selena K, thank you for gifting the membership. I think that one went to Jen Pookie. You did. Thank you so much. I don't know why the kid was in the cop video where they're testing the car. You keep staring at this TV like it's going to do something different than what it's been showing all along. I just don't get it.
And Dylan, on this video, so 11:08:09, I think.
I ran a comb through it right before I went live, just for you. I wish the prosecution had brought in a car expert, maybe somebody from the dealership, a repair tech, anybody who could testify to the design of the car and how it functions. Princess Buttercup just gifted 5 memberships. Pooch is in the house.
Yeah. This is you. This is the testimony.
Yes, sir.
They're playing the testimony back to him.
He is pushing the key fob and the park lights are flashing, indicating you can see the lights flashing there.
Is this appropriate to replay?
The key fob is working, the vehicle is receiving a signal from the key fob. And I am not an expert, but I can tell you that I can replicate a standard. And when we put that vehicle inside the processing bay and we attempted to replicate that, you cannot get the vehicle to flash the park lights if the vehicle is running in the story. There's no, we also then contacted Volkswagen.
He just,
Over and over and over
just
again.
replayed the part he objected to.
If those lights are flashing from that key fob, the vehicle is not running. And I mean, it can't even be just the ACC. In other words, if you get in and start the ACC, right?
So a minute ago,
Could you let
ju-
it go just a little further? Because
Sure.
I know what you're going to ask me, and what I'm trying to explain to you is that you're not showing the same video clip. And in that clip that the solicitor showed at that time is not the same one where we're seeing the pattern flash. And yes, I see what you're asking me, but you're leaving out the pretext of this conversation and whatever else was said, where I'm specifically mentioned in regards to the lock or unlock button.
No, they were here. They know what he said. They just watched it.
The witness has not been questioned, he's just making a speech.
It's fine. They know what he said.
I have an objection.
Defense is objecting
well,
against
the objection
defense.
is sustained as to all commentary by everyone. The role of the lawyer is to ask a question and to give the witness an opportunity to respond to the question. It's not the time to give speeches in the middle of a question or commentary in the middle of a question by the witness or by the lawyers. Proceed.
Thank you, Your Honor. But your quote, and I understand you disagree with me, but your quote is, you cannot get the vehicle to flash the park lights when the vehicle is running. End of story. Your words.
I can't argue that in that particular video, right there at that moment, yes.
Your words. If the lights are flashing, it can't be from that key fob.
I'm going to answer it again. Yes. You're welcome.
Wow.
Mr. Toy, Joe.
Red pen.
Yes, sir.
Yeah, and I don't have any questions.
Thank you, sir.
By the state.
Thank you, Your Honor.
Okay, states can clear this up real quick. Red pen, thank you. Karen, but not that Karen, thank you as well.
Captain Chapman. One of the things you said was that you said on that clip. Well, first of all, was that the only time that you testified that day? In other words, that clip, was that to encompass all of your testimony?
It is not. As I recall, I think I was on the stand 6 hours.
During that 6 hours of video watching and testimony, just to clear this up for the jury, at some point did you specifically say, you did specifically say that that was with regards to lock and unlock?
I did.
And to clear up any confusion, that's what your testimony is today, correct?
That is correct.
And when you said I couldn't replicate it, I believe you're talking about the pattern, aren't you?
When I answered that question at that moment, it was in reference to the video that was being shown at that moment, in which, and you heard me discuss it that day, where you had a quick flash of 2 flashes, followed by a separate single flash. That's what I was referring to. I cannot replicate that, which is significant or implies lock or unlock if the vehicle is running.
In other words, you can't replicate that pattern on the panic button.
Boom.
No, I cannot.
So let me ask you something else. The video that Mr. Phillips just introduced, were you present when that video was created?
I was.
And was that video then turned over to my office?
Immediately.
And then did I, to your knowledge, turn that video over to Mr. Phillips?
Immediately.
Your Honor, court's indulgence, please, for just a second. Captain Chapman, I'm going to ask you to review this section of the video.
Now they're being thorough, and they should have been more thorough initially. I think it would have helped also to have an expert. Currently, we cannot see the video. They're not offering that feed for us. I agree on the culpability. I think he was as much part of this as Rita.
So the different flashes, are those the flashes, the later ones that you're referring to?
That was the whole series, the series that Mr. Phillips showed, and then the series that was previously shown to me on Wednesday, I think it was.
So just to be clear, it's your testimony that that when you press the lock and unlock button.
Your Honor, objection, the lead's getting a little out of hand.
Well, Judge, I'm on cross-examination. I'm allowed to lead.
With your honor. I'll withdraw the objection. I think he is on cross-examination. And I'm allowed to lead.
Your testimony is that when you press the lock or unlock button, it will not light those, for lack of a better word, park lights if your car is running.
If the vehicle is running or if the accessory switch is turned on.
And your testimony is based on all the things that you just saw, that during that series of flashes that you could not replicate that pattern, that initial pattern of the same flashes when you press the panic button.
That is correct. That the last ones we saw there, no matter how many times we try it, we can't replicate that pattern. We can replicate the pattern shown by Mr. Phillips, or the beginning of that series, where you see 3, and then it stops, and you see 3. That's the standard flash pattern for pushing the panic button. But the second and third volleys there, or excuse me, third and fourth volleys, you see where you have the quick flash and a pause and a flash. That is signifies unlock and lock.
And is that what you're talking about when you testified? And I think Mr. Phillips played this clip when you said you couldn't replicate it. Are you talking about replicating that pattern with lock or unlock, or replicate that pattern with the panic button?
That's correct.
I don't have any further questions.
Judy, the defense actually did object when he first testified to this.
Thank you, Your Honor.
And the
The
judge
other night I
overruled it
asked you
because it's
about
not expert
there's
level.
no report in this case and notes, and you said you had notes. They never gave me any notes. They said the video was the notes. You're testifying to all this now about all this other stuff, but there's no documentation that's been provided to us to substantiate anything you've said.
Are you asking me a question again?
Did you give them the notes?
I gave them the video. You asked me specifically on the stand, but you ran through, did you do a report? Did you write notes? Did you do it? And I said yes. And as a matter of fact, we did that 3 times because I had to say, am I going to have to keep answering the same question? Yes. And then we got very specific, and we said we videotaped it. And you told me that you didn't have it. And that's not on me. The video, as we just explained, was filmed. I was present. It was turned over to the solicitor. And as far as I know, they immediately turned it over to you. That is my documentation.
Well, that's not the way it worked. What I said, notes, not a video. Y'all did that last Friday on August 18th.
We did it on. That was the final time that it was done. That was the time that we did the notes.
Okay.
You didn't ask me written notes. You didn't. I mean, do I need
notes?
Okay.
Did you do handwritten notes?
I didn't do a handwritten note on the 18th. I did not.
You do a report?
The video is the report.
No further questions.
Thank you.
Anything further?
Briefly.
Oh, just first. Right.
No, I apologize.
All right. Go right ahead.
Thank you, Judge.
Pam
when y'all
James,
got
thank
to
you
the
very
scene,
much.
was
6
the air
months.
conditioner on the car running? Was the car on?
The car was on. The air conditioner was running, and the air conditioner was cold.
Because there was testimony earlier that I believe that one of the defendants in this case, specifically Mr. King, had reached in and turned the car off. When y'all got there, was the car running or off?
The vehicle was running. The air conditioner was cut on. The ambient temperature inside the car was not cold, but the air conditioner was blowing cold air.
All right, let me back up for a second. So the car's running, the
Yes.
air's blowing cold, but the car's hot.
That's correct.
Like maybe it was just turned on.
Speculation. That's just
Withdrawn,
That's
Judge.
ridiculous.
That's ridiculous.
The jury is to disregard the question and disregard the comment. You may step down.
Thank you, Your Honor.
Wow, that was great. Pam James, 6 months. Yellow Courthouse by your name. Thank you so much. Good to have you here.
Next witness.
Is this her?
Elizabeth Clyde.
No, another witness. So the AC was just turned on. How can the jury disregard that? That information is basically, wow. As much as they tried to distance his relationship to the baby girl, he called his daughter on the 911 call. Man. That was such a petty little attack as well from the defense. Trying to say because he said end of story, then, and obviously you lied because you're able to make the lights flash using the panic button. Yeah. It just rehashed in the jury's mind the evidence over and over, showing that that they were not locking and unlocking the car, that they were acting. Officer, he did better and better every time he testified. Captain Jason Walter Chapman, great. I think he's our witness of the day, witness of the week.
Step right up, ma'am.
Tag, 8 months, still jamming with my peeps. Laura, also 5 months. Lovely to be with you all. Thank you so much, both of you.
Hello, my name is Elizabeth Clyde, Clyde.
Good morning, Ms. Clyde.
Good morning.
If you could, tell the jury a little bit about yourself.
Yes, my name is Elizabeth. I am a high school teacher in the Berkeley County School District, so just about 50 minutes away from Walterboro. I grew up here. I am happily married to my husband, and together we are pastors at Faith Church. We don't have kids yet, but we have a really sweet doggie.
That you don't leave in the car.
Yeah, I'm the daughter of Rita Pingalingen.
I was going to say,
Ah.
what's the relationship with Rita?
It's my mom.
And you're how old?
I'm 31.
Now, tell us a little bit about your mother.
Yeah, so born and raised Walterboro. She raised me and my younger sister, so I was in the house for a very long time when we brought Christina home from the hospital. She was the miracle that we've been praying for. It was very hard for my mom to get pregnant again after me. That was a little complicated. And so I stayed home, went to a local college, and even after I got married, I kept really strong relationships with my mom, coming home on the weekends, all the holidays. We would drive back and forth and see each other so I can hang out with her and Christina.
And so you were around for Christina's whole life?
Yes, I was the one that she looked like. She was my special person, 5 days birthday difference, so we shared every birthday together.
And what's the age difference?
Only 13, 14 years.
And so would you consider yourself part of a caregiver for her as an older sister?
Yes, Mom and I, we had the plan in place when she got too old to care for Christina, we already had a plan in motion for when I would take over.
And again, could you describe your mother's relationship with Christina?
Loving. Christina never heard the word no. Every single month, every single time we went out to eat, we lied and said it was her birthday because she loved being the center of attention and she loved music. So we always lied to get that happy birthday song sung to her. And then people at Shoney's, they kind of knew us, so they knew our facade, but they were always happy to play along with us.
And how would you describe your mother's parenting style?
She was the fun parent. She was the one that I always went to with all of my problems. She cared for us so much. Dad worked all the time, and with her being a school teacher, her schedule aligned with us. So not only did we get to do all of the sporting events and any activities, she was at every single one of them, and she made sure we got to do anything we wanted, or anything we wanted to try. She always encouraged us for any sports, even if I didn't stick to it. She always let me restart and try out new things.
What kind of special accommodations had your mother made for Christina?
Yeah, oh my gosh, so many. We always joked that Christina took my title as the bougie one in the family, because when we did her bathroom remodel, not only was it all pink indoor related, but because she loved the pool and hot tubs and bubbled, we had to splurge. Even though I told Mom it was way too much, she splurged for the jetted tub. And we had to get the bathroom widened so her wheelchair can fit into it, because since she was getting so big and so heavy to pick up, we had to have that special tub so she could just slide in from the wheelchair into the tub. And we got hardwood floors all throughout the house so she can use her walker. There was a wheelchair accessible ramp we had installed, and right before school started, she was just fitted for a brand new wheelchair for the beginning of the school year. So
how
all the
soon
accommodation.
When this tragedy happened, how soon was she fitted for that wheelchair?
We were supposed to pick it up in a week or two right before school started, so it was done just a month or so prior, the custom fitting, and Mom was currently saving up for a brand new wheelchair accessible van, because her last one, the transmission just went out.
How would you describe your mom's character? Who she is as a person?
Was she a good person?
No, how would you describe her character?
She was my role model. One of the reasons why I'm a teacher was because I saw her impacting lives of so many students. She loved us so much, even when she dropped off me or my little sister at camp. Even if it was just for 5 days, she cried every single time. And she would write letters before we even left for camp, so that way the next day we had something mail time to look forward to. Even after I have got married, she would send care packages, and coming back and forth to the house, she always made sure I had everything I needed. She would always I raided her closet and her pantry many times. And she just always made sure we had the best possible. She loved me, but she still loves me so much, and she's just so kind and caring and loving. Yeah.
I know it's difficult. After you moved out, how often did you visit?
Very often, since it was only a 45-minute drive. So I would come home on the weekends, and then I would come home for church with her and attend Nova for Mother's Day, or if we had a special event at church, she would come with me. So we attended church together, even living separately quite often. And of course, I always got a free meal when I came home, so I came home often.
Your Honor, may I approach?
Yes, sir.
I'm handing defense exhibit number 5. Elizabeth, what are you looking at?
That's my mom, my sister, and me. The Boo Bear is what her nickname was.
how would you describe what was going on in that picture?
Well, it was so hard to get her to smile for a picture because she was not photogenic at all. And so I'm sure it's my husband probably behind the camera doing a stupid dance or trying to get her to smile just for that picture to be taken. But, I mean, Mom's holding her so tight. She was Mom's whole world.
Now, at this time, we would move Defense Exhibit 5 into the scene. Well, I provided everything to Sean. Sean had it. Sean said he had it. Could I just see the picture, please? Thank you.
Wow.
I don't have any objection, Your Honor.
Do you have additional photos that you are going to post? If you let them review all of them now.
I provided a flashlight.
I understand. Would you let them see all of them now?
Yes, Your Honor. And I did that this morning.
Would you let them see all of them now?
Man.
Thank you.
It's like I gave him a flash
I
drive.
don't have any objection, Your Honor.
Each of the photographs are admitted without objection if you have them marked.
Judge is frustrated because this guy is disobeying him over and over.
Madam Court, got it. Thank you.
Tell me the exhibit numbers.
Yes, Your Honor. We have 3 through 12.
Very well. May proceed.
Thank you, Your Honor. Actually, if you could, we'll just kind of go through the pictures.
So this picture was at Christina's Special Olympics. Mom and her actually won the wheelchair race because Mom literally fell down while pushing Christina over the finish line, so they would win. And it was just, I mean, they matched, full of happiness. Christina and I, we also had like matching clothes as well, even though we were 14 years apart. It was just fun to be sisters together. And then this was after church one Mother's Day. They came to my church that Mother's Day since I married someone on staff, so it was a pastor on staff, so it was hard for me to leave, but that's when she just started coming to our church very consistently. So this was actually taken in my in-laws' backyard, and we just got done with family lunch. We just went over this one. Okay. Oh, this is when we all went to the aquarium together, and her hair was always a hot mess because she didn't get the good Asian genes like I did, but her hair was always so bad. But this is us at the aquarium. We always try to do anything and everything with Christina, whether it was maintaining to the pool or going to the aquarium or going out to eat. This is their first place ribbon for that wheelchair race I just described. And this Whirling Water had door at Wanamaker, and so if door we could put a Dora store to shame with as much Dora. Her room was decorated in, book bag was Dora. Often went to Disney and Nickelodeon, and we loved going to Disney with her because her being special needs, she was treated like a princess, and I took full advantage of all the line cuttings with her. And this is just a collage probably I made or of her because Mom loved having pictures everywhere, like wall-to-wall pictures of me and Christina, just everywhere. Just it was her treasure because she always says that her kids are the greatest gift from God. And then this was at my wedding because Christina couldn't walk. She was pulled in a wagon with bubbles because she loved bubbles. So instead of throwing flowers at my wedding, she came and throwing bubbles. And it was just really sweet. And I think we're back at the beginning.
Thank you.
Oh, you're okay.
How describe your mom's house? Was it dirty?
No. She was a clean freak.
Did it have food for your sister?
Yes, I stole it often. I stole all her gummies and snacks, and one of the reasons why we got hardwood floors was so Christina could be independent and eat on her own. Like she was able to take bites, very slow bites, and eat and feed herself. So often her favorite was chocolate donuts. So we would just let her have a chocolate donut while watching Dora, and she would make as big of a mess as she could because we would clean it up always.
And they had primarily Pediasure. That was their primary somewhat diet that she had?
Because she could swallow so little, that was a big portion of her like nutrients. But she ate chicken, she ate meat. It had to be like small bites. But for because she had a thing where she would drool all the time, so she always got dehydrated. So Pediasure was her main hydration, not really her main source of like nutrients and food.
So there's generally a stack of them in the house?
Yeah, she would get them in bulk because she's like the crazy coupon lady.
Now, Brittany Honeycutt, she's a former roommate of your mother. Do you know her? Mm-hmm. Could you...
Oh, sorry, yes.
Could you just describe how you know her?
Yeah, so I know she rented a room with Mom just for a small season, and when I would come, I know Mom showed me her bedroom like once or twice before, just because Mom was complaining it wasn't clean. But I didn't really have that much interaction with her. She didn't stay very long.
And why didn't she stay very long?
There was just a lot of fighting. Mom quickly realized that it's very hard to find a good roommate, to pay on time and to be clean.
And so I guess the main issues was that she wasn't paying her rent and she had moved in. I don't want to put words in your mouth. Mm-hmm. Do you know about that?
Yes, sir. And then they trashed the room when they were gone too. Like she had to like fix damaged walls. I can't remember if there was hardwood or carpet in the floors, but I remember we had to like clean the floors heavy after she left.
And she didn't just move in, even though some people came with her, right?
I think she was supposed to move in, but I think she brought a boyfriend along that wasn't a part of the agreement down the road, and then that caused a lot of drama.
And so just to make clear, as far as your mother's house, was it fit for Christina?
Yes. We got the walker for her, even though insurance wouldn't pay for it. They said it was cosmetic, so Mom would work extra tutoring jobs. She would clean houses. She made sure Christina had whatever she needed because the insurance often dubbed something unnecessary or cosmetic. So she made sure Christina had above and beyond what she needed.
Did your mother have a lot of support?
No. After the divorce and my dad left, and the money left too, a lot of people went Team Dad.
And with that, as far as
Team Dad?
I mean, you can describe your relationship with your mother. Has that changed at all?
No, we've been together since I was born, and we'll stay together.
And leading up to this tragedy, was there any red flags that you saw, anything that was out of the ordinary?
No, none at all. Like I said, we were so excited for Christina to start school again. We were her book bag was prepped. She just got her physical done at the doctor's, giving her the clearance to go to school. She had her matching door, her like 15th Dora doll that she has gone through to attach to her wheelchair. But like I said, we were supposed to pick up the new wheelchair right before school started.
Had you ever known your mother to leave Christina in the car?
No.
You've never seen that?
No.
Never heard of it?
No, sir.
All right, this is final opportunity. You can tell them whatever you want them to know about your mother.
My mom, she loved Christina so much, and she's a good mom. She would often say that God created her to be Christina's mom because she was tough and she could handle it. And she loved Christina so much. She loved her so much.
Thank you. No further questions, Ron.
Yes, sir.
I have no questions for this witness.
By the state.
Just a few. Is Is it Reverend? Do I call you Reverend?
Oh, no, sir. Just
Okay.
Elizabeth is fine.
Okay, Elizabeth. Thank you for being here, and I saw the photographs. You have, I guess, been out of the house since you were, what, in high school, I guess?
College, about 20.
Okay. And you've been married for how long now?
About 10 years.
10 years. And you live where exactly?
I lived at Somerville at the time.
In
Yes, sir.
Somerville? Okay.
So just 45 minutes away.
I went through the photographs, and I did not see any pictures in the photographs of Larry King. Did you spend any time with your mom when she was with Larry King?
Yes, sir. We went to church together as well, some.
Did you ever spend any time with your mom when she was doing meth?
No, she didn't even drink alcohol.
So you didn't know she used meth?
By use, what do you mean? Like, with what I know, her character, that was one of the main reasons why she and my dad got divorced, was because of drugs. Okay. And she never used meth or any kind of drugs. I mean, she likes her cigarettes, but she wouldn't even touch alcohol at all.
The house that you talk about, your house, was appropriate for Christina. What about Larry's house?
I've never went to Larry's house.
Okay. So you don't know if Christina has a bed there, what she sleeps on, anything like that?
She said you never went to his house.
Objection's overruled.
So thank you, Your Honor. So you don't know where she slept or anything like that when she was at Larry's house?
I would never ask those questions that didn't come up in conversation.
Okay. All right. And again, so as far as you know, you don't know what goes on in Larry's house when your mom is over there, and you don't know anything about her using meth?
No, sir.
Okay. Thank you, ma'am.
Mr. Phillips.
That's like it's news to her. She must have not heard a single thing about this.
Do you think your mother would do anything to kill Christina?
No.
She loved her?
Yes. She loved her. Christina was her whole world. And she has not been the same. Every single day we've lived with missing Christina.
You wouldn't be up here if you thought she intentionally did something.
No. I stand by my mom.
Thank you.
Anything further?
No, you don't.
Thank you. You may step down.
Thank you.
Ladies and gentlemen, we'll take a break now. Please go to the jury room. Please do not discuss the case.
Okay, so even though both defendants chose to testify in their own defense, Larry's the only one that's gone so far. Rita has not taken the stand, and even now she is capable of, or has the option to choose not to testify at this point. She saw how it went with Larry. She might say, you know what, this won't help me. And they had a couple days to think it over, and they definitely did. I mean, there's no that is what they've talked about. And if they are going to talk about, they even talked about maybe even changing how they're going to testify or what questions they're going to ask.
Your next witness.
Defense restaurant.
No, right?
They rest. She's not testifying. Boom.
Okay, we'll take a few minutes break, and we'll discuss the jury charges. We'll have you rest.
Defense
in
rests.
the presence of the jury. Does the state intend to offer any reply testimony?
No, sir.
All right.
And Your Honor, for the record, I think procedurally, I hate the shell game, but I have to renew all prior motions, the mistrial motion, all the prior pretrial objections, rulings. I have to renew all that at this time.
Yes, sir. Any thing from Defendant King?
Your Honor, likewise, we renew our earlier motions, including our motion for directed verdicts. But that does nothing to
And
Another motion for a directed verdict.
these are jury issues. The motions are denied.
Thank you, Your Honor.
Yes, sir.
Okay. All right, we're gonna put together a poll really quickly, and I have to be careful how I word this. I only have 4 options. Okay, so this is going to be tricky because we've got two defendants. This is the problem. So the possible options are, and we can go over them, Larry guilty and Rita not guilty. Rita guilty and Larry not guilty. Rita and Larry guilty, or Rita and Larry not guilty. But there's a fourth one where it could be a hung jury. So a fifth one where there could be a hung jury, and I can't put all 5 options on here, so I'm going to have to just do the first one. So we're going to do Larry guilty. Let's do not guilty first. That's by tradition. Larry and Rita not guilty. And so you only get one shot at this. So here we go. Larry guilty. Rita not guilty. I also have limited space, so this is tricky. Larry not guilty. Rita guilty. And last one is Larry and Rita guilty. Did I do that right? Okay, let's put the poll up. If I made a mistake, I apologize. Yeah. Just swipe up so you don't change anything. All right, Shirley Matt, just click the subscribe button. Shirley, welcome. Good to have you here. We call that admitting to being an addict, true crime addict. Thank you very much for being here. You're one of us now, can never leave. Does the jury have lesser included options? Yes, they do. There are going to be some lesser includeds, but for this specifically, we're going to consider just whether or not they get convicted, not whether it goes with manslaughter, involuntary, anything else, just whether or not there's a conviction for them. Catherine says, I think I pressed the wrong button. I warned you, Catherine. Just kidding. The two charges are basically it's murder and conspiracy is what they're facing. Let's see, is it like 100 degrees in this house? Just in this room? Man. I'm going to adjust the temperature a little bit. There we go. All right. No rebuttal. Momo Shark, I don't think they didn't call any expert witnesses, so I don't think they would need rebuttal on anything. Everything was handled through redirect examination or cross-examination. Sorry.
Bring the jury.
Karen, but not that Karen, says, this 4-month membership, by the way. There is truly no other place I'd rather be than here with RA and the RA family. Thank you all for creating such a lovely community for all of us. Karen, thank you very much. I appreciate you being here. Yeah, you're a big part of what makes this community wonderful. Shirley says, I feel so welcome. Thank you. Good to have you here. It's wonderful there. Yeah, what do you guys think of the daughter's testimony? This was Elizabeth, was the daughter. I'll remove this right here. What do you think of the daughter's testimony that her mom didn't drink alcohol or use meth? And she almost looked offended that anyone suggests that her mom may have used meth. Christy, no, the defense has rested. Rita did not testify. They're gonna rest formally in front of the jury in just a minute, but we're taking a little bit of break here, and then we're going to go to jury instructions or closing statements, depending on how the judge wants to proceed. I think the evidence, the first of all, defense did an awful job when they called the officer again, recalled him to the stand, and started asking questions about the car fob and the lights flashing, and he was able to even more clearly spell out the situations where those lights would flash like we saw them flash. We saw them lock, and we saw them unlock, and we saw it lock. And they said, we cannot replicate that with the car running. It's impossible to replicate that with the car running. And he tried to confuse it with the panic flashes and everything else. But the part that the officer testified to was we cannot replicate those 2 quick flashes and the 1 long flash with the car running. And they said the car was running at the time. And basically it just proves the car was not running. So it was a bad choice to put them up there. Lulu gifted a membership. Thank you very much, Lulu. That one went to
my first one.
K-Metz.
Love it here.
K-Metz. Debbie, my first one. Love it here. Thank you very much. Your very first super chat. Yep, it shows up on my screen. Celebrate the first super chat from Debbie Wilson. Thank you, Debbie. Appreciate the super chat. Good to have you here. It's a wonderful community, and thanks for being a part of that. The daughter looks seriously shocked. Really? Dale, I think she was. Okay? Because here's what we don't know. Everything testifies that, or points to the fact that this mom was a great teacher because she won like Teacher of the Year and was a great mom based on, the photographs and the stories and the testimony we've heard. I can't judge that other than what we've heard as, face value. How long do you have to be using drugs for it to ruin your life? Do you need to have 10 years of meth use to suddenly, just be so far in a hole that you can leave your daughter in a car to die in the hot summer? How long does it take before that point is reached? Could it be a few months? Possibly. I believe Rita hit it. I think she did. We heard that she liked to take her meth in her coffee, probably to avoid the telltale signs of other ways of getting it in your system. How old are the little RAs yesterday? They're both under 12. Too young for their own YouTube channels. She did not read the toxicology report. I don't think she heard any of the testimony or has even followed the news stories. Because honestly, the look we got on her face was like utter shock that someone would suggest her mom was on meth, even though we literally have the report that shows the blood work that shows meth was in her system. Ellie Veldman, thank you for gifting a membership. That is super kind and generous of you. That one went to Soko Judy. Congratulations, Soko Judy, and thank you, Ellie, for that generous gift. Ivan says, I've seen people completely flip their entire life. Capsuling meth is common for professional people. Adam is not a fan of pumpkin spice. That's all I can gather from this comment, Adam. You're not a fan of pumpkin spice. 'Tis the season, by the way. You're starting to see pumpkin spice everything all around. Although we went to a fast food restaurant yesterday. The kids and I, we got them their treat. Thanks, guys. And they had a Christmas tree set up in the foyer, which my kids are like, why is that there? I'm like, I don't know. We still have Halloween. We have Thanksgiving and then Christmas. They do have YouTube kids. Yes, they do. But I think 13 is the age they need to have reach, according to YouTube standards, to have their own channel. I think it would be much beyond that before we let them loose on YouTube on their own. Let's see. Sandyfield says, I may be wrong, but I think a car sitting in the hot sun running with the AC on would certainly overheat before 6 hours were up. The newer cars can idle for a long time. I realize nobody likes cars idling because of the pollution and everything, but the newer cars are configured, and really a slow idle, yes, it would overheat. But like my wife's car, if it's idling, if you have it running, you can start it, you can have the AC running, just sitting there idle, even with the key out. It will engage the engine and it will rev the engine to generate the power it needs to circulate everything to keep the car from dying. It's smart enough to know that it's too low of an RPM to run like that forever. So it alternates and it will rev the engine automatically by itself to do that. Judy says, I think she should have testified. Here's the deal. Right now, you've got Larry, who's took the stand, who's like, hey, it's not my fault, not my daughter, not me. And it really, I think, backfired on him. Maybe she's thinking, if I can just let to the jury say Larry was a bad guy because he's like, not my fault, I just threw her in the car, and whatever happened after then was, up to somebody else. Maybe if they can throw the book at him, and then last thing the jury hears about her is what a great mom she is. Obviously, closing statements will be different, but maybe she can get a lighter sentence, is what she's hoping. A lot of talk back and forth about pumpkin spice, peppermint, everything else. I'll tell you, I'll I'll start sharing when the season gets a little closer. I'll start sharing some of my favorite flavors of hot chocolate, and there's the specific brands. But it's not the season yet. I mean, it's still hot outside. It's 71 degrees here. It's beautiful. It's beautiful today. Samantha Terry just gifted 10 memberships. Samantha, thank you so much. One of our great mods here. Chances are, if you said hello or participated in any way on the channel with Samantha has at one point or another welcomed you or thanked you or responded to you. Thank you very much, Samantha. And now on top of that, 10 memberships that went to Susan Bond, T.A., Nicole Hernandez, Susan McElroy, My Michelle, Flower 711, Mrs. O, Jessica Wiley, Helen D, and Monica, all recipients of Samantha's generosity this morning. Happy Friday. Thank you very much. I'll stick with my deer chili. Oh, I've had a good deer chili. Venison makes a great chili. Okay. Did the officer say how much gas was in the car? Nobody testified to that, Sherry. They have sort of gotten around it, or at least led up to that, where the testimony we heard from Larry specifically was that the car was running before they put her in it. But we have video that was running from basically all night and everything else, and it would have had to have been running for like 16 hours before they put her in the car, and that doesn't make sense, that the car was just out there running all night long. Cars shut off. If you start them remotely, they will not run forever. They'll turn themselves off. Who said that Samantha was a ray of sunshine? There it is. Detect Vids. Samantha has always been a positive ray of sunshine. She is one of the great people here on the channel. I thought the daughter's testimony was pure smoke, no value. The only substantive issue was meth usage, and she waffled from what or outrage. Inconsistent responses, says Emwa. Lexi, this is the most generous chat. Honestly, this is an amazing group. Rosie says, RA, you got me addicted to the pickles. Please don't offer me the cocoa. Oh, but if you like the pickles, Rosie, you're gonna love the hot cocoa. It is so good. When the season comes around, I will say, I reached out yesterday to a company, and I'm waiting to hear back. But it's the first time I've reached out to a company other than Deer Park Water that I thought might be a good fit for the channel, and it was thanks to Weather Watch that connected me with them or gave me the idea. So it would enable us to grow, because there's like a hurdle that we have to get over to grow to the next step, and a sponsorship that is in line with what we do may be appropriate. So I just wanted to give you a heads up. If something ever comes out, it might be months down the road before, or they might just say nope, not interested. Anyway, was it ever said what was put in the car? No, we didn't get any testimony about that. We saw it on video once, and that was it. It was very quick. When she opened the back door, might have thrown something in, opened the front door, reached in and closed the front door. I don't know what happened then. Loves the mods. They're great on this channel. We have a special emoji just to show the mods how much we love them. It's a wrench with wings and a halo. If you look in the custom emojis. Yes, I caught my daughter eating pickles out of the jar yesterday. Thanks, RA. Spicy maple bourbon cocoa. No. Haven't tried that yet. Although I like the idea of a spicy maple bourbon relish. I would like to try that on a hot dog. I like a sweet relish on a hot dog, and this just might be the next best. This might be the next thing. I might need to make it myself and sell it. Let's see. Shell says, I bought the hot chocolate you recommended, and my 16-year-old used it all. I haven't tried it yet. No. Oh, yes. Thank you, Amber, for that's the logo just for our mods right there. Okay. If you like Swiss Miss Dark, Rudy Patootie, I've got one for you. But you have to wait. It has to be the season. It has to be the season. You can't have it yet. I think Rita took classes from Alex Murdaugh with crying faces. I don't know. I wonder if now that she's out. I would not be surprised if she's sober. First of all, a case like this can really scare you into sobriety. Even though we know she's out, I don't know the terms of her bond. She might be tested regularly or something. I'm not sure. Maybe she's not. She's just out on bond. But I wouldn't be surprised if she's sober, and if she has sobered up, some of her underlying motherly instincts might be resurfacing when they're not masked by drugs. Judy says, it's pretty obvious to me they were arguing and Larry wanted them to leave, so he took Christina to the car. Then they continued to argue and make up. Yeah, the makeup and everything, leaving her in the car. Man. Teresa Farmer says, how do you become a member and what does being a member mean? Teresa, you don't need to be a member, but if you choose to support the channel, it is a financial support of the channel, and it puts your name in green, first of all, on chat, and behind your name, you'll get a courthouse that signifies how long you've been a supporter of the channel. That courthouse changes colors as you progress through membership. It also enables you to use the custom emojis that we have, and it gives you a reserved virtual seat in court by typing !seat, like Kiki did right here, and it lets you move right up to the front. But mostly it just gains you my undying appreciation and thanks. Shout out to JB this morning. Hope you're doing great up there in the northern tundra area of Canada. Oh, look who rolled out of bed. Is Weather Watch here? Look at that. Yep. Just kidding. Weather Watch is my podcast partner. We're on for a podcast tonight, unless I hear something differently. Weather Watch, we're planning for a podcast on this channel, the same YouTube channel at 8 p.m. It's a live podcast where you get to participate just like you do here. Looking forward to that one. Okay, Boo, I wish you would have testified. She had the benefit of going second. She really did, and we talked about this a little bit previously. That she has, she got to judge the response by both the state and the jury even. They got to watch the jury and how they responded to what Larry did. And based on how Larry tried to throw her under the bus, well, man, that makes him look like a really bad guy. And if she got on the stand, I bet she would also look like a bad guy, a woman in this case. So this way she can say, well, you know what? I'm not going to testify. I'll just let the jury know that Larry's a bad guy by not saying anything. I'm not going to accuse him of anything. He's going to be the one that's going to be like, it wasn't me, but it was him. So she's gambling here, but she and her lawyer have made that decision, and they're going to stick to it. Oh, then you will love our green jalapeno relish and sauce. Mm-hmm. I do like a good jalapeno. I want to find the maple bacon pickles not spicy. Samantha, if you use them as a garnish instead of as a main dish, which I'm a big fan of both, just for the record, if you use them as a garnish or on something else, it really loses a lot of the heat. The heat is when you just get like you're eating them out of the jar with a fork. That's when you're going to feel the heat, even though it is have a little bit of a kick to it. It's not going to be, like I regret putting this in my mouth type level. Let's see. The daughter said the parents were divorced because of the drug usage. But whose drug usage, young lady? I think what she insinuated was that the father had a drug problem, and that led to the divorce. But that if it happened really quickly, the testimony was all sort of jumbled into one quick sentence. The drug use. Oh, the judge is coming back, so we've got to talk quick. The dad had the money and left, and some people went with Team Dad. That's what she said. Here we go. We're back.
Okay, requested charges. Yes, sir, from the state.
Your Honor, we had previously handed up, and I can hand you up another copy if you need it, 4 states' requests to charge, one as to malice, a second one as to voluntary intoxication, and if I can take a brief pause on that one, Your Honor, you had asked us to find case law one way or the other. With Your Honor's permission, I'll hand up State v. Todd, which is a Supreme Court case from 1986. In State v. Todd, it's a shooting case where there was evidence introduced that the defendant had consumed alcohol. And it's pretty much the exact same argument that was made in this case, I believe, by Mr. Phillips, and I think it was joined in by Mr. Loy on behalf of Larry King. In that, well, we didn't raise that as a defense, so it's not a proper charge. What State v. Todd says is that the evidence should...
If you don't mind, give me a moment to look at it.
Yes, sir.
So that...
Okay, so the charges they're talking about here, sorry, that was a quick phone call, a business-related one. They wanted to sell my information. I should have, she had my personal information, so I couldn't have taken the call online. But the charges they're talking about are the charges to the jury, what they want to include in the jury instructions. These are not the charges they're pressing against the defendants.
Thank you, Your Honor, and I'm sure as Your Honor saw, it's actually on page 404 on the last page. Appellant also alleges the trial judge erred in charging the jury on the law of voluntary intoxication because intoxication was not a defense. The law to be charged is determined from the evidence presented at trial, and that since there was some evidence showing the appellant had been drinking prior to the shooting, therefore there was no error in charging the jury as to voluntary intoxication. And Your Honor, I would respectfully ask the court to consider this. Otherwise, there'd be no reason for that jury charge because no lawyer is going to get up and argue that as a defense because it isn't a defense in South Carolina. But what we have to do is make sure the jury understands that as a matter of law so that they don't make an incorrect ruling. And the solicitor said something when we were talking about this, I believe yesterday, that kind of struck a chord, which is just like mere presence. None of us have gotten up and said that just because they're merely present, they're guilty of the offense or could be guilty of the offense. But obviously, we're not objecting and have included mere presence in one of our, I think in the hand of one is the hand of all charges, that mere presence cannot be considered by the jury as enough to convict him. So I would respectfully ask the court, based on State v. Todd and the other reasons cited, to respectfully deny the motion by defense counsel that not be charged to the jury.
All right, Mr. Phillips.
Thank you, Your Honor. The charge in this case wasn't actually listed, the specific language. However, the court does say they find no prejudicial error in the trial court's charge to the jury on the law of voluntary intoxication. But they don't say whether there actually was an error, just no prejudicial error, which depends on the facts of the specific case. In this case, I made pretrial arguments under 404B, 403, specifically challenging the admissibility of the intoxication testimony and evidence. And so we have no idea whether the lawyers properly preserved those issues in this case, and we don't even have the language that's charged to provide in this case. And so it just says no prejudicial error, which could be harmless error. It's a 4-page opinion or something like that from 1986 that doesn't provide any other specifics. So based on that, because we don't know that the lawyer made the same arguments, the prejudice can be different as far as their analysis. And so that's the distinguishing factor, in my opinion.
Mr. Lloyd.
Lloyd,
Mr. Lloyd. I'm sorry.
Your Honor, I haven't need to be heard further, but I'll go on with Mr. Phillips.
All right. I find that it's a proper charge given the evidence presented in the trial.
Thank you, Your Honor. Your Honor, we had two others that were States 3, which was the law of conspiracy, and States 4, which is a combination, actually. It is, I think, something the defense had asked for, which is a mere presence charge. Proof of mere presence at the scene of a crime is not sufficient to find someone guilty, and then goes into the law of the hand of one is the hand of all. So that we would renew our request for Your Honor to charge those four. And again, if I need to hand up another copy, Judge, I can. And then I do, at the appropriate time, Your Honor, I have objections to the one that Mr. Phillips sent out last night.
You all really think this brain can... I'm trying to focus on your charge, and now you told me about your objections. Just focus on your charge, your requested charge.
Yes, sir. Those are the four that we would respectfully request the court to charge.
Okay, so they're talking about what they want the jury to hear, specifically as far as the instructions, telling the jury what the rules are about how they're going to deliberate.
Number 3, conspiracy.
Yep.
Says the defense.
As to the conspiracy?
Yes.
I think it's a correct statement of the law, Your Honor. I don't have an objection. Your Honor has a conspiracy charge in conjunction with it. I'm fine, but I think that this is correct, and I don't object to you including this language.
All right. Mr. Phillips.
With the malice charge, specifically looking at it, again, what I presented as far as what I believe to be the proper malice charge, where it says...
We're talking about request to charge conspiracy.
That's fine, Your Honor. No objection.
Okay. So we'll charge number 3 as conspiracy, as requested. Of course, I will not reference any statute number. Request number 4, mere presence.
Your Honor, that was my verbal request. The state has requested it also, and I think that what they have submitted is a correct statement, and I'm asking for charge.
Says the defense. Mr. Phillips.
It doesn't apply to us. That's the unfortunate part about a joint trial is you get chained to another individual in the sense that mere presence is not our issue. So if they want to charge that, that's fine.
No, they do want to charge that. So.
We do, Your Honor, and just so everybody's clear, and I know Your Honor has it in front of you, it's a combination charge. It has mere presence and then rolls right into the hand of one is the hand of all language. But it is clearly set out in the rules.
Okay, they're talking about...
There's no objection to this requested charge by the defense. Is that right? No. Okay. Back to the first requested charge. You both have submitted requested charges concerning malice. You wanted to comment on the state's request first?
Your Honor, as was stated to you earlier when we were talking about this, and not so much in the context of the request for charge, but we had a very lengthy discussion with an objection by Mr. Phillips as to the law under Muzon and implied inferred malice with respect to the indictments themselves. So we would basically rely on that same argument. What we did was take this straight out of both Muzon and State v. Wilds.
Okay, let me pose a different question. Is there an objection to Mr. Phillips's requested charge?
Yes, sir, there is.
But tell me where... I've printed your... I have it, yes, sir. Tell me what language in his requested charge you object to.
Judge, the first few paragraphs, it starts out with malice as hatred, ill will, or hostility towards another person, and then goes on to talk about the intentional doing of a wrongful act without just cause or excuse. The problem that I have is that is the correct, or a part of the correct law of malice, but it's not what we have in this case. That would be, I've been doing this long enough, I guess it's unfortunate to say a typical shooting case, but if you had some sort of shooting case or some other murder like that, that might be appropriate. But when you have a murder that is based on the malignant recklessness, and I think Mr. Phillips under, I want to say it was State versus Wharton, talked about extreme recklessness, that there is a different type or different proof of malice that can exist, which is the reckless disregard for the safety of others. So
I'm going to end the
fear
poll
is,
here.
Judge, in this case, I think what everybody understands the case to be about is the state of mind of Rita Pangalangan and Larry King as they did this, and whether their actions and their behavior constitutes, whether it be malignant recklessness or extreme recklessness under the statute. I believe either would support a murder charge.
While they're arguing this, just briefly, our poll came back. The outcome of the jury would be 83% say Larry and Rita both guilty, 10% say Larry not guilty and Rita guilty, 4% say Larry and Rita are not guilty, and 1% say Larry and Rita not guilty. So we're pretty much all on the same page. A little bit of on the not guilty side.
It's the defense's request. Defense
I'm going to try to explain this when we get a minute, but
I apologize. I'm just trying to
there's not a lot of
reference it
downtime
in relation to why we're asking what we are charging, and the correct law of malice as we think it should be applied in this case would be that ill will or hatred is not required to be directed towards the individual injured, and I think that's clear law under Muzan and his progeny. So to say that malice is hatred, ill will, or hostility towards another person is, based on the evidence in this case, we believe would not be a correct recitation. That would be my first issue with it. And then that is repeated on page 2 of 13, where it says malice defined. It says the same thing. Maliciously means with hatred, ill will, or hostility toward another person. And that is not required, especially if you were going under a theory of malignant or extreme recklessness. That would be the state's issue with that definition of malice, and why we are requesting it, the language under Muzan in our request.
Now tell me again about Muzan.
Yes, sir. So
first tell me the site for Muzan, unless you have the case to give me.
Yes, sir. State versus Muzan is 231 South Carolina 655.
Yes, MOU.
1957.
MOUZON.
I'm sorry.
The spelling of it.
Yes, sir.
MOUZON.
Is this thing on?
1950.
1957, Your Honor.
Oh, goodness.
That's going way back, citing that case. It's an old one.
Ended up when we were having the argument on Mr. Phillips' motion as it related to the indictment, Your Honor.
Yeah, I will ask if you feel convinced that they're not guilty, and we'll be respectful here. If you can respectfully just share what makes you lean that direction, and it doesn't have to be verbose. It could be that you think it was an accident, or you don't think there was any proof of intent. I'm just curious. I'd ask everyone not to jump on someone just for sharing an unpopular opinion. Agenda and Pookie says, I'm trying to understand the conspiracy piece. Conspiracy, you have to understand that you have to really look at the legal definition of conspiracy, and it's different than what we think is like, oh, there's a conspiracy, they're out to get somebody, or they're out to do something. It can be less sinister than that and still be a conspiracy under the law here in South Carolina. There in South Carolina. While the judge is reading this, these charges they're talking back and forth about, they're talking about the headings. Okay, they're like, oh, we're going to talk about conspiracy, or we're going to talk about malice, or we're going to talk about murder. We're going to talk about these different sections that we want us to read. The hand of one is the hand of all. This is like the bold title at the head of a big long instruction. And they're arguing about whether or not to include that big long instruction in the jury instructions that the judge reads to the jury. It's basically telling them, this is how the law works, this is how you should operate, this is how you should weight, what you should do with the evidence, or how the evidence applies. as to the guilt that or the innocence that you should or not guilty that you should find. So they're talking about stuff they know about the definition, but we're only hearing the title, and it seems a little confusing. The judge has the benefit of not having to do his own homework. I mean, he does some of his own homework, but really he gets to rely on the lawyers. And he says, hey, you want this, you want that, tell me what you want me to say. And
As
then
it relates to
if they
that
agree,
particular point,
it's
what's defense Panalanga's response?
That is the proper charge, that malice is not looked at in a vacuum. As it goes through, it explains what malice is, and that it can either be proved, expressed, or implied.
Yeah, that's the second or third paragraph of the requested charge, referring to the very first sentence.
And that's describing what malice is, and then the other part describes how it can be inferred. So they are separate, but you can't have it in a vacuum. They want to have just the inference language, but actually take away the actual definition of malice. The other definition allows the inference of it. And so it's not in a vacuum. And this language is from the old standard book. I mean, and again, with the cases they're citing, it uses the word malignant to try to describe that. And malignant is a hatred, ill will, or hostility. It is an inference that can be done through that second part. And I have no issue with that as long as it's all together in conjunction and not separated.
Going line by line, paragraph by paragraph on the charge. The State v. Muzan, which is quite interesting.
I want to define conspiracy for you.
Location that the case stems from and who it involves from 1957. Citing State v. Hayward, it takes us further back, I imagine, in history. Held in State v. Hayward that malice as an essential ingredient of murder does not necessarily import ill will toward the individual injured. Your first requested charge says malice is hatred, ill will, or hostility toward another person. The state is objecting to that language, those words. What is the defense Panalanga's position regarding those words?
Regarding the initial definition?
Regarding the sentence that I just referred to.
That it's a proper charge, Your Honor.
So what is your response then to the statement in Muzan citing Hayward that says malice does not necessarily import ill will toward the individual injured?
That the 2002 case, State versus Watson, that I provided is the appropriate definition for it. So what you have with the ill will is more of the explaining what express malice is, whereas Watson gives us the language for the inference of malice, that a jury may infer it, that malice and recklessness are not equivalent, that extreme recklessness can lead to an inference of malice. Malice may be referred from an act so reckless as to manifest the depravity of mind and disregard of human life. That, to me, is the appropriate language.
I'm going to turn him down just for a
century,
minute and explain what he's doing. It's from this century.
What the potential inference of malice could be done.
Defense here wants this definition to show that malice is worse than the definition that the state wants them to read. Because under the state's rules, it's easier to find her guilty of committing this crime with malice than under the defense rules. That's what they're arguing back and forth. So the defense says, I want you to include and say malice is the hatred, ill will towards the person, where the state's saying you could have malice without really having any ill will towards the person. So this is what the judge is going back and forth between. He wants them to agree on something because he has to find a common ground. And if he can just get them to agree, that saves him the work. And he'll say, all right, I'll read what you guys say. And that's the benefit of the judge, as we were talking about. He has those attorneys, both, all the counsel that are, arguing there in front of him, that have to find the case law, they have to find the existing stuff and argue and say, this is what we'd like the court to do, and this is the reason why, this is the legal precedent that has been established, and here's the case law.
Any further comment, Mr. Lloyd?
Yes, sir, Your Honor. First of all, I would disagree respectfully when the solicitor's pointing an argument where he says we've all agreed what this case is about, that it's about mental state or whatever phrase he used to phrase it. In Mr. Solicitor's opening statement, he made it real clear that his theory of the case was that there was hatred, ill will, or malice towards his child. He told the jury when they watched the videotape that they would see Mr. King bring this child out of the house and throw her in the back of the car like she was so much baggage. And he told the jury, ladies and gentlemen, that's what she was to them. She was just baggage. And she went on with this argument or with this presentation to say that she needed to be put out of the way. I believe he used the language to be got rid of. Certainly this would lead to an implication of a jury could infer that there was ill will or malice toward this particular child. So I think the argument that somehow we all agree that there's no indication of malice toward this child falls by the wayside, because I don't. And my concern is that the jury would believe there was some sort of malice or ill will toward this child. And if that's the case, then in fact this is the correct statement of law. And even if that is not the case, this is the correct statement of law. I do not have an objection to the language that they've requested in conjunction with the language that is in the typical charge that you provided to me
I think he's going to side with the defense.
prior to the commencement of the proceeding today. But no. If he wants us to come in and say, oh, we agree, nobody's going to say there was any ill will or malice toward this child, I disagree. I've already heard the solicitor state the exact opposite. This is a correct statement of the law, and we're entitled to have it read to the jury.
Laura.
Thank you. And it's not just because it's a correct
conspiracy?
statement, but also because it applies to the facts here. With the allegations, the statements, the accusations that this child was just baggage and was thrown around like so much baggage and then left to die in the back of the car. Certainly a juror could interpret that or infer malice toward the child from that. Thank you, Your Honor.
A combination between two or more persons for the purpose of accomplishing an unlawful object or lawful object by
I'm
unlawful
going to
means.
charge the
That's
standard
conspiracy in South
definition of malice. That includes the statement, malice is hatred, ill will, or hostility towards another person. It's the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstances that the law will infer an evil intent.
The state won on that one. Or sorry, the defense won on that.
So I'm including the defense's request at the first portion of the request. Then proceeds, malice and forethought may be expressed or inferred. Do not mean different kinds of malice, but the manner in which may be shown to exist, direct or inference from facts and circumstances. That entire paragraph accurately states the law. I do not use examples, so that portion about lying in wait, I'm striking. And that covers that part of the requested charge.
Hey, KD214, thank you for gifting a membership. That one went to Carrie
Proceeding
Dietrich.
to this next part of
welcome, Kurt. Kurt's in the house on civil law.
extreme recklessness
Welcome, Kurt.
as
Good to have you here.
inference of malice. What's the state's response to that?
Your Honor, I believe we would renew our motion to charge our language when we're talking about the inference of malice, that malice can be inferred from conduct under Mouzon. I would also point out next to that is that we have under that is also a quote from State v. Wild, which is a 2003 South Carolina case, also earlier handed up to Your Honor, but I can give you the site.
All right. Well, the request by the state, malice can be inferred from conduct that is so reckless and wanton as to indicate a depravity of mind and general disregard for human life. In the context of murder, malice does not require ill will toward the individual injured, but rather it signifies a general malignant recklessness of the lives and safety of others, or a condition of mind shows a heart regardless of social duty and fatally bent on mischief. What does the defense say about that further definition of how malice can be inferred?
Anybody down to the
We
state
would
says they
object to
didn't
that
intend to.
language and cite State versus Watson as we have listed because it cites Mouzon. So our appellate court in 2002 directly cited Mouzon and said malice and recklessness are not equivalent. I think the language listed in Mouzon is dangerous, can be confusing to the jury, certainly prejudicial, impairing.
We'll see you, Kurt.
Ms.
Thanks for
Panel
stopping by.
Lanigan's right to a fair trial.
Have a great day.
It's cleared up through language of this century. Malice and recklessness are not equivalent. Extreme recklessness can lead to an inference of malice. Malice may be inferred from an act so reckless as to manifest depravity of mind and disregard of human life. I think the language is plain and easy to understand for the jury.
I think defense is winning these arguments.
Defendant King.
They have more relevant and recent case law.
I'm going to include the word extremely reckless, which is so extremely reckless, and that covers everything I believe Mr. Phillips has been saying about State v. Watson.
Yes, sir.
All right. Yes, sir.
I'm trying to jump ahead, Judge, but the next section of that is the section for State versus Wild, which is the bottom part of our request.
SF in Texas gifted a membership. Katrina Hetherington, congratulations. Thank you, SF in Texas.
Let's see.
Melody, I think when they talked to Larry, this was the weakest part of his testimony. He couldn't remember.
Bottom
because
portion
of the drugs.
is included in the. Let's see. Malice may be inferred.
Thank you. That's super generous. That's very kind of you. Jen G, yes, this is the same judge that oversaw the Alex Murdaugh
Malice
trial.
may be inferred from conduct showing a total disregard for human life. That's the standard charge.
So we're in the same courtroom with Judge Newman as well. Other than that, none of the same players, other than just, I think we might have some of the same court
all of this is pretty
personnel.
much a standard charge, except for this request to include this extremely reckless as a criteria for inference of malice. All right.
I think we're going to see
else about
epic Judge Newman
So we've covered the state,
after the
we've covered
verdict
murder.
on the sentencing. It's going to be epic.
Now, the next request involves criminal intent. Any objection to that requested charge by Mr. Phillips?
Yes, sir. I do not object to the first paragraph, and the best way I can describe it is a paragraph. The first paragraph that runs through what does criminal intent mean in the law. Criminal intent is a state of mind. That paragraph, Your Honor, I think that's the standard charge, and I have no objection to it. I do object to the next section, which says intent means intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conducts of the defendant. I think the first part of that under criminal intent is the standard charge, and I think that covers it.
Here's what I think. I think defense is fighting this whole case in the jury instructions.
The second part of the language,
If they can win this
I pulled
battle,
that out
it's
of,
a huge
again, the
win
old
for the
standard
defendant.
charge book that used to be provided by court administration. I understand that maybe the second sentence being duplicative, but the first, it came from the original charge book, been charged to many juries in the past. I believe it's appropriate law to say that that's the appropriate explanation.
Didn't cite anything. Yaku gifted a membership. Thank you very much.
I believe the proposal is a direct statement of the law, and I'm asking for.
Let's see.
Larry's lawyer is not litigating this very aggressively. He's pretty much going along with almost everything. Whereas Rita's lawyer is fighting tooth and nail for every single sentence.
Well, the state must prove criminal intent as part of proving any crime intent. So let's see. In order to establish criminal liability, criminal intent is required. criminal intent is always a matter to be determined by the jury from the circumstances surrounding the situation. No way to prove intent to a mathematical certainty, no way to medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from circumstances shown to have existed. This is how you make a determination of whether it exists, may be established by direct and positive evidence. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact taken into consideration.
So would
the acts of the parties and
would
all
Newman
the
be the
facts
King of
and
Hearts? Is that
circumstances of the
since
case.
we all love him?
Criminal
would
intent
he be the King of Hearts?
is a mental state, a conscience, wrongdoing. It is up to you to determine what the defendant or defendants intended to do based on the circumstances shown to have existed.
I think
Criminal intent can
the
arise
Aaron
from
Dean judge
actions
would be one of the
or failure to
jokers
act.
for sure.
It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. That's the standard criminal intent charge.
I'm going to turn it down just a little bit.
State has no objection to that charge.
They're hammering out these
Throw in
details.
the word extreme wherever I use the word
This is the news the other day, and since we're here with Judge Newman, it's appropriate to bring it up right now. Alex Murdaugh did lose his privileges, his phone and his tablet privileges. He had like an iPad, but apparently he was using both of them to read journal entries to somebody who's putting together a documentary about his story, which is probably for revenue. But apparently it was not allowed, and so he's now lost his connection to the outside world through phone and tablet, and he'll have to be a good boy for a while before those can be restored. But that's a big loss for him.
criminal intent must be proven by the state beyond a reasonable doubt.
Oh, I apologize, Your Honor. So we're on the same page there.
Nicole, I don't know if these are public
So
defenders
as
or
far
not.
as the language, intent means intending the result which actually occurs, not accidentally or involuntary?
Yeah, that's included.
Yes, sir. And then the third paragraph, I cited State versus Rowell. In a criminal case, the state cannot rely on civil concepts of negligence and recklessness, that is, statutory violations, to meet its burden of proving the defendant's state of mind. The imported terms of negligence and recklessness, as used in the civil law and in the criminal law, are neither equivalent nor interchangeable.
Connie, yes, it's one set of instructions for both
Talking about
defendants.
civil concepts with the jury.
And this particular defendant or
I think the
attorney,
I think the charges I read is
defense attorney, is like, hey, this is what we have against us because we're shackled to this other defendant, and so the charges that need to be read to the jury for that defendant are also read for ours, which might be bad for us but not needed.
Judge, that's, I don't believe you altered that one any.
That's the state standards.
No objection, Judge, from the state. I think your standard charge covers that. I read through this, and it appears to be the standard charge, but, I mean, that's obviously you're going to charge that in every case, so we don't object to that being charged.
Circumstantial evidence, this is the updated.
State versus Logan, Your Honor.
The two words that changes it, which are those two words? All of the circumstances, is that it?
That's part of it, yes, Your Honor. And I know I have to make sure I pursue this State versus Logan charge, or I got an issue down the road.
Well, you mean beyond you mean is that on regarding circumstantial or? All right.
As far as explaining circumstantial evidence,
All right.
that's right.
Yeah, they changed two words, and I keep forgetting which two words they changed.
Your Honor.
All of the circumstances. All right.
As far as the sentencing goes, I
Mere
believe
suspicion,
there would be a
Phillips's request
pre-sentencing investigation
that the same as what
for
the state requested.
any defendant found guilty
Or, no, mere
unless
presence is what you-
the minimum mandatory was also the maximum. And then there's no options, and that would be sentencing at that time.
I don't remember, to be honest with you, where it is, but it usually mere suspicion, however strong, is not enough to sustain conviction. So I don't have any objection to that language. I think it's in the general charge as well.
All right. Well, I'll include it somewhere.
Yeah, I'm not on, for better or worse, I'm not on Mr. Phillips' mailing list. We're going to have one moment.
I'm not on Mr. Phillips' mailing list. That's a subtle jab saying he's not sending me the stuff he's supposed to send me. But I guess I'm not sure if defense has to send it between each other.
While they're perusing that regarding the verdict forms, any objection by the state or the defense?
No, sir. No objection from the state.
Done, Your Honor.
Yes, Your Honor.
Okay.
Yeah.
I sent the email to you in reviewing the State versus Green case, the 423 SC 263, the one homicide, one punishment rule case, dealing with multiple offenses, including multiple homicide offenses. Although they may be prosecuted in a single trial, you have principles inherent in double jeopardy and due process preclude multiple punishments for the same offense. And as reading that case, it appears, at least my position is, that the jury, if the state's theory is that it's recklessness as far as the murder, and then we have this competing theory.
Extreme recklessness.
Of course. Extreme recklessness, Your Honor. And so with that being said, under murder, as far as an inference of malice, when we're looking at the next charge, the infliction of great bodily injury, that's a willful, intentional act. The reason we run into again, as I said, specifically the theory of criminal liability does not satisfy the elements of both statutes because the state is pursuing a single theory of liability. The jury can infer malice from the defendant's extreme reckless disregard for human life, whereas the infliction of great bodily injury...
Who said stop
Whereas
reading?
the infliction of great bodily injury statute requires a willful, intentional act. And so with this competing set of theories, essentially, or in elements that the jury has to determine when reaching a verdict, that puts in a position where the verdict form should state the jury can either find the defendant guilty of murder, or the jury can find the defendant guilty of infliction of great bodily injury to a child.
So in effect, you're filing a motion to require the state to elect?
Yes, Your Honor. In this case, it walks through that.
My interest in cases probably went back through Casey Anthony, a little bit of Jodi Arias. That was a crazy one. Johnny Depp. That's when I really got into it. But I've loved the law since I was a kid, sitting in traffic court just for the fun of it to watch what happens. Reading law books since I was in junior high. But those cases were really exciting for me. I like those.
All right. Let's see. So I guess you're referring to something you sent me, and when did you do that?
Well, I didn't want to send it at 2:30 since you commented on that the other day. So this was
that was only in relation to telling me you'd be ready for closing at 9:30 rather than being ready to do more argument.
Well,
but we're beyond that now.
11:35.
Okay, that's all right. A proposed jury instruction. You're now telling me that something about the verdict form that you object to, and you've now explained all the law that's the basis for your objection, but what is your specific objection to the verdict form?
Yes, Your Honor. So specifically that the verdict form would instruct the jury that they can either find the guilty defendant or find the defendant guilty of murder or infliction of great bodily injury, but not both. Okay. And that's why we don't have murder and abhand charged at the same time. We're running into that same, because the infliction of great bodily injury somewhat mirrors abhand, and that's why we don't have murder and abhand charged at the same time. But in this case, we have murder and infliction of great bodily injury, and then the single theory of liability that's provided by the state is recklessness. The infliction of great bodily injury is a willful, intentional act. So now we have this competing issue.
I don't have any legal background, Adam. I just do this full time. I've loved the law since I was a kid. I read not just the law as far as judicial, but I read the law on legislature side as well.
Does bring in an interesting
created and voted on. think the jury gets the
point
case
because
today.
I don't know that anyone has submitted a proposed charge on great bodily injury on a child. Have you all submitted a requested charge on that?
That charge meaning charge to the jury, not.
The statute itself, we have referenced the statute to you on that, which is 16.395 subsection A.
No, did we talk about that?
Yes, sir. That was in the indictment. This was the entire conversation I think we had the first day.
My dog Clover. There are some states like Virginia, I believe, where you can take the bar exam without attending law school. But most states do require you to attend it, I believe. So we might have to cross the border.
Requested charge regarding malice, voluntary intoxication, conspiracy, and mere presence.
Yes, sir. We didn't, not a special, I assume Your Honor is going to charge under your general, what the law of the particular statutes, but the statute is referenced in the indictment.
And there's an objection to the court charging this.
Jocko just sent a super sticker with 6.99.
Thank you very much, Jaku. Appreciate that.
That the defendant, the statute is unlawful parent, guardian, etc., person responsible to a child's welfare, to knowingly to allow another person to inflict bodily injury on a child. Gross bodily injury means bodily injury which creates a risk of death.
That's awesome, LB. That is awesome.
Serious of permanent disfigurement or loss of impairment of bodily function.
This is not a stall tactic. This is a very effective defense.
May not be construed to prohibit corporal punishment.
Basically, what the defense is doing here for Rita at the very end of this trial is shaping and sort of restructuring the rules that the jury has to play by. These are the rules. The judge is going to read this set of rules and say, "This is if you find this is what you have to do." And if they can change those rules to make it very difficult for the jury to reach the murder or the guilty verdict in a certain area, that's a huge win. It's a bigger win than anything that happened in the testimony portion of the trial. So this seems to be where they've spent most of their time, because they've objected to almost everything and are adamantly arguing to have things read their way to the jury.
Great bodily injury on a child. So,
and that is subsection B, and we didn't charge that. We charged subsection A. It's unlawful to inflict great bodily injury upon a child. And then that goes, now of course the great bodily injury is defined in subsection C, in which you put there's a substantial risk of death which causes serious or permanent disfigurement. So that's the section that we charged, and in fact in the indictment we actually have direct references to subsection A.
And the defense's objection is that there's a conflict with murder versus great bodily injury as being, you've stated that objection.
That's correct, and I think Your Honor was correct when they said basically what you're doing is asking the state to elect, and I don't believe we're in a position of having to do that. The Green case, which is what they cited, is two homicide statutes. This is not a homicide statute. It is it's unlawful to inflict great bodily injury upon the child, and the substantial injury is then defined as potentially something that would cause a permanent loss of impairment or even death. And in this case, of course, that was the conclusion of this. So what you've got is you've got two separate statutes, just the same as you have the conspiracy. So now you have three separate statutes. You do not have two homicide statutes as you did in Green. And so then the question is, do we have to elect? And the law in South Carolina, and I'll hand you up, State versus Reynolds. I got this motion. I had this motion, unfortunately, this morning, so I'm sorry I didn't get this to you earlier.
Yes, sir.
But in that case, which is a federal district court case, but it talks about South Carolina law and specifically references the issue of election. Page 7 of 12 of that opinion.
Your Honor, do I have a copy?
There you go. Thank you.
Your Honor, do I have a copy?
And the issue,
do
just
you?
to make sure we're clear, we go to the second set of paragraphs over to the right of this, and the court says, and it's about halfway down toward the end, when several offenses charged grow out of the same transaction, then the process.
Let me catch up with you.
I'm sorry, yes, sir.
On the right-hand side,
It's about.
In the middle of a paragraph?
Yes, sir, and it's right before the blue section starts under State versus Lee, because actually those are all the cases that the district court is citing. Yes, sir.
That's all you go ahead.
So when several offenses charged grow out of the same transaction, then the prosecuting officer is not required to elect, and the court instructs the jury to pass upon the several counts separately and write their verdict accordingly, which I believe is proper for you to do. Obviously, you have to explain to the jury that each one of those indictments are separate. The only difference is I think they included them in the same indictment. We have 3 separate indictments. So I think the law in South Carolina is clear. You have distinct offenses in this. If you even analyze it under double jeopardy, which is, I think, basically part of this as well, it doesn't apply either. So I think your Honor charges to the jury, you have to pass upon these indictments separately and make decisions separately upon them.
Anything further on that issue?
No, Your Honor. I've marked the email as well as the green case as a defense exhibit. It's there with the requested charges, and it's also marked as an exhibit. We stand firm on the arguments presented.
I don't know if you need to mark a case as an exhibit. The law is...
A week from today, we have a hearing in the Sarah Boone case on Friday.
Absolutely. It's just marked with my email.
That is going to be a key moment, because we're going to find out if the judge allows Mr. Bankwitz to be off the case, which will definitely affect the timeline.
Malice or intentional killing, and so if you recklessly cause injury, you cannot be guilty of that. Based on the fact that the state's theory is to prove
Lizzie, send me a text to the burner phone, and I'll see if I can text you back when the verdict comes in.
As a result of extreme reckless, I agree with the state. The jury may find the defendant not guilty of murder and guilty of great bodily injury. The jury may find, given the facts presented, that great bodily injury was caused, and then also death was caused. And a criminal conspiracy was engaged in causing all of this. So
Sarah Boone is next week.
I deny the motion, and the argument is respectfully noted.
Thank you, Your Honor. And with that, I would respectfully request that the willful intentional language be attached to the statute of infliction of great bodily injury, because I believe that is a correct statement of law. So the jury is not confused by the arguments in the law as it relates to the inference of malice with recklessness, whereas the infliction of great bodily injury is the willful intentional act. That language be included to make sure the jury understands, because unfortunately the statute is silent on it, and I provided the law as far as State versus Freeland, and then some persuasive authority from our sister state of Georgia, showing that when you have no mens rea listed in the statute, the default is regular intentional criminal intent, willful intentional act. And that language to make sure that the jury's not confused on the law, that what the state's arguing to prove murder is actually not the same state of mind that is required to prove the infliction of great bodily injury to a child.
Exclamation point burner in chat. We'll give you the burner phone number, Lizzie. Sarah Boone, it's a hearing next week. She might not even be there. I think this might be ex parte in front of the judge.
The state would object
but
to
maybe she will be.
The insertion of something being required willful, the insertion of that into the statute. That's not what the statute says. With your Honor's permission, you may have already read it, Judge, but I will hand that up to your Honor. This is 16-3-95, if I may, Judge.
No.
Thank you.
I had them printed just a moment ago. I'm not going to alter the statute. I think criminal intent in general covers whatever mens rea is needed in order for a crime to be committed, and it's adequately included in the jury charge. I'm not going to modify the statute.
Thank you, Your Honor.
And to be clear, does that in any way impair my ability in closing to make that argument?
You can argue whatever you want to,
Thank you, Your Honor.
as I suspect you will.
Jan,
Yes, sir.
during the discourse, Your Honor referenced or read from subsection B of the great bodily injury
Yes, sir.
statute. I don't know if the court's going to treat that as a lesser included. Is the court intending to charge subsection B? That's my question.
Well, I wasn't looking at the indictment at that time. I'm going to charge what he's been indicted. They have been indicted. They've been indicted in subsection A. That's the one I will charge.
Thank you.
It's not. I'm not going to charge subsection B. That's not the charge.
I understand.
All right.
Nancy, eyes opened.
Hey, y'all
Corey
ready?
Richens is going to be in a
Ready?
hearing
Close the
today.
argument.
It's a scheduling hearing.
How many minutes?
10,
All right.
10, 15. Just a short recess, Your Honor. Take a moment.
Okay, so we get another 15-minute break.
We're going to take a break.
Thank you.
We're going to take 10 minutes, and we'll be ready. Is that enough time for the state? Take 10 minutes, and we'll be ready to close in the presence
Down
of
in
the jury,
front.
and then move to closing.
Okay, so they're going to close in the presence of the jury and then move on to closing arguments, or move on to jury instructions on closing arguments. So Corey Richens, this is the case of the mom who is accused of killing her husband with fentanyl overdose and then writing a book about children grieving their lost parent. This is in Utah. It's up in Park City. I think it's the same courtroom that we watched the Gwyneth Paltrow civil case in. It's the same courthouse either way. This one, we're expecting a scheduling hearing today that will maybe lay out some of the time frame as for the case moving forward. I don't think it's going to go anytime soon, but we'll know for sure. I am on the media pool for that. I should be getting copies of the video from KUTV on that as well later, so hopefully that comes through. Let's see. How can the judge order the jury to cut off deliberations and find the verdict before they're ready? I don't think he can. I think the jury has said we can't go later than this, and so he's like, well, I have to give it to the jury, and then if the jury decides to take longer, then that's on the jury. Judge's voice is very soothing. Yes, he's got a very distinct and soft, easy to listen to voice. But man, he can be sharp if he wants to, and I think we're going to hear that from him, especially if we come back with the guilty verdict from the jury. Let's see. Newman did give us little yoga breaks. Yes, we got yoga breaks. But so did... Didn't Schroeder give us yoga breaks as well? 10 minutes, and then we'll bring the jury. Did Rita take the stand? No, Diane. She changed her mind. Realized they stalled. Both defendants said they wanted to take the stand, and they were going to proceed that way. Larry did, got eaten alive. And I think Rita's like, oh, that's what it looks like. I don't want any part of that. And so instead they called some character witnesses, including her daughter, to testify about just what an amazing mom she was and how much she loved Christina. Or is it Christine or Christina? I'm having a mind blank right now. And how she didn't even know that she had done meth. So, yeah, so that's the way they left it. They'll both be convicted, says Last Poet. Rita did the right move. I think it was better. It's rarely good to take the stand in your own defense. A couple times this works, but generally no. He let loose on Murdaugh. I think he's going to let loose on this as well, and for the same reason. We've got a parent unaliving their child. If she's found guilty of that, I think she's going to. First of all, he's going to rip into Larry for the whole "not my problem" defense. That if guilty comes back, he's going to just tear him a new one over that, and then he's also going to rip into Rita as well. Judge Darrow gave us comfort break. She was wonderful. Yes. Judge Darrow's docket, I was checking that, is entirely divorce court. I'm not sure if she shifted to a new rotation, but all she's doing is family law right now. Let's see. Nathaniel Rowlands, he ripped into him and his mom at sentencing. Yeah, he can be extremely sharp. He will give you a good dressing down. Judge Newman sadly lost a child around the Murdaugh trial. Just before the Murdaugh trial happened, he lost his son. And you have to know that's got to be in his mind a little bit. Reverend Beasy, thank you for exercising vicariously for me. I'm feeling the benefits. I appreciate the miles you put in on my behalf. Thank you. And that's some great runs too. Used to run cross country way back in the day. I still do love running. It just doesn't feel as good as it did back then. Am I retired? I wish. No, I'm not. I'm a full-time employed content creator on YouTube. This is what I do. And this is pretty much all I do. There will be another verdict on the Not Relevant podcast tonight. 2 weeks in a row with a verdict interrupting the podcast. Possibly. It could. The judge probably will let them go a little bit later. Let's see. Ooh. Holy cow, we do have a lot of people here today. Wonderful. That's really cool. I don't know how his son died. But I believe it was sudden. Let's see. Judge Dora was the judge on Daryl Brooks. Yes, he was, Melody. That's correct. She's great. And now she's like nothing. I went as far out as her docket has basically got cases on it, and there's no criminal cases on it. So I know that she was on a rotation of sorts, but she was also sort of like the top judge in that group. And so you think she would be able to choose where she goes a little bit. Thank you, Samantha Terry. Let me check the mod chat really quickly. I always forget to keep an eye on that. It's a tip on a case. We're going to have to do some research on it before I send you all down the various different rabbit holes. Samantha, thank you very much. I'll do some digging on this and see what we can find. Kiki, welcome. Hello. The son was in his 40s, a cardiac issue. I know it was sudden. Judge's daughter is also a circuit court judge. Newman's daughter is? How did I not know that? Jimmy, I'm doing great. Thanks for asking. Appreciate you being here. Thought Judge Newman was retiring soon. I think he's close to retirement age, but I don't think he's scheduled a date yet. Isn't he still handling all the financial crimes trials for Murdaugh? Isn't he still going to be over those? Oh my goodness, a drunk driver. Can you imagine sitting in front of Newman for a DUI charge? If he lost his son to a drunk driver, that would be. If you knew that was the case, you just plead guilty. Just plead guilty. Let's see. Yes, Brandy's covering the sex therapist trial as well. I don't think we're going to be covering that one. Did an interview with his daughter after the Murdaugh trial. Newman will retire after the... Maddie. Maddie left us hanging. I think you bumped the enter key. That you're thinking of a different judge? Son had a cardiac event, not a drunk driver. Okay, so that's better. I mean, it's not better. It's still a sudden death, unexpected. But I would say that would be better for anyone who has a DUI charge in front of the judge. Yeah, that seems more familiar now. He's in a forced age retirement. I think he turns 72 in November. Is it a full stop retirement, or is he allowed to do like sort of like the civil stuff after this, or is it just he's done at 72? He ages out of the system. The poor judge in Brandy's trial is about to tear what's left of his hair out. Oh no, it's so bad. One thing Judge Newman has incredible ability to articulate very insightful viewpoints.
Didim said those divorce cases in family court can be pretty criminal. She was married 3 times, so she knows. Don't tell her I'm spreading her business.
we would never tell her. Bite me that you're doing that, Princess Buttercup. Thank you very much. Buttercup belongs to Bite Me, but Bite Me thinks that's the case. But Buttercup thinks it's the other way around. She's taking care of Bite Me. Anyway, this interview, it's a forced age retirement. So the judges, the one thing I'm worried about Judge Newman, he's very articulate. He's smart. He's really good at speaking, and he can really, light into you if he wants to. He's got an edge to him if you trigger him a little bit. But what I don't like is he gets pushed around by attorneys. And even we saw it today, where the defense attorney for Rita is doing the whole, I'm not asking a question, I'm just talking. I'm going, here's my soliloquy that I'm going to offer in court to try to get the testimony in that we couldn't get during the testimony phase. And he's like, you've got to ask a question. And he's like, okay, I will, Judge. And he goes on again. And even the witness is like, is there a question in there for me? And like 3 times, and the judge just lets it go. He ends up getting pushed a little bit. And lets it slide a little too much, I think. I wish he would sort of jump on them a little sooner and say, look, do what Judge Doro did to DV. Say, look, if you can't follow the rules, I'm going to terminate your portion of this cross-examination or direct examination in this case. Less conflict of interesty. Yeah. Ashley, yes, I did hear about the 8 passengers YouTuber getting arrested. It sounds like that was appropriate. It seems weird because there's many family members that are fairly prominent on social media in that case, and it seems like they all knew, and they're like, oh, we've been trying to get help for all this time, and finally they're doing something about it. I don't know. All right, Judge Newman said after the Murdaugh trial that he was retiring after the 99 cases he had left for Murdaugh. If he hits 72, like mid-case, can he be like, let me just finish out my docket, don't assign me any more, and I'm going to just keep going? Because those 99 cases might take him through a little while. Let's see. I'd rather a chill judge than one that gets too emotional. Yeah, Judge Newman is much more chill than say, Schroeder. Schroeder he can almost like, but not split personality, but he can flip in an instant from kind to just like, rawr, it's like one of those cats that you're petting and it's purring, and the next thing you know, it's like 3 fingers, gone into its mouth. It's just like, rawr. It just turns on you in an instant, and you're like, where did that come from? Schroeder has that element to him, and it gets a little. Makes you a little jumpy, a little bit, but anyway, can't stand Schroeder, says Dreamscape. We like some things about him and don't like, and honestly, I even like some of the things that I also don't like. How's that for a conundrum? Schroeder has the, and Schroeder was the Rittenhouse judge. He was also the why can't I remember? What? Say it again. Zach Anderson, says Mrs. R.A. Zach Anderson, judge. Everyone else. I will say, I see your comments. My wife told me first. She remembers. Zachariah Anderson. Anyway, he was the judge for both those cases. He gets very verbose and he thinks out loud. And so you get this, and yeah, you get squirrel as well. But every thought that goes through his head, it like goes through his head, through his mouth, and then he and then he continues. And so I love that because it lets you see inside the judge's brain, saying like, well, this is my rationale for doing this. What I don't love about that is these arguments. A lot of them happen, and because some of it is because of his courtroom setup, but they happen in front of the jury. Where instead of when any other judge would have said, jury out, we've got some things to talk about outside your presence. Judge Schroeder is just like openly, they're arguing back and forth and the jury's sitting here. I'm like, what's going on? And he'll even turn to the jury and explain something about what he's thinking about as he's making a ruling. And so I didn't like that part about it because I thought that...
Is that correct?
There are some things the jury shouldn't see in a trial. It's like the making of the sausage. They don't need to know how the sausage is made in the courtroom, right? They just need to be able to test the sausage and see if it's good or bad. And so Schroeder was I didn't like that, and I did like it. I do like that he's verbose a little bit. We really get to hear what he's thinking, but sometimes it got, you'd be like, hey, wrap it up. We're land the plane a little bit. Here we go. I think jury's back already. Judge Werner is amazing. Love Judge Werner.
I'm not a cat.
I don't know. Does he have a Harley? I'm not sure. Ernest.
Scratch all that. Oh, that was terrible. I apologize.
Thank you very much, Ernest. Appreciate you being here. 7 months. Look at that yellow courthouse by your name. Appreciate your support. It's wonderful. Not just gallery, jury member as well. Wonderful. You've got the padded seats. Judge Schroeder doesn't like the sidebars because the jury has to climb a flight of stairs to get to the jury room. And oftentimes you'd have jurors that mobility was an issue, and it was in the Zachariah Anderson case. And so he didn't want to excuse them because it would be a hardship on them every time they leave the courtroom. But I think they really need a new courthouse if that's the case. Melody, welcome. We were about to have the defense rest in front of the jury.
Hey, you may bring the jury.
There we go. Jury's on its way in. Matthew Terry, Trevor Summers judge, also the Chandler Halderson judge. Matthew Terry, is that the Florida judge with like the Tesla or whatever? The little model car. Was he the Ice Cream Man judge as well? There's my soundbite. This morning's was the best, I think. I've never heard him say bring the jury with quite the oomph and gusto as we got this morning. So I think I'm going to go back and get that one. Thanks for all those who like the channel. We are so close to 500. I appreciate that. It actually does help the channel. It's free. It doesn't cost you anything. Today only. Likes are free. And it helps other people find us, which is fun because we have some friends out there that don't know they need to meet us. Kiki, yay for 2 months. New courthouse color. Thank you so much for your support.
Because he's the guy. Don't miss the forest for the trees.
I'm going to have to turn down all these sound bites here in just a second once the jury gets back. The sex therapist just had to walk down for a sidebar. He asked the lawyers to get him a Stairmaster. Oh, man. Thank you, Samantha Stevens. Wonderful that you're here with us.
Bring the jury.
Trisha Fishburne just gifted 5 memberships. Laura Olson, Keeper Texas, Utah M, Melody Breckenridge, and Teresa Farmer all gifted memberships. Thanks to Trisha, your fantastic gift there. I appreciate that. Okay, here we go.
How does he do that?
Okay, I'm really turning the sound effects down, so they'll be much quieter now. I am captivating. So happy to found you in this community. Thank you so much. This community is fantastic. The best place on the internet to watch true crime, all because of you guys. Thank you so much. I think it's Rita. Rita and Laura. The F's throw me off, but I think it's Rita and Laura. Thank you so much for clicking the subscribe button. Welcome to the community. Good to have you here. I will say as the weather is starting to turn colder, I've seen some yellow leaves on the trees up near the mountains. You might want to think about some of our new gear that we have. We have our Recovery Addict hoodies available that have the courthouse colors across the back. In the front it says seat. It's the membership command that shows that you belong, and you get the reserved seating. On the back it says Recovery Addict. It has the membership colors of the courthouse. I think you guys will love it. Do check it out. You can do that by typing !uniform in chat. Samantha Terry just gifted another 5 memberships. Sandy Spivey, Rhodey, Jane Tucker 68, Nancy Eyes Opened, and Shell. Congratulations. Thank you, Samantha.
You may call your next witness. All right, ladies and gentlemen, you've heard the defense's case. Any reply by the state?
No, sir.
No rebuttal.
Ladies and gentlemen, you've now heard all of the testimony. You've now received all of the evidence. It's now time for closing arguments. If you will give counsel your attention, first by the state.
Ricky, thank you very much for the super chat.
Yes, sir.
We're going to listen to this really quickly. Samantha, welcome to the gallery as well. Thank you so much.
I'm going to talk to you very briefly today about what we know. What evidence we've heard, what testimony you've heard, what you've seen, from everything on the video, to the chemical analysis, to the experts, to everything. What I want to talk about right now is just what we know. There's the question. We start with Christina. Christina was a child born with cerebral palsy. She could not walk. She couldn't grasp. She couldn't talk. She could show emotion, because you've seen, versus this photograph, you can see the child can show emotions, and that's going to be relevant in a few minutes to what I'm talking about. But Christina was not like other girls. She was totally dependent, 100%, on other people. She was dependent on everybody, for somebody to take care of her. Somebody to give her food, somebody to give her water, somebody to keep her safe. Christina was totally dependent on Rita to do all of those things. Every day. Every day. Not just on Rita's good days. Not just on days when Rita is posing for photographs. Not just when Rita is sober. But even on the days when Rita chooses to go hang out with Larry and get high on meth, Christina was dependent upon her then too. Wholly dependent on her. Even when Rita was high. And you heard testimony from defense witnesses, and they came in and they told you what they did. One had not really had much contact with her for 18 years, except through Facebook. Her daughter came in and said what a daughter should say. She's a good mother. But neither one of them knew about the meth. Neither one of them. And we know on that day, where none of those witnesses were, they didn't know what was going on. On that day, on that weekend, on that Friday, that Saturday, the Sunday, and the Monday, we know that they were on a meth bender. We know it because we took their blood. You know it because you had chemists, 1, 2, 3 chemists come in and tell you that. Methamphetamine in both Rita's blood as well as Larry, and all well over the limit that would make them high. And if you didn't, for whatever reason, think that was enough, Larry told you the same thing. He didn't want to, but he did. He hadn't slept in 3 days. He and Rita had been doing meth. She liked to put it in her coffee. He didn't want to tell us, but he did. And we know that. And that little girl was dependent upon Rita to take care of her, to keep her safe. Rita was high. And neither her daughter knew about that, nor the other lady that testified. But we know that. Without any shadow of a doubt. What else do we know? We know that Larry had first of all, we know that in the middle of that bender, Rita and Larry get in Larry's truck and go get the child and bring her into that environment where they're getting high. And they go in and they stay the night. And we now know that Larry had a security system, a very good one, a very sensitive one, one that would pick up any type of motion going in and around the car. And we know, because there's direct testimony, that there was no motion around that car at all until 11:15. And 11:15, the motion we saw with these two going to the car. So what do we know? The car's not on. There's no air conditioning. Nobody's been near that car. Unless the angle was that they parked the night before and left the car running with the air conditioner on. But nobody said that. Larry said, oh, the car was running when we put the child in. Because Larry needed to say the car was running when we put the child in. Not because it was true. And you know, because you could see it. The car went on. There was no air conditioner on. And they left the child in that car for 1 hour and 15 minutes before there was any more motion, before there was any more interaction with that car. We know because of, flip these back around. We know that as of about 11 o'clock is when, about 12 o'clock is when the heat starts spiking inside the car. We know that because we actually brought an expert, Dr. Grunstein, to come testify to you about what happens inside the car when it's that hot outside in August in South Carolina. And this spike starts right after 12 o'clock. Until then, it's about the same as the car. So you're talking about 90 degrees to begin with. And by the time they go back to that car at 12:15, Larry doesn't go back to the car, but Rita does. We're already over here. The heat inside that car is now approaching 100 degrees. And now I want to go back to this. And first of all, let me just stop this here. If all they had done was put that child in a hot car in the middle of August and left that child there for an hour and 15 minutes, in some way, miraculously, somebody had come along and gotten that child out, I submit to you they still would have inflicted serious bodily injury on that child, because the definition of serious bodily injury is the likelihood that it could cause serious impairment or death. And I don't think there's any question at all what the end of this result was. If we stop there, you have that. And did they do it together? Absolutely. Even Larry testified to that. We did everything together. Put them in the car together, and you see that? We left them in the car together. And there's your conspiracy. That's not all we have. Unfortunately, it didn't stop there. Unfortunately, the child was not rescued from the people that she depended on or anybody else. So now we're at 12:15.
I'm sorry, Alabama.
Child's been at 12:30, excuse me. Child's been now in the car for an hour and 15 minutes. No air, no wind, Rita goes back to the car. She opens both doors. She opened both doors, the air conditioning's on. She's opening both doors, maybe let a little wind out of there, which is the only considerate thing she did in this entire event. Do you know what else she did? She looked inside the car. And now I want you to think about something. Go back to Christine's picture. This child can show emotion. She can't scream and she can't talk, but she can show emotion. You can see it in her face. So what did she look like when her mother was looking at her after being left in a hot car by herself with no wind in 100-degree heat for an hour and 15 minutes? Rita see when she looks at the car. Child's got to be going, oh, that's not a happy face in that car. After an hour and 15 minutes of this heat in that car by herself, a child who's totally dependent on others, she's begging for help. So what does Rita do? She closes the door. She goes back inside with Larry. The first time, she and Larry put the child in the car. And they go inside, as Larry says, to make up, to have sex. So while they're inside having sex, the child is out in the car. She comes back out, looks at the child. The child at this point had to be begging. She closes the door and goes back inside to spend some more time with Larry. Which, by the way, would be the last time anyone approaches that car to look after that girl until 3 o'clock in the afternoon. They go back on the porch. They go back on the porch about an hour and a half later. They don't actually walk out into the car and go see the car. It's been another hour and 15 minutes. They go back out on the porch. They hang out on the porch. And now it's 2 o'clock, 2:02 to be exact. Neither one of them approached the car. The girl is still in there. And what's going on inside the car now? Now it's 2 o'clock, 11, 12, 1, 2. Take a look at the temperature inside that car now. It's now reached that maximum temperature. It's getting closer to that maximum temperature. It's well over 110, 115 degrees inside that car. And they come back out. And do they go check on it? No. What do they do? They hug. They kiss. And then they go back inside for another hour and 15 minutes. The child is literally cooking to death in the car. And they're going back inside again. And they stay in there for an hour and 15 minutes. And then they come back out. This time, Rita actually walks to the car. This is when she finds that the keys are locked in the car. But pay very close attention to this. Where does Rita walk when she walks out of the house? It's now 3 o'clock. The child has been in the car since 11:15. The heat is now at well over 118 degrees. Inside the car, it feels like 135 degrees. You've heard testimony from experts giving you that testimony. And where does Rita go? Does she go to the side that the child's on to check on her? Is she trying to get in the car to drive? No. What's she doing? She's going to get her cigarettes. In the back seat of the car, where they put this child at 11:15, there was a bag in the back seat. Right beside the child. And inside that bag was this. A gun.
Renewed objection.
And not only
401, 403.
May proceed.
And not only was it a gun, it was a loaded gun.
It's overruled.
Again, in a bag, right beside this child. And right there, also, are the cigarettes. She walks back out to the car at 3 o'clock. She's still not going to check on the child. She's not even going to drive away. She's going to get some cigarettes. And she finds that the car is locked. So what do? The car is locked. The child has been in the car since 11:15. It is now 3 o'clock in the afternoon. It is well over 118 degrees inside that car. It feels like 135. They have found that the keys are locked in the car. So what do? Naturally, they break the window. No, they don't. Rita says it's too expensive, so break the window.
Objection, Your Honor. It's not vaccinated.
Let's go. Ruling, Your Honor, it was sustained.
Objection is overruled.
Thank you, Your Honor. Break the window? Now. What do? They hang out. They get on the swing and start swinging back and forth. It's now 3:19. 19 minutes after they found that the child was locked in the car with the keys. 19 minutes after we know for a fact it's already 118 degrees inside the car. And what are they doing? They're swinging. Is there any sense of urgency here? Is at any point in time they're going to say, hey, we need to take care of this child? No, we're swinging. And then what do? They eventually go to Larry's truck, which is parked out back. And now what do? It is now 39 minutes later. It is 3:39. They're still at the house. And they're kissing. Not taking care of the child. They're not thinking about the child. They're thinking about themselves. So then let's go get a spirit key. This is where the child is. And this is where Larry and Rita go to go get a spare key. Which is why they don't get back for 52 minutes. The child's locked in the car at 3 o'clock. They don't get back until 4. Any sense of urgency there? Any concern for the health and welfare of that child? Did the child even cross their minds? Because they were hot. And they were interested in each other. And they were interested in kissing, and hugging, and spending time with each other, and having sex. Even the doctor talked about the increased libido as a result of being high on that. And you see it in all these pictures. Because that's what they're concerned about. Not an ounce of concern for that child. 52 minutes. And then when they get back, they arrive 4:40. They get back to the house at 4:40. They're in Larry's truck. Thank goodness they've got a key. They can come rescue this child now. When did they get out of the truck? They don't open the door till 4:44. They sit in the truck for 4 minutes and talking and hanging out. Again, no concern for the child whatsoever. They're just hanging out in the truck. And eventually they get out. And they approach the car. And when they do, neither one of them are sober enough to even figure out how to unlock the car. Larry testified, I'm pushing the unlock button, but it's not unlocking. It's because he's locking it. He's locking it, he's unlocking, he's pushing it. And the testimony that you heard from Captain Chapman, but also from even Larry, pushing the button and the light's coming on when I'm pushing the button, but it's not unlocking. And what you know is that when it's hit the emergency flasher, it's going flash, flash, flash. But at the end, when it goes blink, 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 that's hitting the lock and the unlock. I think it's once for lock, maybe 2 for unlock, I don't know. But the point is that you can't do that if the car's on. But we already do that. You know how you know that? Because otherwise, if you spend 5 hours in the car in South Carolina driving around with your air conditioning on, we would all be dead. Clearly the air conditioning wasn't on. They may have thought it was, but clearly the car wasn't on and the air conditioning wasn't on. And why do we know that? Because the child cooked to death. That's why. And also something else. Not one piece of testimony, not one person, not one came in here and said, I turned the car on. Larry said, I was already on when I put the child in there. Although we know that's not true. Did Larry say he turned the car on? Nope. What did Larry say? I turned the car off. And we'll get to that in just a second. So they get the child and they pull the child out of the car. What happens then? Oh, and by the way, one other thing too. If they haven't gotten the child out of the car yet, they can't figure out how to unlock it. It's now 4:47, and they're back to hugging again. That's not a distraught picture because they haven't pulled the child out of the car yet. They're still hugging and kissing. They still haven't focused on the child. And eventually we get the child out of the car. And what happens after that? They pull the child up. They pull the child out. Larry calls 911. What does Rita do? She leaves. When Hallie Godley gets there, Rita's nowhere to be found. She's inside the house. And that's particularly relevant for what we're going to talk about in just a second. He calls 911, but before the police get there, what does he say? I reached in and turned the car off. Why would you do that? Think about it a minute. They just pulled a dead child out of the car. He's calling 911. Police are on the way. Why does he reach in the car and turn it off? Don't want to waste gas? What? Why would you in any way, shape, or form stop what you're doing when there is a dead child on the ground to go reach in and turn the car off? You wouldn't. There's no reason for that. But there's a real good reason to reach inside that car and turn it on. And what you heard Captain Chapman say today is, when we got there, the car was running. The air conditioner was working just like it was working 3 days ago. There was no compression issue with that car, compressor issue with that car. It works. And the air was on, the car was running, but it wasn't cold inside. The air conditioner was blowing cold, but it wasn't cold inside that car. Why? Because Larry had just turned it on right before the police got there. Why? Because he knew he just murdered that child. That's why. And by the way, what did Rita say when they finally went and got Rita out of the house and brought her out? What did she say? Hallie Godley testified to this Monday. That was the very first witness. She said, I brought Rita out, and Rita said, we put the child in the car. I went inside to get cigarettes. I came back out, and the car was locked. That was her description of what happened. Even Rita didn't say the car was on with the air conditioner running. Because that would have been the very first thing out of her mouth if that was true. Instead it was, was just a matter of seconds. I went inside to get cigarettes. I came back out, and the car was locked. That was it. Because Rita didn't know they had the camera system. Thank goodness they did. Because we wouldn't know any better. But we do know better. The child wasn't just in the car for a split second. The child was in the car for 5 hours and 42 minutes. It's an awfully long time. Everything I have told you so far, you know. Yes, you guys do know. I think we'll talk about that. So you know what happened. The question is before you now is, what do you call it? What is it? You know what it is. You've seen it. You've heard the testimony. The question is, what do you call it? Putting that child in the car to begin with, and leaving that child in the car, exposing that child to potential death, was the infliction of injury to that child. rose to the level of substantial death. The first charge, they did that early. The conspiracy, they did everything together. But the rest of the 4 hours that the child was in the car. What about the pain and suffering that child had to endure before they died, as Dr. Vitalis testified to you? We expect at 105 degrees that people start dying. We've all had fevers. You know how bad you feel with 100-degree fever or 101. Child's inside temperature was 110. And Dr. Vitalis said, I'll be honest with you, I think at 104, 105, the brain stops working, the organs start shutting down. She vomited into her throat. She defecated in her diaper. You see that in the crime scene pictures. Her whole body just stopped working. And I'll be honest with you, I wouldn't expect her to last more than an hour in those conditions. And they put her in those conditions for 5 hours and 42 minutes. So you know about the infliction of serious bodily injury. You know about the conspiracy. What do you call the child's death? Well, murder is the unlawful killing of another with malice. What does that mean? Unlawful killing of another, that's pretty easy, but what's malice? Well, there are 2 ways to show malice. One is expressed. If you walk up to somebody and say, I hate you, I'm going to kill you, I don't care if you live or die, you shoot them in the head, that's expressed malice. This case is about implied malice. And what is implied malice? Implied malice is that you can take from the facts and circumstances of the case, what you have seen, what you have heard, what you know about this case, that someone was so extremely reckless that they had a wanton disregard for human life. They may not even have direct ill feelings toward that one individual, but their attitude, their actions, all of the things that they chose to do, all the way they chose to act, all led back to a conscious disregard for the lives of others, and in this case, the other person was Christina, a child totally dependent on them for safety. A wickedness, a depravity, malicious. And we know what malicious is. And so I ask you, as you go back and look at all of this, at what point in time in any of this did either one of these 2 people show an ounce of compassion or care or concern for Christina's life? If they had walked up to her and shot her, she wouldn't have suffered the pain that she suffered in this case.
Judge, that's your argument inflammatory. Matter of law is appropriate time.
Objection is overruled.
Thank you, Honor. 5 hours and 42 minutes of suffering. You see the blisters on her legs, the burn marks from her coming in contact with other parts of that car that was also rose to the level of 118 degrees or 135. She was burned externally and internally. What do you call it? Well, I'll tell you that if you're sitting around talking to your family members or your friends and you're describing this situation to them, you may not talk in terms of legal anything. But I think a good way to describe this is torture. The child was tortured. Before Larry and Rita, after Larry and Rita. Not the Larry and Rita that these other people didn't know. The Larry and Rita that were high on meth. And these bruises and these blisters that Dr. Vitalis described, torture. And you don't accidentally torture somebody. You treat them with such a lack of disregard for their human life that they die because of the torture. And that's what happened in this case. In the real world, you're talking to your fans and family,
Can you describing all of this? You might use the word torture. But in this courtroom today, they ask you to use the word murder. Thank you.
Now I have two defense presentations, one for each defendant. I think Larry's going first. Let's see.
Good afternoon.
This is Larry's defense, Larry King's defense.
Solicitor, in his comments to you, said a bunch of stuff, and some of it I agree with, and some of it I don't. I'd like to remind you at the outset that a moment ago, in the midst of his remarks, what he said was, and I wrote it down, they may have thought that the air conditioner was on.
That was a misspeak by the prosecutor.
I will tell you right now, when you have heard the judge explain the law in this case, and you apply it to the facts that you've heard here, that sentence alone means the murder goes out the window. We'll talk about murder in a minute, but please, if you think nothing else about that opening remark, remember that the solicitor has conceded to you that Mr. King may well have thought that the air conditioner was on in that car. Now, ladies and gentlemen, I'm here on behalf of Mr. King. My remarks to you were addressed solely as relates to Mr. King. Ms. Hanlon has a really good attorney, smart guy. He's going to address you soon as relates to her. So again, understand, I'm not talking about the two of them. I'm talking about Mr. King. Another thing that the solicitor pointed out in his opening remarks that I agree with was he said, well, this child was totally dependent upon Rita. And he said it over and over, and it's because it's true. This was a child who was always going to be dependent on her mother. Her mother was responsible for her. Her mother had to care for her. Her mother may well have tried to do the best she could or not. I'm not talking about her, but I'm talking about the child who was completely in her care. There's no evidence before you that Mr. King was this child's father, Mr. King had adopted this child, that Mr. King and Miss Rita were married, and he was some sort of step-parent. He was dating her mom. It doesn't create some sort of legal bond between them or create duties that he has to do. This child is in the care of her mother, and he's visiting with her mother on that particular day. Ladies and gentlemen, when y'all return to the jury, when the judge is charged you on the law and suggests or instructed that you commence or begin your deliberations, it may be that if y'all read Mr. King's indictments first, that you simply say, looking at the laws the judge gives it to you, Larry is not guilty of the crime. At least he's not guilty of any one of these crimes alleged in this indictment. Larry didn't kill anybody. He didn't commit a murder. He didn't cause grief bodily injury to anybody. And I'll talk about the conspiracy court. There's going to be no evidence to support that. It may be that at the outset you say, I understand why the state was outraged. This never should have happened the way that it did. But Mr. King didn't kill him. If that's the case, I don't know if we have a full person. But if that's the case, whoever the full person is on the jury, you're fully entitled to this right for not guilty. Set those indictments aside and move on with whatever other business y'all have. But in the event that one or more of you feel like his circumstantial situation merits further discussion in the jury room or deliberation, I need to talk to you about a few more things, okay? First of all, the judge is going to tell you soon that every person charged with a crime is presumed innocent of any wrongdoing. And I know somebody wrote a book and they made a movie called Presumed Innocent and stuff like that, but it's an absolutely critical term of law when used in court here today. And what it means is the defendant, although he chose to testify, has absolutely nothing to prove during the course of the prosecution or during the course of his defense. And you have a right to remain silent, and that right cannot be used against you if you choose to exercise it. It's because of the presumption of innocence. It doesn't mean we'll wait and see. Maybe, maybe not. Show me what you got. It means at the outset of the trial, even to this point, you look at that paper and you say, he's innocent. It's critical. And then you look at this paper and you say, okay, Mr. Solicitor, your office brought the indictment, your office called the case, your office summons law report someone's here to try the case that you scheduled. Prove to me that the defendant is guilty of the crimes in this indictment or in these indictments. And for the state to prevail, to meet that burden, what it means is they have to prove every element, ingredient, ballot. They have to prove every element of the crimes that are alleged within the indictment. They have to prove them beyond a reasonable doubt. So this isn't civil court. I don't know if you've done that. Sometimes you see the statute, lady justice, when she's holding the scales and it tips a little. In civil court, it's preponderance of the evidence. It tips one way or the other, that side of things. It's not that way here. Today it's proof beyond a reasonable doubt. And the state calls it murder indictment against Mr. King, alleging that he has murdered a child. It means they make you a promise as juror that they will dispel every reasonable doubt as to every element and prove beyond hesitation that Mr. King is a murderer and that he murdered that child. I talked about beyond a reasonable doubt. This term of art also is Judge Zahn is going to define for you. But a reasonable doubt, and he will tell you. I know you all pay attention to the charges. He will tell you that a reasonable doubt is the kind of doubt that would cause a person to hesitate to act in the course of their own most important affairs. And in any criminal trial, if your juror has that kind of doubt as to the guilt of the defendant, you are required by the oath that you took earlier to return the verdict not guilty. So, if we put aside some of what I would call the clutter or distraction in this case, and just look at what is actually relevant and what should help you in your search for the truth or in your weighing of the evidence that's been presented before you, I would suggest to you that most of what you've seen is more or less clutter. Okay? I mean, the state called Dr. Grundy, the state called an expert from Georgia. He was an expert in heat. And he came from Georgia to tell y'all something that every one of you already knows. If you park a car in the direct sunlight in eastern South Carolina in August with no air conditioner and the engine not running, it's going to get too hot to live in that car. So the charts and his testimony and all this, it's filler. Because it doesn't give you a chance to look in Mr. King's heart, which is what you're going to have to do shortly. We conceded in our opening statement that this child was in a car, that it got too hot, and she died. I submit to you that this professor from Georgia doesn't really bring anything new to the table. You can pretty much set it aside because we know what happened. It got too hot in the car and the child died. The pathologist is the same. You already knew before the pathologist ever took the witness stand what had happened with this child. You had heard us concede that this is what happened. You had seen the videotape that this is what happened. And you knew this child died from me. Really nothing you should do whatsoever. They called this police officer, Captain so-and-so, and I don't know why he's back up here today. But they called him to testify to this key file. There's been a lot of talk back and forth. But really, what was necessary to hear from him was plain and simple. It came out yesterday. He said, if you unlock the car, or you lock the car, while the engine's running, the lights don't flash. Nobody ever locked or unlocked the car with the key fob that they retrieved from Rita's house. Because as you heard, the battery was dying. Once or twice they hit the key fob, the doors didn't unlock, the lights flickered, and then they didn't flicker anymore. So Fine. You lock it or you unlock it while the engine is running with the key fob, the lights don't flash. It never happened. It's irrelevant in this case. And as much as the solicitor wants to talk about methamphetamine in this case, because it's prejudicial and it's bad and people think terrible stuff, because it is a terrible drug. As much as he wants to talk about that, they're not charged with methamphetamine. And when the solicitor says the only reason that you know methamphetamine was involved in this case is because their expert came to testify to that, I submit to you that's not true. As a matter of fact, what their witness did to the toxicologist, while I submit she gave you nothing that would help you in deciding this case. She said methamphetamine goes to the cycle, you take it in, it keeps in your bloodstream, your body processes, it goes out of your bloodstream. She says, yes, people get a tolerance to it, and I would submit to you that if anybody would have a tolerance to it based on all the evidence that she knows, probably. She also said that, yeah, Mr. King having 400, that was certainly a level to raise eyebrows or cause concern, but that she's seen it up to 2,000. This doesn't have anything to do with the charge of murder. We don't talk about that. But what she did do was give the defense, wrapped up in a nice box with a fancy bow, a gift to Mr. King. Because she said on the witness stand, under some fairly stringent cross-examination by Mr. Phillips, yes, this stuff can take up to 3 days to get out of your body. She further confirmed to him, I can't say if this is from ingesting methamphetamine that day or the night before, or if it's from 3 days before. I simply can't say that. You know, as jurors, that there's a whole lot of people who would have sat at the defense table, and that would have been the story. I took it 3 days ago, and I get on the stand, only the second time I ever used it. 3 days before that, 2 days before that. I was just tired. That was the only effect I was under. I was out from under this. Mr. King got to the stand, and he rejected that. He took an oath to tell you the truth. And we're hurting, potentially, or at least make the solicitor realize he has been smoking right in the family. He told him. No one else was going to tell you he was addicted to methamphetamine. No one else is going to tell you he was what's called a functional addict. That is, that he used methamphetamine throughout the day to allow him to function. He's never been without work, no excuse. Had 5 jobs in his life, no excuse. He's always been functioning, going to work, supporting himself, meeting his needs. But just as there are functional alcoholics, he was a functional addict. No one else was going to tell you. The solicitor knows that, right? And he's probably going to talk about it some more because he loves talking about that. Why did he tell you that? Because he tells the truth. Good, bad, let the chips fall where they may, this is what happened. It's not that he didn't want you to know, it's a solicitor. The only time he hesitated to answer was when they asked about weed. And according to his own code, he said, I'll speak for myself. Then he answered the question on further cause. But the judge will soon tell you that it's up to you as jurors to judge the credibility of the witnesses as they come in here to testify. And credibility means the believability. And there's no magic formula for it, but the judge will tell you it's your own opinion based on your own experience, your own worldview. But when a person testifies, you can see that they testify consistently or inconsistently, they testify, they contradict themselves, or they supported by other facts and evidence or other evidence that's being presented. And I will submit to you that if Mr. King will come in and give the state this gift, knowing full well it sounds bad, but he's honest enough to give you that, you can certainly find he's honest enough to give you the rest. If he'll tell you the things that are bad for him and you believe him, you can probably believe him when he tells you the rest of it also. Now, the state has charged Mr. King with murder. I assume it's the worst crime there is. And murder is not hard to define. Murder is the killing of a human being with malice aforethought. First of all, as relates to Larry's case, the murder indictment fails me. Okay? Larry didn't kill anybody. If you recall and you think back to the solicitor's opening argument, or opening statement, his opening statement, he says that he's going to show you the videotape where Mr. King rudely comes out with this child, the doors open, he throws the child in like some baggage, but he just wants to be rid of her, and he uses the term 2 or 3 more times. She was just baggage. I know y'all want to take my show. Lawyers can't help it. We watch y'all play it. I watch y'all all the time. I know everybody paid attention. Everybody listened to all the evidence. On behalf of Mr. King, thank you all for that. But you didn't see that. What you saw, it's in evidence. You see it again if you need to. Was Mr. King coming out, as he described, appropriately, properly, gently, maybe lovingly, but certainly appropriately, properly, gently, appropriately. Place the child in the back seat. Move the child to put her in the proper position and be comfortable. Step back. Rita stepped up, put the seatbelt on her, did whatever she was doing. She did what she needed to do to have the child settled into the car. That's all there did in this case. That is the sum total of what he did. He relinquished this child into the arms of her mother. He stepped away. I got the feelings hurt, heartbroken the way he described it. I'm out, and he tells her to go. You just go. Leave. I'll talk to you later. She doesn't leave, obviously. She goes back and forth. But at that point, the solicitor would need to prove to you, hold on, that when Larry King put her in that car, he did it with malice. First of all, he's got to prove that putting her in the car killed her, which of course is nonsense. It didn't. He made efforts to make sure she was safe and well done and properly positioned in there. And then he's got to show that when Larry did that, when he put that child in that car, he did it with malice. That he killed her, and he did it with malice. What does malice mean? I'm going to read it to you. Sorry, I'm going to read it. Malice is hate, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstance in which the law will confer an evil intent. That's what malice is. So before you can even consider whether or not Mr. King should be convicted of murder, you have to consider whether or not there's any evidence whatsoever to make you believe he put that child in that car with hatred, ill will, hostility, or the intention of doing a wrongful act. And that's nonsense. And y'all met Mr. King. Y'all met him. Y'all had a chance to judge his credibility, his believability, and to determine whether or not you think he's innocent based on everything you heard, everything you saw, whether or not the state has proved beyond any reasonable doubt in your mind that when he put the child in the car, he did it with hate, ill will, and malice. And it's nonsense. Further, malice can mean a general malignant recklessness for the lives and safety of the others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. And all of that's real strong language, and there's a reason for that. It's because it needs to be. It's the worst crime that there is. And if Larry actually walked out and put the child in the car with the intention of the mom driving her safely away, and then he stepped away and said, y'all go, and he doesn't do anything else to this family, there's no indication whatsoever of malice, hatred, or ill. And without it, the murder indictment falls in court. It falls for element one, killing someone, and it falls for malice, because he didn't kill anybody, and there's no indication he had any malicious, ill will, ill intent toward this child. That's what the state promised to prove. Ladies and gentlemen, in your jury room, excuse me, in your jury room, you will have the indictments, and there are 3 indictments Mr. King is called to answer to. Murder, and I'll address that. Inflicting great bodily injury on a child, and the arguments will be very simple. And a conspiracy charge. When you have those indictments in your jury room, you are fully entitled to look at them, examine them, and see what you think about those documents. You may notice, if you look closely, that shortly after this child died, Mr. King was indicted for murder. Period. Stop. And then as time went on, and a trial went, and the rubber's going to meet the road, we're going to put it to the test. Somebody looked at that murder indictment and said, this is a lie. It was 2.5, maybe 3 years later, coming in for the trial, they came up with new charges. And that's just different. Look at the dates. Look at the dates. And they got all this fire in their heart, absolute confidence in this murder case, we've proven that, etc. Why are you coming around at the back end and trying to get a fallback position? You know why. It's because there's no evidence of malice whatsoever. There's no evidence of guilt. That indictment goes by the wayside. The arguments as to inflicting great bodily injury upon this child are the same. Mr. King placed the child in the car. At that point, she's not in his house, she's in the car. Mom can get in the car and drive away. Mom can get in the car and drive 100 miles an hour. Mom can walk. She can do whatever she wants to do. She's not his child. He is not responsible for this child. He is not the one who needs to take care of this child. He steps away and says, y'all just go. She's off his claim, so to speak. He didn't hurt her. He didn't cause her to be hurt. As a matter of fact, as the solicitor concedes, he thought the engine was running, the air conditioning was going, and she was off his claim. He'd seen nothing in the grievous parental background to cause him concern that she wasn't able to care for her child, or in some way she was going to allow the child to hurt, or that the child was in danger because her mother was there. And her mother had the child. And as the solicitor stated, she'd always ride on Rita. And I'm not shooting at Rita. That's a different, not on my place. But she relied on Rita. Only one person was responsible for the child that day. And it wasn't Mr. King. Now, that would bring us to the conspiracy charge. Mr. King is also charged with conspiracy. I told you at the outset and got admonished for it. I don't know what the conspiracy to do what. And the indictment doesn't say. It doesn't say conspiracy to commit murder, conspiracy to cause great bodily injury to this child, but a conspiracy. Okay. I'll assume, or I'll go with, that means he must have conspired, because the solicitor made a point of saying how they acted together, everything they did together. Well, he must have conspired to murder this child. Or he must have conspired to cause great bodily injury to this child. I'll tell you what conspiracy means. As I'm going to tell you shortly, but just so I don't get it wrong. Conspiracy is defined as the combination between 2 or more persons for the purpose of accomplishing a criminal or unlawful object, or an object either criminal or unlawful by law. So basically it means conspiracy is defined as the combination between 2 or more persons for the purpose of accomplishing a criminal act. So he's alleging that Mr. King has conspired with someone to murder this child. Now, if you look up the word purpose, Google Dictionary, it'll tell you it means intention. The judge's purpose here today is to rule on matters of law and ensure that the defendants get a fair trial. The judge's intention here today is to rule on matters of law and ensure that the defendants get a fair trial. So, we can substitute that word and say a combination between 2 or more persons with the intention of accomplishing a criminal act. So, I told you at the outset this was a garbage indictment. It is. Certainly, even the state is not going to get up here and tell you that they've established evidence that shows Mr. King and Ms. Panlanigan somehow got together and decided, how are we going to murder this child? How are we going to hurt this child? How will we kill this child together? The law says they come together for the purpose or with the intention of accomplishing a crime. And it's absolutely devoid of any evidence that shows Mr. King ever intended to commit a crime. I'm almost done. So let me do this, and then I'll sit down. Let me do this. Take you back to this tape and consider it this way. Blank slate. You watch this tape, and Mr. King walks out with his child in his arms. He places the child in the car. He steps back. Stay with me. He has a conversation with Rita. You need to go, etc. And then he turns around, he goes to the back of his house, he drives away. He's upset, he goes to the brother's house, he goes wherever he wants, he turns and he drives away. And then the events unfold exactly as they did here, without him being at his house. Is there any way he's committed a crime? Is there any way he exhibited malevolence, ill will, or hatred? Is there any way whatsoever? And the only answer is no. Well, the only difference between the scenario I just described and what took place is that in this case, he was present in the case. He didn't do anything different. He was just present. His honor was in integrity. That you cannot be guilty of a crime created by his integrity. So Mr. King's undying regret already continued, guys. He was present with the crime, so he's the all determined. But he did no more in reality than he did in that scenario I just described. Thank you.
Okay, now we get to hear from Rita's defense. Hopefully it's a little louder. We don't have to crank up the noise in the courtroom.
Ladies and gentlemen, we're going to break for
break time.
45 minutes for lunch.
Short lunch.
Please do not discuss the case. We'll go to the jury room.
Okay, we're trying to... All right, so the defense there, he's arguing. He's got an argument saying basically, according to the law, Larry's not responsible. He takes a very limited look at the video.
45 minutes.
45 minutes.
Your Honor, right before we break, one of the things is this is televised on Court TV and on Crime and all these news stories. Before we send the jury back, I'd like Your Honor to poll them to see if they happen to watched any of that or come across it, just to ensure if we need to have somebody stricken.
He's not going to do this.
It just is a fail-safe, Your Honor. I want to make sure that's absent.
Okay, we'll do that.
He would.
Thank you.
Wow.
Okay.
So he's going to ask the jurors if any of them watched this, any of the case.
45 minutes.
On Long Crime Court TV or all these other stations, he said. I've been kicked off. What did I do? I'm devastated. Rosie, how did you get kicked off? How did you get kicked off? I didn't know you're not kicked off now. I don't know how you got kicked off. We're gonna turn off the audio there just for a minute because it's so loud. Yeah, that's a last ditch effort to try to see if they can. It's not to get a fair jury. Honestly, it's so they can get a mistrial. That's what they're hoping for. They're hoping they can get more people to admit, to say, "Yep, I watched it, Your Honor. I disobeyed your strict instructions and went home and I pulled up Court TV or Law and Crime or, whatever the South Carolina news channel is that's airing this. And I watched the whole thing so I could see what was happening out when we weren't there. It's not going to happen. It doesn't happen. The people know they're not supposed to do this. So yeah, there's no problem. I'm gonna end the poll here on the jury deliberation time. Let's see, I'm also gonna get rid of this pinned message because Larry's defense is over. The jury, let's see, last chance to vote here on the jury poll. I think I just ended it actually. Did it just end? Where'd it go? It's hiding somewhere. Oh, there it is. End poll. All right. We say 44% say 2 to 4 hours. 40% say 1 to 2 hours. 12% at 4 to 8 hours. And 3% with over 8 hours. That's with 525 votes. So if we're right, if 84% of us are right, which is funny because 84% was also the number that we had that said that both are going to be found guilty. If we're right, if that group is right, then we'll probably have a verdict today at the end of day, before the end of day, and the verdict will be guilty on both counts. Imagine if it was RA someone watched, then the judge would have to pull it up on the live stream and listen in for a little while and see if it's okay. He'd be like, "Oh yeah, it was RA. Yeah, you're good with that." I bet every single juror took this extremely seriously. Mr. Torso, they generally do. I can remember, let's see, I don't remember what case it was, but there was one juror who's like, "Oh, somebody said something to me and I told him to stop." How often do you have a juror that says, "Yeah, I went out and completely disregarded the instructions. I just found this case so interesting I decided to do my own research." Went home, pulled up Recovery Addict, and watched everything. I do have all these videos on the lives. We've got the entire court case that we followed from the beginning. So we have all those available, but at least from the opening statements on. But we're not. I don't have them in a playlist yet, so I have to get them on a playlist. What happens if jury doesn't come in today? Will they have to come back at the weekend? Sharon, I don't know. I'm hoping the judge might explain that a little bit. I think he's already worked it out with the jury, but he can't really tell them how to deliberate or when to be done. I think his deal was he promised to get the case to the jury before the weekend, and then however long it takes, that's how long it's going to take. Barbara Smith says, "I believe Rita locked the keys in the car on purpose. It's obvious in the video she didn't want to leave and wanted whatever Larry was scratching." Yes, I should have read that whole comment before I just read the thing out loud. But yeah, it was pretty disgusting. I think the only reason she is crying is because she got caught. Stephen says, "How was the hurricane?" It was a miss for us. But those poor folks down there, especially down by Perry in Florida, right there on the bend, got hammered. I was taking some calls for these guys for crisis cleanup last night from people who were asking for help cleaning up their yards, and just talking to people about some of the stories about how they experienced it and what happened there, and people are describing their telephone poles that are snapped off, like the telephone pole snapped and power lines down over the house, and it's really, really bad. They had, I believe, what people are saying, according to the people that I've been talking to, is they had both the hurricane and then they had a tornado that came through that area as well, possibly wrapped in rain and everything else. Let's see. Went to a local bar and all the TVs were on. Imagine that. Yep. Doesn't Judge Newman ask the jurors at the start of the day if someone has watched or heard anything about the case? He has not on this one. At least not on to us. Now he might talk to the jury outside the presence of the lawyers, but I doubt it. I've only heard that happening a little bit. Usually, once the case has begun, he doesn't talk to the jury at all without the lawyers there. Videos for Perry were awful. It was really, really bad down there. I know Brandy's got her beach cam up, and it looks absolutely gorgeous. They're in the Gulf. Once the storm's cleared out, it's just beautiful. I can show you her beach cam real quick. Just one second. Let's see, where is it? It's right there. There's the beach cam from Brandy. I think she's getting a bit of rain, but still, day at the beach, even in the rain, is a wonderful day. Wasn't it the egg lady who did something like that, or was it that the ZA trial? See, the egg lady was in Judge Newman's trial with Alex Murdaugh. I don't recall. I'd have to go back and rewatch it. All right, where we are now, we've heard the prosecution their initial go at it. They do get another go at it. So we've heard them. We've heard Larry's defense. We're now going to hear Rita's defense. Hopefully he's going to stand closer to the microphone, or at least have the podium in front of him so that he can talk and we can hear it. Then after that, the defense or the prosecution will get our final wrap up. They'll be able to address the things that both defenses brought up, and then sort of put a bow on it and hand it to the jury. We'll get the jury instructions at that point, and they might be a little bit lengthy. I expect probably 30 to 45 minutes of jury instructions, and then the jury's going to start deliberating. Let's see. Kim R says, I just posted a portion of that part of the video on your Facebook page. Very interesting watching Rita going to and from the car again. Yes, thank you very much, Kim R. I'll take a look at that. We only saw that just that one time the other day. Where's the video? Missed the videos. Jeannie, I haven't made a thumbnail for this video. Honestly, I don't know how to do it because I don't have very good pictures of everybody for it. I probably should put a thumbnail on there so it's easier to find and put it in a playlist. But if you go to the live button, the description will tell you the different days that we followed this. The judge says it's day 4. For us, it's day 3 because we skipped the pre-trial stuff with jury selection. Okay. Debbie, thank you. We did make it through the hurricane just great. We just got grazed. It rained. I think we got maybe 4 or 5 inches of rain, and it was spread out throughout the night, so it was pretty good. Egg lady was Murdaugh. The dozen eggs. It wasn't just she was the one that we say the egg lady, but everybody had a dozen eggs. That one juror brought a dozen eggs for everybody. She's just the one that had to take them home early. Everyone else took them at the end of the day. There were eggs all over in there. Rosie says, I don't know what happened, but I was locked out of chat. I am sorry, Rosie. It seems to be fixed now. That's wonderful. Honestly, this case doesn't deserve a thumbnail unless you just put one of Judge Newman on it. That might be a good thing to do. Maybe I'll just put his honor just front and center. That's when eggs were so expensive. Yes, and one of the jurors had chickens, and they're like, I've got all the eggs I can handle. I just brought like a carton of eggs for everybody. Frosty Jen says, hello, I'm listening as usual while I work. So grateful for my job. I get to work from home. Woohoo! And my husband is my boss. Well, hopefully you got a great boss. So that keeps everything copacetic there at home. Let's see. We're not in verdict watch yet. Not yet, Sammy. We've got one more defense closing to hear, and that's Rita's defense. This guy has been very, very aggressive in fighting this case and challenging the jury instructions more than anything else. I mean, we counted. I think we were up to 21 or something objections, and they really haven't had as many objections during trial as we thought we would have. Especially considering we had 2 defense attorneys that would all object. And sometimes they do object differently, or not all object to the same thing. But where we really saw the spiciness and his passion for pleading his cause in front of the judge was when we were talking about the jury instructions, where the judge wants to discuss what the rules are he's going to admonish the jury with before they go off and do their deliberations. And really, I think that's what he's trying to get a win on. So if he can change these rules and make them, a little bit more friendly for his client, just in the wording of how the jury is told how to do their job, that could be more beneficial than any witness he could call up, because really, they've got a tough defense to try to raise here. Eggs are now under $1. Unreal. It's go up and down. Price of eggs are crazy. Small hailstorm here at the moment, says listen to learn. May 9th, we had probably 50-cent piece size hail at my house. What do y'all think of the defense guy's closing? I think he did a weak job. There are a couple points he raised that he did okay on, but overall, I don't think the jury was with him. I don't think where he started, he's like, I told you this at the beginning, and now here it is. This is a garbage indictment. And I'm like, you need to probably walk them through that a little better than just trying to say, I told you it's junk, and it is, so we can, throw that out. What I did like is how he broke it apart and said, look, you're trying two defendants, okay? You've got two people. And honestly, on this one, on my defendant, I only care about Larry. Rita is her own thing. She's got a great lawyer. He's going to do his thing. I'm only talking to you about Larry. And if on this case, if we can get you to look at this and just consider Larry, and if if you believe, like I've told you, that these they didn't meet the elements of the charges, you can set those aside. You can say not guilty, set it aside, and then you can focus on the guilty party. He's like throwing Rita under the bus there, but telling the jury that they can view these separately. They can sit down and view first one for Larry and one for Rita, and they don't have to be the same. It's not a yes, they're both guilty, or no, they're not guilty. It can go either way. So that part was good, but overall, I don't think he had the jury, in the palm of his hand, walking them through a logical thinking process that got them to see things the way he does. Mazla says, hi, y'all. Just liking and saying I'm in and out, but I'm concerned that our court reporter is struggling with a condition. COVID, shingles? I don't know. I haven't been paying close attention to her. I know she's got a lot of things to do. Court reporters do more than just type, and she's got like 6 things going on. Let's see. Lego Briefs, so we just wrapped up the poll for length of deliberation. Number of questions they may ask. I've never done a poll on that one. It's interesting. Let's see. Whatever way the defense spin it, they both had care and duty knowing that Christina was in the car for that length of time, and they're both 100% guilty of gross negligence, says CD Man 77. I'm getting like a weird sound in my headphones. Test 1, 2. Check, check. Test, test, test. Test 1, 2. Now it's super hot. Test, test. Was that bad? Is that good? Turned it up a notch. Court reporter looked emotional during the state's closing. I wouldn't blame her if she was. I think had we had a camera on Judge Newman the entire time, we would see that he's also been emotional during this as well. Some of the testimony, just for any parent, especially one who has lost a child, is just heart-wrenching. Mr. Torso says, I don't know if the jury is going to get pedantic about the law in this case, even if they should. I think they're going to come down hard on both, but Rita might get it worse. I think the law so far has made it, treated her a little more harshly. She has the higher bond. It's double what his is. Maybe there's a reason there. Kath says, maybe an obvious question. Are Rita and Larry still in contact, apart from sitting aside from each other? They are not. Rita is actually remarried fairly recently, like in the last couple of years. And Larry is, they're no longer connected at all. The sound is the after effects of eating a whole jar of pickles. Well, I'm about to experience those again because I've got a jar fully chilled in the fridge waiting for me. Sarah, I can't see that happening. It's these pictures, the pictures they showed the jury of Christina, they're really, really rough to see. We've only seen a couple, like in passing, as we've seen the pictures from an angle. I think the jury will feel a sense of obligation for justice here. And there's enough evidence, especially with the fact that we have a video of 5 hours of this. I mean, the entire crime as we watch it happened on camera. So I don't think that they're going to have not guilties across the board. If we had not guilties across the board, the jury would have to believe that the car was on, and that the behavior that they witnessed, especially first maybe Larry, that was they believe him saying he had no responsibility. So the car's on, air conditioner's on, according to them, at least in their minds. Larry has no duty to care for the child, and also that the behavior that we saw from Rita throughout the rest of the time was appropriate and didn't, they'd have to believe all that together to get a not guilty on everything, and I don't think they'll be able to reach that. Okay. Question is, why did they put her in the car in the first place? Jerry Lynn, I envision, we heard testimony earlier on in this case from the babysitter who showed up to help a little bit with Christina at Christina's home, at Rita's home, and then Rita bailed and didn't show up for a couple days. She just was gone. Didn't say, hey, I'm going to be gone for a couple days. See you later. You can take over and babysit. She just disappeared. She's like, hey, watch her for a second, and then she split and went on, a bender. I think that bender probably looked something a lot like what we just saw in the video, with the 5-hour video. That's probably what was happening there. At least that's how I envision it. So I would say, not why did they put her in the car in the first place, but why did she bring her along in the first place on a drug bender? Is it she just couldn't find a babysitter? So sure, I'll bring the kid. I'll bring the kid to go to a meth house and get toasted out of my brain. There is some testimony that we heard that she put her in the car a lot of times. She even tried to get someone else to watch Christina at one point and said, just keep her in the car and you can leave her in the car. I do it all the time. Where's the video? Christy, it's there. It's there. It took a while for us to get video. And then once they start playing it, they jump all over the place. They we're watching it live, and then they jump back to the rewind, and then jump live again and back and forth. So you have to keep an eye on the timestamp in the video. But it's 2 days ago. This is when the video started being shown. Yeah, it wasn't yesterday. So. '80s Music Man says 100% guilty. No chance of not guilty. This is an open shut case. They put her in the car as a free babysitter, in my opinion, says Kathy. It's clear that none of them were thinking clearly. Neither of them were thinking clearly. The drugs had such an effect on them. They were not walking straight. They were clearly not conversing in a manner that we would say would be normal. Their decision-making skills were questionable, to say the least, even just in how they were behaving and what they were doing, and it was bad. In South Carolina, being on drugs, voluntary intoxication is not a defense. So, one of her daughters got arrested the next week for leaving her kids in the car. We didn't see the video, did we? We saw most of the video, Kiefer. There were a couple parts, specifically once they got the car open and got the daughter out after the 5 hours and 42 minutes or 46 minutes. We did not watch that part. That was not made available. Let's see. Trying to follow some chat and get caught up here. All right. Why are they trying both of them at the same time in the same courtroom? Jimmy, this is a decision the court made. Basically, they said this is the same crime. We have multiple participants that committed the same crime. It would be... It's the same set of facts, the same evidence. They're basically saying we can't separate that. Now, in the defense, the defendants have the right to independent representation, because they have the right to throw the other person under the bus, basically, or have a different story as to their theory of defense. And in this case, the defense guys are saying, yeah, this hurts us because we get painted with the same brush that she's getting painted with. And the prosecution says, yes, you do, because you committed the crime together. And that's where the conspiracy charge came in. We're just on break. This is a short lunch break. They said 45 minutes. So we have, I don't know how much time left. Actually, the closing arguments for the state were good, very logical and thought through, and covered everything very well. The closing arguments for Larry King were difficult to hear. The lawyer turned to the microphone and then walked away from it. And so we just got a lot of background noise. Even cranking the volume up, it was difficult to really follow. So it really doesn't make it worth watching. You'll just end up with a headache. I can just tell you, he basically restated the same things we've heard from him all along. Same thing we heard from Larry on the stand was, I gave the child as much care as I was responsible for, and that was just carrying her out and putting her in her car, gently strapping her in, and getting them set to go and telling them to leave. And then everything else is not my fault. Karen, we're waiting for lunch to be over. We're on lunch break. You found the video of the car was almost on the front porch. It was right there, and there are parts of the video where these two are sitting on the porch swing, just swinging away. She's been in the car for 3 hours, and they're just swinging away on the porch swing. Can be. I don't know that for sure. I'm not sure. I can't say that. All I can say is the court reporter has a job that I don't think I could do. Do you think they overcharged on this case? Should it have been manslaughter charge? Haven't asked that. I believe they should both go to jail forever. Dallas born, Boston bred. Initially, I did think they overcharged this. After watching the video, I can see why they went where they did. The behavior. There are so many points during that video where you think, okay, now they're going to do the responsible thing. Now they're either going to break a window, they're going to call for help, they're going to call 911, they're going to get neighbors, get somebody. They're going to do something. Instead, they go to kissing and hugging and talking and swinging and drive away for an hour and come back. It's like, okay, now it makes sense. Now it looks like they did conspire to have this outcome. See, any idea why they didn't do that for the Melly and other defendants trial that's coming up? The RICO case? Todd, I think that's the RICO case, right? They have is that Young Thug? Anyway, I'm not sure. I haven't stayed up to date on that one. If it's the Young Thug case, I tried to go to that trial one day, and that first day, somebody Zoom bombed the courtroom and started playing inappropriate videos on the screen that was visible to us as a camera angle. And I got gun shy of that one and said, I cannot go back. It is so dangerous. I haven't heard the lessers. We're going to hear that when the judge reads all the instructions to the jury. I think we'll find the lesser includeds there. Can you run a ticker tape of your most often repeated answer? We're on a 45-minute lunch break, for example. I could, wishful thinking. It just, let's see, 1, 2, 3. My problem is I have limited numbers of upstream and downstream keyers. That's the catch. It would have to be a downstream keyer as a video source, which would take up one of my channels. I just like to watch so many things at the same time on my screen over there. It would tie up another window. So Melly was double homicide. Young Thug is RICO. Okay, I was thinking Young Thug. I don't remember the question about Melly. Didn't follow that trial either. I believe that one was just, mostly it was a trial of patience while they had sidebars. don't talk where you go, or this could get beyond pickles. Yeah, we'll steer clear of that one. Okay. What is our next trial? Actually, we were talking a little bit. There's one case that we're really, really anxious to follow, and that is Sarah Boone out of Florida. It's currently slated to start October 2nd, but there's a hearing next week on Friday, and that hearing will determine whether or not her current lawyer is released from the case or has to stay on as a defending her. He's filed a letter with the judge saying, I want off, and Sarah Boone should probably just represent herself because no lawyer is going to satisfy her. So we want to follow that and see where that goes. But we'll keep an eye out. We've got some other trials that we're looking at as well that we'll look at. Some that start on the 5th, I think, is one we're looking at, possibly out of Washington. We'll let you know. I have to do a lot of homework on each one before we can just agree to follow it. Can you imagine being a juror for a 10-month trial? Well, OJ was 11 months, right? It must be like being in a different world for a good year. Yeah. Basically, put your life on hold. Annie Marie, got to go. Everyone, don't forget RA and Weather Watch and Thomas and I have our podcast tonight at 8 p.m. Hope you guys are there. That will be great. Kath, that is a possibility, and if that's the case, are you saying that would get rid of the conspiracy charge? Basically, it was just negligence. But the interesting part is in South Carolina, the legal definition of conspiracy is a combination between two or more persons for the purpose of accomplishing an unlawful object or lawful object by unlawful means. So basically, two people get together to make an outcome. The conspiracy really starts showing up for me strongly in the video when you start thinking about what happened with the key fob and how they're saying, oh, we couldn't get in. And they, after they've seen that she's in the car and they decide to sit on the swing instead, after they, know the doors are locked, instead of breaking a window, they decide to drive away for an hour. That would be the conspiracy side where I think they've got a good argument there. And the state didn't present any other evidence to support conspiracy except for that video. And they basically said that we think it stands on its own as evidence. Let's see. TB, you're right. Brandy Churchwell is going to be covering that case. If you're not a friend or if you're not a subscriber of Brandy's channel, I do highly recommend it. She does a great job. Is Brandy near Sarah Boone? She is in Florida. I think she's just west of where the hurricane hit, so she's closer to Boone than I am. There should be time limit for jury service. 2 months is long enough for a long trial. When are James and Cynthia due back in September? I think they're next week as well. It's either Friday or the 15th. I'll have to check. Amber, it takes a while for them to finally give us the feed, but yes, they do show us the video eventually. Closing arguments are not done, Katie. We have one more defense argument, and then we have prosecution with the final say, and then we'll have jury instructions. Can you request or find a trial of Kentucky v. Bradley Caraway? It's a DUI case with death. Court TV has only shown opening statements and small clips of testimony. If the video exists, if it's like if Court TV filmed it themselves, they won't give me anything. That's not what they like doing. Never heard of Brandy's channel. Oh, you're missing out. Not to be biased, but I'm addicted to this channel. Brandy is let me show you Brandy just 1 second. Brandy is right here.
Because there was no
that's Brandy. Hi, Brandy.
Testimony
she doesn't know where spine on her right now. But she's also on break. She's covering this trial right now, but she's covering the sex therapist California trial as well. Can you do a quick check on the timing of the other cases in the news around parents leaving children in hot cars? There was a case on the of the dad who went to work, but I can't recall. I'd have to do some deep dive on that. September 13th, Greener says, this is going to be for our dynamic duo of James and Cynthia back in court on September 13th. Thank you for all those who are saving that date for us. Sarah Boone is in Central Florida, Winter Park, right next to O-Town. Correct. Orange County. Yep. Yes, Peter Tragos got enough likes or subscribers, I think was a threshold that he said he'd commit to go to attend Sarah Boone, which is awesome. We're still trying to get that same access. The court down there is really, really hard to get into with media access. So Letitia was moved to a prison in Kansas. I don't know. I wonder if Kansas is going to go after her for what she did in the car in Kansas on the way back.
Mickett just sent a super sticker with 5.
Mickett? Did the computer just call you Mickett? MCAT, thank you very much for the super sticker. I appreciate that. I'm hearing a train. It's interesting. I only get to hear a train horn about once or twice a month because we just don't have any train tracks around here. But right now there's one like just downtown, I think. Will you be covering the Idaho 4 case? Teresa Farmer, we have a couple things on that case that we're keeping a very close eye on. First of all, I'm missing the train. Thank you, Tag. I see that. First of all, Brian Koberger's team just filed to say we'd like cameras to be excluded from court. And they did this because the judge had made a ruling saying, hey, you need to not have close-ups on Brian Koberger. And guess what? Just like last time, we have people breaking the rules and doing close-ups. Hold on 1 second. Let's try and answer this.
Call from Mr. Wisconsin.
Mr. Wisconsin, or King Wisconsin. Is that what we call you? Ivan, how are you doing, my friend?
How's it going? How are you today, sir?
We're doing well. Let me finish my answer to Teresa real quickly.
Yeah.
Teresa, I'm just saying that we're watching to make sure that we still have court access with the video. So we have to see what the court rules. If the court locks it down and nobody can see it, it'll be very difficult to follow. It'll basically be something that's followed on social media with tweets and releases from documents. And that gets difficult to follow on YouTube. We could if we had to, but I'd rather be there in person. Ivan, what's on your mind?
Well, I was just sort of wondering what was on yours. How do you think this, I know how much we all have an affinity for, the defense lawyer for her. Like, what do you think he's actually going to say here? What's his silver bullet? What can he possibly say at this point?
I think he's already fired his best shot. And I think we saw that in the arguments he was making about the jury instructions. I think really that's where he was putting all his effort. He's going to probably going to try to harp on the fact that they thought. I mean, the prosecution made a huge mistake in saying they might have thought the air conditioner was on. That was a huge mistake. He never should have said that. He's going to pick up on that as well. That's like a free fumble. Okay, you don't leave that ball laying on the ground. And
I think in the DA's not defense, but at least in his back pocket, he gets to rebuttal one last time and clean that up a little bit, right? And so, if I were him, this is what I'd say: who the heck cares if the air conditioner was on? How many of you, and I would point at every juror, I would say, how many of you would leave your child alone in a car? I don't care if it feels like the Four Seasons or the Holiday Inn or anything in between in that car, which we know it didn't, but even if it does, would you leave your kid in that car for 6 hours, 16 minutes, an hour? How many of you would do that, let alone a kid that can't scream, cry for help, or help themselves at all? I do not care how comfortable they want to make that car seem to be. It just seems like a strange point to, I know it's all they have, I guess, but, holy smokes. I mean, I wouldn't leave my 3-year-old in a car for 6 minutes unattended, and I'm not bad of the ear by any means.
I think the comment that the state made about they might have thought the air conditioner was on is more helpful to Larry than it would be for Rita, because we have Rita on camera doing that whole opening both the doors, like to let the hot air out, and then looking at the dash and poking her head in, things like that.
And so
that doesn't.
And Larry, does it strike you as odd that was there hearings about doing them together? Trying them together. Did they fight that? Was there hearings about it? Do we know?
I think they did, because they've been fighting it, and they said they're renewing all their previous motions. And they brought up at one point, they said, "Your Honor, this is what we said. It really hurts us when we're shackled to another defendant." That sort of language would indicate they have fought it in the past. I didn't listen to all the pre-trial arguments, but odds are they did try to separate the case out so they wouldn't be painted with the other brush.
Well, and let me tell you something about Larry. His whole, Rita wouldn't let me break the window. Dude, it's your property. You see the kid in there. Are you kidding me? Like, I'm here to tell you that the last thing on earth. So when you show up to a prison and you're not over 65, it's pretty much expected that you're going to click up or gang up just to survive. Well, let me tell you something. He's revoked his ability to do that because he has a crime against a child, let alone murdered, let alone a disabled child. So I do not envy that man one bit showing up on the block when like I said in the chat earlier, I'd give half my bank account to see the reaction when he has to read his paperwork. Well, he won't read it. He'll have to hand it over to whoever is quote unquote running that block. Every prison has one. It's just a known thing. There's always somebody sort of in charge of the block. He's going to have to hand that paperwork over. And let me tell you something, him being overruled, by a woman on meth to not break that window and help that kid, that might be a defense for a jury. That's not going to be a defense in the institution. Let me just tell you that.
Yeah. I am not a huge fan of jailhouse justice. I've said this over and over, so I'm not a fan of that. I hope that doesn't occur. I want to see justice happen in the courtroom, and I think it should be. It should be there. But I realize, it doesn't change whether or not it occurs.
Yeah, right. I'm not a fan of it being 30 below, but it happens every winter.
Yeah.
And so there's just what we approve of, what we would hope for, and what is. And in my experience, this is what is. And so I don't know how it flies in women's prisons. I've heard it's not nearly as not nearly the same, I guess. But let me tell you something. This guy's time hasn't even started yet, and I just can't see a jury like this is my point of their whole thing about blaming meth as well. You can't have it both ways. All I heard about was how functional of an addict these people were. Well, if you're a functional addict, you can't have it both ways. You either knew she was suffering and didn't care because the drugs were affecting you, or you're a functional addict. It has to be one or the other, right? Like you can't have the benefits of both argument play into your narrative. And so I don't know.
I don't know.
I feel like they're trying to.
Here's what I think. He's got one last shot, right? And he's fighting tooth and nail right now. I think he's going to give a very passionate, at least strongly delivered argument, even if it's not really logically, solid and the foundation that way probably isn't going to be somewhere that the jury's like, yeah, this guy's speaking the truth. But I think we're going to see a little bit of fiery, some finger pointing, a little bit of yelling, raising the voice, some sympathy, some concessions, from him saying, we agree that this is bad, this is awful, But I think we're going to see that, but I really don't see it working at this point. I think his best bet was to get those jury instructions, crafted in such a way that we made it just a little bit harder for the jury to reach a conclusion for his client.
I agree. I also said at the beginning of that, I also always feel like, and I think Upper Torso mentioned this, it seems as if lawyers, when they're sort of trying to regulate or sort of influence jury instructions, I think they put way too much stock into how that's actually received. They're looking at, like she said, from a lawyer's point of view. I look at things more from a human. I feel like we all suffer from the human condition and the human experience the same. It's just some make better, decisions along the way. And so I don't think they're worried about the logistics or the legalese of how if this word is used or if that phrase is, emphasized or whatever. I don't necessarily think that has near the impact for the amount of time that is allocated towards it. I really don't. I think by the time they get to that point, they know what's up.
Yeah. There were several times in the arguments you can see they sort of pounced on something that was like, legally I can make this point and score this point. And in lawyer talk, or maybe if we're scoring a debate team, I would be like, oh, okay, check one up for them. But the jury's like, they're looking at a bigger picture here, okay? And they're
Joe Blow, Joe Blow, who turns rents for a living, doesn't care what legal word you use instead of the other word. He just doesn't. He's looking at the facts of the case and the common sense of it all, and what flies by his, moral compass and what doesn't. I think that's what it actually comes down to.
And the jury can tell that you're like picking apart a word and you're trying to twist it and say, so you said the lights could never flash, and if I can prove they flashed, then throw out your whole testimony. The jury's like,
it almost makes
that's
it seem
not
like you're
what
trying
we
to put them
heard.
for a fool.
Yeah.
Yeah, it almost makes you seem like you're trying to alienate them, or even patronize to a point in which they almost makes it worse and makes them more angry. Because, like I said, your everyday person who just has a regular job and has a regular life and a regular family and isn't connected knee deep into the legal system, they don't care about the emphasis of what word you use or what phrase you use or what. Anyway, so I don't know. I think if I had to put money on it, if I were a gambling man, and rumor may have it that I have been in the past, I would say I don't know. Lesser charges are included. Is that right?
I believe they are. Yep.
Okay. I don't think we're going to get first-degree murder. I really don't. I don't know that they could have predicted they'd be in that position, or predicted the fight, or predicted the argument, or predicted the craziness, because, as we all know, addicts are predictably unpredictable. However, I think that everything else is going to fly. Conspiracy's weird, but by the letter in which they state it by the law, this does seem to fall under that. It also would seem to say that if I walked into a store with a guy and he said he was going to steal a pack of gum and he did it, that would constitute conspiracy under South Carolina law. So I think all will fly except the first degree if I had to put money on it. So
yeah, I don't know. I can sort of envision Larry getting a lesser included, and only because
I know
because
it's his property though.
It is. If anybody had walked by and known that was going on and had turned and chosen to walk away, I'm like, hey, charge him too. Okay, there's
somebody made a great
a human responsibility to do that.
For sure, just as a man or just as a red-blooded human being. But what if the car gets replaced with a swimming pool?
Yes.
If you see a kid flailing in the swimming pool, it might not be your blood. I don't care. Like I said before, I don't care if it was my worst enemy's child in that car. Nothing gets discussed until that child is free.
Yeah, not just flailing in the pool, but would you put a child in the pool and then walk away? That's going to be, knowing the child is in the pool, we're now going to leave.
Can't swim.
And we're not going to check on the child. And we're going to, we're going to go off and do our own thing. So I think, I don't know, if the prosecution uses some sort of analogy like that makes it a little better, because like it or not, they have this whole, everything in the car is sort of, we couldn't see it. They couldn't see it. They had to go up and put their hands on the window. It's not like they're looking in. It's like, oh, she's still alive. We've got to wait longer. But so it was sort of like happening in a vacuum a little bit. But if you can put that in another scenario, like the swimming pool one, I think that'll sink in and be very impactful for the jury.
Or a burning building, right? What if you walk by a shed and it's on fire and you see a little girl in there that can't walk and she's in a wheelchair? Are you just going to keep walking past the shed that's on fire? Oh, it's not my kid. Sorry, I'm not at fault, even though it's on my property. I mean, come on, dude. Like, he carried her out there, and everyone's like, well, why was she out there in the first place? We all know the answer. Some people use the iPad as a babysitter. Some people use the television as a babysitter. She used her backseat of her car as a babysitter because this child couldn't move. Okay, nobody wants to say that because it hurts and it's sick and it's weird, and no sane person would ever do that. But those are the facts. The babysitter confirmed it. She did this for years. I have no doubt. She got more blitz than usual, and here we are. Yeah. But anyway.
Ivan, thank you once again. Passionate and very reasoned logic from your part. Appreciate it. I think we're on the same page here on this one for the most part.
Absolutely.
So, thank you, my friend.
All right.
We'll catch you later.
Yep,
Happy Friday to you.
Hey, thanks again for yesterday.
Yep, no problem. Hopefully it worked out well.
Yes, sir.
Wonderful.
All right.
Bye.
Bye-bye.
Okay. Perhaps the defense attorney was fighting more for a lesser sentence than with the judge rather than a lenient judgment with the jury. Ellen, I think he wants both. Obviously, he'll anytime he can get a lesser sentence, he's gonna sort of expound on that and minimize the worst stuff. But he's definitely, in the way he's shaped the arguments that'll be read to the jury in the jury instructions, he's tried to help his client out as much as he can in that area. Now he has one more go with the jury, and he's got the benefit of seeing their reactions with the prosecution, of seeing their reactions with the defense and with the defendant who took the stand, and that's why they changed their mind, I think, and didn't put Rita on the stand. So he's shifting as best he can. He's pivoting his defense to be absolutely the best he can for the client, which is good. That's what we want. We want a good defense for everybody, because everyone is innocent unless proven guilty. Front window cannot be tinted. Right, but the reflection on it would be a problem. I mean, our camera angle was very similar to their viewpoint angle, I think. Oh, Dodie, make me one as well. Those sound delicious, as long as they're fresh. I don't like them if they've been, left out.
You have the best hair on this side of the globe.
Unique detail. You're trying to bail yourself out of the hole you dug yourself in when you called me out for having not combed my hair earlier this week. And it's true. I just had time to take a shower and dry it and jump on the stream, and my hair was going every which way. I'll always remember that. It's not that I'll never forgive you. I'll just always remember that. Karen, thank you very much. Admitting you're a recovery addict. Addict. Thank you, Karen. Appreciate you being here. Kath says, apologies. Haven't seen the video. Did they know it was recording? Was it a neighbor's device? It was his device. It was Larry's device, and he actually had cameras on multiple sides of the house that captured multiple events, all on the outside. Thankfully, I'd hate to see some of those hours of video on the inside, but it was his own security system that captured it. Let's see. Gaily May just gifted another membership. That one went to Ed Geen. Ed, congratulations. Appreciate you, Gaily May. Thanks for your generosity. No one has better hair than Ivan, says Ivan. Okay. He does rock a mullet better than I think I could, for sure. Jim Bob says, being native, let's just say my hair is very sought after. It's beautiful. Luscious, I'm sure. If the jury comes back with both guilty verdicts, will the judge sentence them after or schedule another day? Candace, this has to do with mostly it has to do with minimum mandatory sentencing. If the charge that they're convicted of and found guilty of carries a minimum mandatory that is also the maximum, and for that you would basically get life in prison without parole. If that is the minimum mandatory, then there's no need for a pre-sentence investigation to delay this, a month or 2 months even down the road to have the sentencing. And if that's the case, then we'll have sentencing same day, and it will be decided, and they'll be done, one and done, and out the door. Sandy Cosner, welcome to the gallery. Thank you so much for becoming a member. I appreciate that. Looks great to have that blue courthouse by your name. Wonderful to have you here. Make sure you take a seat, ! Seat, and you get reserved seating as a member as well. Help yourself to the emojis. Sharon, a lot of people are asking this. I don't know the name of Larry's lawyer. I've sort of been skipping the names in this trial, mostly because I can't say Rita's last name. It's a huge, long one that I just stumble over every time. And I don't feel bad because Judge Newman himself is not saying the lawyers' names. And he's just over it. He's like, I'm not going to invest the time to learn your names. It's going to be a quick trial. You're just going to be Rita's lawyer and Larry's lawyer to me. So there it is. Pangalangan. That's my best bet. Yes, the family is on social media. We're not going to post that here, but they're on there. You're used to me with facial hair. It's going to go eventually. It can't be there forever. I'm going to eventually buy a diving mask so I can scuba dive and metal detect underwater. And the diving mask and facial hair mean that the water just goes in the mask. So we can't have that. KKD says, I have 7 cameras on my house, 3 front, 2 driveway and garage, and 1 each on east and south to watch the deer. You've got full coverage. You've got views everywhere. And all you need is a live stream that you can live stream deer every time they show up. Can I ask a question, says Teresa Farmer? Is there a story behind your name, Recovery Addict? There is a story behind my name. Thank you for asking. Teresa, I chose the name Recovery Addict initially because I was addicted to recovering artifacts from the ground. I'm a metal detectorist. I'm not a metal detector. That's actually the device that detects the metal. So I think it's a metal detectorist. And I love searching for history. I love looking for lost coins, lost rings, just little bits and bobs that tell the story of what happened in an area where people, haven't been for generations. I also have my own story of addiction involving addiction to electronic gaming, computer gaming, and so I chose the Recovery Addict name, and I started using the channel that I was initially doing metal detecting videos on to live stream, and the name is sort of stuck. And so we've kept it, and I like it. Like my goatee, it sort of grew on me. It's a mystery. Nobody knows. Nobody knows. All right, I think we've actually probably talked most of the way through lunch. Oh, my phone is beeping. Hang on. What am I missing? Okay. Pangalangan. Thank you, Holly. You know how bad I am at pronouncing names that aren't just easy, cut and dry, simple to pronounce names. I was calling Lois Cox Lewis for like 6 months. Are you allowed to go into a courtroom as a guy from the prees and film anything? Oh, from the press and film anything? Jimmy, yes and no. Every courtroom, the judge generally has his say over what happens in the courtroom. And so they have their own set of rules, and it might be for the district or the type of court, or in the state that has their own rules. For instance, in Wichita, Kansas, or Wichita Falls, Texas, we were trying to follow a case there. And they have rules that say, yes, media is allowed in. We have an open courtroom. You're just not allowed to bring a recorder, like a camera or a tape recorder, and you're allowed to scribble all the notes you want while you're here. And sometimes they might allow a still photographer. So that's pretty restrictive. In North Carolina, we had a case where we were trying to follow a case where a corrections officer was driving the corrections vehicle, like a truck, from the jail or from the prison, and struck and killed a kid on the road. And he got out. The kid was walking with his parents. He got out to stop. He's like, "Oh no, I hit your kid." The dad pulls a gun, shoots the corrections officer, and then the mom and the dad get in the corrections officer's truck and drive away and steal the truck, leaving their son and the dead corrections officer on the road. We were trying to follow that case, and it's here in North Carolina where legally, I can make a request and say, hey, I'd like to go in the courtroom, and the judge said no, or I'm going to shut down the courtroom. And she can. She has that power to do that. Other places, for example, in Bexar County in Texas, it's completely different. They have a fully open courtroom. They're like, the courtroom's open. Bring whatever cameras you want. Film everything. Just don't show the jury, and don't zoom in on the defendant's notes that he's handing to his lawyer. Just the basics. So every court's a little different. Some of them, like Orange County in Florida, require you to go through an approval process to be deemed, where they decide if you're press or not. And they have this standard that is strongly biased towards more traditional press outlets or formats. But yes, Wichita Falls, great example. Yeah. Okay, I think we're about done with lunch. Are we close? Poll, yes, they will. Why shut the courtroom? It is what it is. That sounds like a judge doesn't want what they do to be seen. Gallie Mae, in the North Carolina case, did a little research on the judge, and it turns out that not too long ago, she was in a court case where the defendant was asking for a new lawyer because his lawyer was not working with him properly the way he wanted. And she said, no, you get this lawyer or you're on your own. And his lawyer said, I'd like to withdraw. She said, granted, you're on your own, which is I think probably not the right process to do that. He did not ask to be pro se. So he tries to defend himself on his own, talks to one witness on his own, and then a police officer is the next witness, and he's like, look, I need legal counsel. I can't do this on my own. And she starts yelling at him, and he's arguing back, and she says, shut up. He says, no, you shut up. And then he goes to throw a chair, and that was probably the wrong move. In hindsight, the one bailiff in the court tries to wrestle with him. Defendant goes for the gun. The bailiff is yelling, he's got my gun, he's got my gun. The witness on the stand, who was an off-duty police officer, ends up pulling his gun and shooting the defendant in the head and killing him in the courtroom. So this all happened in the judge's, this happened in North Carolina a couple of years ago in the courtroom, the same one I was trying to get into where the corrections officer, got killed and they stole his truck. So that's probably why she doesn't like press very much, but we can still request audio from that. Kath says, how's it going on getting the tapes from the Florida case, wife murdered husband case we partly watched? We have still not got a response, and they sort of reserve the right to take up to 60 days on that. And so all we know is that I've submitted it, and we're waiting. Look at this. Jackie Ferreira does some homework for us. Larry's lawyer is Gil Gatch. Gil Gatch. Already had fun with my name for 3 months as well. I still have to, not Jaco, Yaku. It's Yaku. I've been calling him Yaku for a long time, and he says it's right. Anyway, so yeah, there was a lot of fun things going on in different cases. Anyway, the question that brought that up is basically, does the media have access or the right to go in? And the media does have some rights. And the court has to balance that between the rights of the defendant to have a fair trial, the right for the defendants to have an unbiased jury, the protections that the court owes to victims, especially child victims, in various cases. And so they juggle this a little bit. And usually we hope they err on the side that gives us access. Beep, 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 beep. It's Taco with a J, buffer. Amber, I think I'm right here with the yay sound. Yaku. It's Jaco. No. Tell me I'm saying it right. I thought it was like Yahoo. Yaku. I'm still having fun with your name. Sorry. It's not fun anymore. I keep getting it wrong. Jaco. Yako. I think it's Yaku. I'm sticking to my guns here because I thought there was one time that I had it confirmed. You're going to have to call in and pronounce it. Call in and pronounce it. Taco with a J, but sounds like a Y. Yako. Yako instead of Yaku. Yako, not Yaku. We're going to have to enter a motion for a legal name change for you. That's all I can do. I cannot pronounce a simple 4-letter word, apparently. RA equals cuckoo. Cuckoo, okay. Thank you, Thomas. Oh, man. Looking forward to the podcast tonight, by the way, Thomas. I'm super excited. Let me know how I can help a little bit more. Amber concurs. We're good. I think we've got people coming back into the courtroom. I've seen a little bit of motion. You can see the camera shaking. I think we're about ready to start. Let's see. Turn the audio on. Let's see. He just told you, look up. Let's see where. Look at this. RA, you have it right. Don't lose it.
Is it Yako, really?
He says it is Ya for Yahoo and Ku for cookies. Yaku. Vindication. Justice. Bring the jury. We have a verdict. No, just kidding. Ivan says, I can pronounce 4-letter words. Those are the ones we can't play on the air, though. Cuckoo Kachoo. Thank you, Ritz. Evidently, Christina's father was arrested on August 21st for back child support of $155,000. That's more than a month of child support, I think. That's an extended period. The telltale camera shake. It's the cameraman walking up to the tripod. Gonna crank the volume here. Yeah, that's a lot of money. That's a ton of money. In fact, that's neglectful, I think. Yeah, if he's Bill Gates, it might be 1 month of child support. Rosie, I think I called you Rozzy for a while as well. I had trouble with your name. Once again, 4 letters, and I just can't get it right. Andriel Hillis? Is that spelled right? Was that Andriel Hillis? Is it Andriel? Sorry, we're not going to go down this road. The jury's coming back in. We're going to listen to closing arguments.
Mr. Phillips.
Please talk into the mic. Please, please, please.
As a parent,
nope.
This case is hard for me. I have 3 little children, and I know it's hard for you. I said it in opening. The raw emotion that you feel, I'll be candid. I'll put my cards on the table. It's anger. I can't watch the video and not yell, please break the window. It's anger. I have to be candid with it. And I know you feel the same. I told you that in opening. I'm not running from it. This case is what it is. There's the video. But
welcome to all the uncivilians. Thank you, Kurt. Good to have you guys here.
What we have, the evidence, and the video itself, this case is a lot of it. But it's not murder. When you separate that, my job is much easier than yours. I'm an advocate. Your job is harder. You've taken a sworn oath before God to separate that. And that's hard. That's not something normal people have to do. You have to separate emotion. You'll hear from the judge and instruct you on the law that passion, prejudice, hatred, any of that stuff that comes up in this trial, those raw emotions, you have to set that aside. And you have to base your verdict solely on the evidence that's presented on that witness stand and admitted through everything that we see. But when we do that, it's not murder. It's a lot of things, but it's not murder. You swore to give her a fair trial and not base your decision on emotion. Now, I give you every right, because it's natural, it's human nature. In this courtroom right here, You can be as angry as you want, Rita. You can be angry. You can have those natural feelings. 'Cause we all know it's natural. However, and I can't stress this enough, when you cross the threshold of that door and walk in that jury room, you have a sworn oath that you are separating yourself from that. Your job is hard. But you took that oath, and you have an incredible responsibility. That when you cross that threshold, you have to separate that and apply just the law. And again, I'm not saying it's easy. It's not easy for me. But we've all seen it. And in this case, the government's done a lot of different things, and we'll touch on that. But I just can't stress it enough. I have to say it again. Be angry now. Have that emotion. But you can't let it cross that threshold and go into that jury room. You swore not to do that. And if somebody in that jury room starts talking about that kind of stuff, or starts talking about TVs and all this other stuff that's improper, I empower each of you to come tell the judge, because that is not what's supposed to happen. That is not the law.
No jury instructions yet.
We're going to follow the law in this courthouse. And it's not easy. It's not easy. But that is the law, and that is your sworn duty. Now, depraved heart murder, this malice, this extreme reckless disregard for human life. The government has went painstakingly to say, well, that's easy. Well, let's walk through that. Today, I showed you on this Defense Exhibit 15 that's been admitted, they put an officer on that stand the first day. He was unequivocal that the lights won't flash if that car's running. Turns out he was there and it can flash. And he can come up with any explanation he wants. But the facts are the facts, and the video's the video, just like the video you gotta watch. It's tough. And they gotta own this video just like we gotta own that video. They can't run from it. And I want you, if you have any questions about it, watch it for yourself. It's short, and it shows what he said, and what was unequivocal, and what they would have argued if I didn't do that. They would have said there's no way that car was running. And then you hear for the first time today from him that the car was running when he got there. You didn't hear that from Miss Godley, that first witness. You didn't hear that from him until now when he's backtracking. Why? They want that murder conviction so bad. They got the cameras. This is their spotlight. They're going to make the news. They're going to send a message, right? That's not your job. Your job's not to get caught in that. You leave that anger in this courtroom, and you decide this case on the law. In that. Now, we see Rita go to the car at, they said 12:15, I think it's 12:29. But again, you have all the time in the world, and it's your show once you get the case. You can watch the video as many times as you want. You can go through any parts. I empower you. Any not sure what somebody said, Madam Court Reporter can pull it up for you. We're not running from the facts of this case. They are what they are.
These are the concessions I said he'd be giving.
And there's only 3 scenarios. And they intentionally, I think, left this out, and I'll just say it. They said, well, she opens both doors. Right before that, again, what does she do? She comes out, she opens the front door. She sits in that car. And we know she sits in the front door for a period of time because the camera skips. That means there wasn't motion. So we know she sat in the front seat of the car. There's only 3 scenarios. She sat in the front seat for a period of time, and the car wasn't running, and she left it that way. I submit to you, that's a depraved heart murder. If they both believed that car wasn't running and the air conditioning wasn't on, they're right. That's depraved heart. But the solicitor conceded that they might have believed that the air conditioning was running. But we also got testimony today that the car was running. She didn't hear the day before. That's strange. They then tried to flip it that Larry turned it off, or turned the car on right beforehand. We heard this extra testimony from Officer Chapman. But again, you watch the video, anybody that knows the push button start a car, you got to push in the brake to cut the car engine on. Guess what he doesn't do? He doesn't sit in that car and push it. He leans in and hits the button. Why would they do that? Also says, Rita doesn't know they have a surveillance camera. Their own evidence shows that in his bedroom, where they say right is what they contend, there's the surveillance camera videos. This is their evidence. This is what they brought. And he's switching it up in closing, saying she doesn't know anything about it. Also their evidence. The surveillance camera itself, sitting right behind the swing. Rita doesn't know there's a surveillance camera. That's the solicitor's words. He's going to have to own this. They want this conviction back. They want you to use emotion. They want you to be angry. That's not what you're going to do. I know you're not. We chose you all for a reason. Because you swore to do that and follow the law.
Who played that? Greeners?
Facts are the facts. They can't run from them. They try to show this gun. Where's that picture of the gun? The gun had nothing to do with this case. If they truly believed it was a murder based on the facts they presented, why are they trying to show some gun? It shows the weakness of their case. They're just trying to inflame you and get you more angry. What's the purpose of the gun? Now, my position is this. They knew they had a problem, and 3 years later they did the infliction of great bodily injury because they knew they had a problem with proven murder. Why else add that charge? This case is a lot of things, but it's not murder. They knew that, and that's why they added that indictment. Now, you'll hear that reasonable doubt is kind of defined in two ways. That you're firmly convinced of something, or it's something that causes you a hesitation to act. And that's important, because I like to describe, defense lawyers have a hard time trying to always come up with a way to describe legal definitions. But this is how I like to do reasonable doubt. I say you consider it a voting booth. Very similar to going back to a jury room. You got to make a decision. You got two options, non-guilty and guilty. Under the law, Rita is presumed innocent. That not guilty button is already pushed. Now the state has to prove beyond a reasonable doubt of all the elements, malice, this depraved heart, based on the evidence, that you don't have any hesitation to hit that guilty button. If you have any hesitation, you'll hear the judge himself tell you, if you have any hesitation, that's a reasonable doubt in the law. She's not guilty of murder. If you're firmly convinced, no hesitation, you're 100% sold, there's no doubt that they thought that car was running an AC, that's a brave heart. We own that. Anybody that do that, it's on its face. Now, you're entitled to your own opinion. Don't be swayed necessarily by other jurors. You're entitled to your own opinion. The law gives each one of you your own voice. Don't let other jurors bully you into a position that you don't feel comfortable with. Stand firm. And I'm not saying one way or the other, but you stand firm in your convicted beliefs. That is what the law requires, and that's what you should do. Again, you're a chosen jury. It's not random. You came here, that was random. But each one of you was chosen. I used 10 strikes, I think. They used 8 strikes. We chose you for a reason. We chose you because you knew that you could be fair and impartial, that you would follow the law. It's an incredible responsibility that you have. It's not random. Each one of you were chosen for a reason.
Whoa. What's going on here? I've never seen this.
We've been sitting over there in the corner. I had to bring her right here in front of me to look you in the eye. You heard from her daughter that she's a loving mother, that she was there for her family, that all this other stuff about dirty house and food, all this stuff that they try to say is the murder from that video, they threw in all this other stuff. Bed bugs, dirty house. Her daughter, the one that's there, the one that's a teacher, the one that's part of the pastoral part ever, married to a pastor, all the people here in attendance, saying exactly what you needed to hear, right, that the lady that you saw how she acted, that she didn't pay rent, that she brought her boyfriend and kids in there and was dirty and messed up the house and she got kicked out. She had an axe to grind. But why present all that if this case isn't what it was supposed to be? The murders on video is what they're trying to say. They're trying to say it's so open and shut. And why are they adding all this other stuff in there? This is real. This is no high school debate. This is no round table discussion. This is this woman's life, this woman's freedom. And I'm not saying that she did everything right, because God knows, I already said she didn't. And you can be angry in here at Rita, but you can't do it in there.
My concern is she did not testify, and this is sort of like her testifying. I realize I don't know. Never seen that before. I mean, yes, with Alex, but he testified
as I said,
in
an
defense.
incredible responsibility, one that almost nobody has. You heard the judge tell you out of all the United States and the state of South Carolina, you were chosen. There's only 3 people I know that can judge another person. That awesome power of judging a person. That's you as jurors, the judge with the black robe, and the man upstairs. You have been given just an opportunity in your life, one that's the most difficult decision in your life. I understand. We put you in a tough place. But it is an incredible responsibility. You're sitting in judgment of another person. There are no do-overs. You wake up tomorrow, you have your breakfast or your coffee, you think, did I make the right decision?
He's trying to guilt them into not
There are no do-overs. You
convicting
can't
them.
wake up 10 years from now, 30 years from now, 50 years from now, wondering, did I make the right decision? There are no do-overs. If you have doubts, you have them now. You have them in that room. You be confident in your verdict. If you have any hesitation about hitting that guilty button, that's reasonable doubt. And that is not what you're supposed to do. Any hesitation, firmly convinced, depraved heart, that they had no belief that they put those kids in that car with that Christine in that car with that air rope. No belief. They firmly convinced it was depraved heart. You got to be sold on that. I'll just end on this. There are no words. There are no excuses. Just the law and your sworn oath to find her not guilty of murder. They gave you the answer 3 years afterwards. Tell them what the answer is. Thank you.
Wow.
Mr. Stone.
Thank you, sir.
Is he going to drag her back up again and say, Rita, come back up here? Let me tell you what she did. Wow. Now, everyone just ignores this microphone. I wish they chain them to the podium. I'll do what I can for audio. At least he was loud on the last one here.
The defense wants you to believe that because they didn't get together and say, let's kill Christina, there's no malice. Unfortunately, that's not the law. That's not what the law is. That's not what the judge is going to tell you. The judge is going to tell you this. That malice can be inferred from conduct so reckless in one as to indicate a depravity of mind and a general disregard for human life. And renewed objection. It's not going to stay the law.
Renewed objection.
Objection's overruled.
Thank you, Your Honor. It's not going to be the malice that they're trying to say has to exist. They got together and said, let's kill Christina. The bottom of this, malice does not require ill will toward the individual. What does it require? Actions and conduct so reckless as to show a disregard for human life. So the question you have here is, what did they do to show a disregard for human life? And the answer is everything. Everything. You want to know what's relevant about the loaded gun in the back seat? That's a disregard for human life. defense attorney got up here and said, everybody in South Carolina knows you put a child in a car that's in direct sunlight in August and you leave them there, they're going to die. Right. That is a disregard for human life. In fact, it would be actually better and easier if you went through and tried to find a sign at which time they actually showed you some regard for that child's human life. But you won't find it because it's not there. It's not there. Larry's defense attorney came up here and basically said this. Well, just like the solicitor said, he may have thought the air conditioner was on. Right. Because he was high. Because he was high. I don't know what he was thinking. I think if any of us watch this video, the one question that has to pop in your mind over and over and over again, what are you thinking? What are you doing? You put this child in the car, and you know nobody's been in the car, you know it's not on, there's no air conditioning, you're in the middle of summer, you're in South Carolina, everybody knows you're not supposed to. What are you doing? What are you thinking when you find the child locked in the car at 3 o'clock that afternoon? 4 hours later. Let's don't break the window, let's go find another kid. What are you doing on the swings? What are you doing when you're going inside and having sex and the child is still out in the park cooking? What are you doing? And there's no answer to that. You know why? They're high. And what the judge is also going to tell you is that voluntary intoxication, voluntary use of drugs is not a defense in South Carolina to anything. To anything. If they're high and they think the air conditioning's on, so what? They're high. And by the way, the disregard for the safety of others, the disregard for human life, I'm getting high to begin with. You go in to get your child, you continue to get high. You put the quick kid in the car while you're high. You can't find a single thing in this anywhere that shows that they care 1 ounce about that child. Did I say at the very beginning that that child was baggage? The child was baggage on that day. Did some witnesses take the witness stand and say, she's been a good mother in the past? But none of them knew about her nephews. None of them knew how she acted when she was high on Beth or Larry. None of them did. They didn't lie to you, they should know. And they said they didn't know. And Larry says, okay, I got another defense. Not my child. Never mind, he put the child in the car himself. He wants a pass because it's not his child. He's not responsible for the child. Because he doesn't have any regard for human life. Her child or anybody else's. Supposedly, if I saw something going on with a child, I'd do something about it, would you? What about 3 o'clock in the afternoon? The child's locked in the car. Break the window. That's Larry. What about me? They gave me a big deal about Brittany Honeycutt. What did Brittany Honeycutt tell you? She said, take this child with you. Please take this child with you. I got to go to work. I can't take the child with me. Take her to work, put her in the car, leave her there. That's what I do. I do it all the time. They said, well, Brittany Honeycutt didn't like her very much, and she didn't like Brittany. Okay, fine. Let's go to Lindsay Lewis, the babysitter. The same babysitter that Rita abandons her child with 3 days before this takes place. The babysitter who'd never taken care of the child before. The babysitter who didn't even know that if the child ate solid food, that there was a choking hazard because Rita never told her. The same babysitter who came in and testified there wasn't any food in the house, and she just left. And all Saturday I tried to call her and she didn't respond. You know why she didn't respond? Because she was getting high with Larry. Her focus was on Larry. Her focus was on getting high with Larry. Not anything to do with this child. She didn't respond then. She didn't respond before. She didn't respond to this entire event. Not to that child. All of her concern is Larry. She abandons the child with the babysitter. Then she turns around and puts the child in the car. They don't forget it. Just like I said in my opening statement. They didn't forget her. They stood around the car until they went inside and had sex. Where was the child in the car? Abandoned the child again. Yeah, I own the fact that I said baggage. It's exactly how they're treating that child. Baggage. In the way. Because she needed to be with Larry. She abandoned the child in. And the child's locked in the car. Does she stay with the child? No. She and Larry go and hug and kiss in the car in the truck and they take off. It's abandoned the child again. And one more thing and I'll sit down. Mr. Phillips spoke an excellent point. He said he's a parent. Lots of his parents. Would you find that her child is dead? I'm a parent. Imagine finding my child dead.
Objection, Your Honor.
Just like this
Objection is
speculation is improper. It's not in evidence.
the objection is overruled.
Thank you. And imagine. Most parents, they find their child dead. They're not going to be inside the house when the police get there. In fact, the police are going to have to pry the parent off of that child. And if the police don't have to do it, the coroner's going to have to do it. The coroner's going to have to do it. The funeral director's going to have to do it. Because the parent is going to stay with that child. That child is dead. The child is part of them. They're never going to leave that child. Even if the child is dead. And what did she do? She went inside. She abandoned the child again. Maybe at some point in her life, and maybe on other days, she would have done that. But on August 5th, 2019, two people finally murdered that child. On this day, they tortured that child to death.
Powerful close. We now proceed to jury instructions.
Now, for lady
Yes, sir.
and members of the jury, you've heard the testimony, received the evidence, and heard the arguments of the state and the defendants. I will now explain to you the law that applies to this case. Under the Constitution and laws of the state of South Carolina, you are the finders of the facts. I do not have the right to pass on the facts or to express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, the weight, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, to rule upon the admissibility of the evidence offered during the trial. You are to consider only the testimony from this witness stand, together with any exhibits which have been made a part of the record. I have the additional duty to charge you the law applicable, and as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now stated to you, then deliberate in an effort to reach a verdict. I charge you in that regard that you should not be concerned with what you think the law ought to be, but what I tell you that the law is. Now, you are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who've testified and of the evidence offered during the trial. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony of a witness was contradicted on the one hand or supported and corroborated on the other hand, you may believe a small portion of a witness's testimony and disregard the larger, or vice versa. These things you will consider, bearing in mind that you should give each defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or the value to be given either direct evidence or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray a defendant's behavior as suspicious, the proof has failed. The state has the burden of proving each defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Now, the rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists for witnesses who are called expert witnesses. An expert witness is a witness who, by education, experience, has become an expert in some field. And that witness may state an opinion to relevant and material matter within their expertise. And they may also state the reasons for their opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight that you think it deserves. If you decide that an opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion even though it is not contradicted. Now, I instruct you and emphasize that the fact that a defendant did not testify is not a factor to be considered by you in any way in your deliberations and in your consideration on the question of the guilt or innocence of a defendant. It must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. So I repeat, under your oath, you are to draw no conclusions whatsoever from the fact that a defendant did not testify. The fact that a defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated, is on the state. The defendant is not required to prove him or her innocent. The burden remains on the state to prove guilt beyond a reasonable doubt. Now, the fact that the defendants were arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt. Nor does an indictment create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendants. The indictments are the formal documents by which this case is brought into this court. Each defendant has pled not guilty to the charges in the indictments. And those pleas put the burden on the state to prove the defendant or defendants guilty. A person charged with committing a criminal offense in the state of South Carolina is never required to prove himself or herself innocent. I charge you that it is an important rule of the law that a defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies each defendant throughout the trial until you reach a verdict of guilt, satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of a defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you are satisfied from the evidence of proof beyond a reasonable doubt. The state has the burden of establishing every fact necessary to prove each defendant guilty beyond a reasonable doubt, because the law presumes every defendant charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. So what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt, therefore, is proof that leaves you firmly convinced of the guilt of a defendant. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are convinced that a defendant is guilty, then you must find him or her guilty. If, on the other hand, you think that there is a reasonable possibility, a real possibility, that either or both of the defendants are not guilty, then you must give each of them the benefit of the doubt and find him or her not guilty. The indictments in this case allege 3 separate offenses against each defendant. The indictments are murder of Christina Panalengan, great bodily injury on a child, and criminal conspiracy. Each indictment charges a separate and distinct offense as to each defendant. You must decide each indictment separately on the law and the evidence applicable to it, uninfluenced by your decision as to any other indictment. Each defendant may be convicted or acquitted on any or all of the offenses charged, and you will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant Rita Panalengan and the defendant Larry Eugene King are charged with the murder of Christina Panalengan. The state must prove beyond a reasonable doubt that the defendant or defendants killed Christina Panalengan with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant or defendants just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which expresses hatred or ill will for another, or when the person prepared beforehand to do the act which was later committed. Malice may be inferred from conduct showing a total disregard for human life. Malice may be inferred from conduct that is so extremely reckless and wanton as to indicate a depravity of mind and general disregard for human life.
If anything,
in
that's
the context of murder, malice does not require ill will toward the individual injured, but rather it signifies a general malignant, extreme recklessness of the lives and safety of others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. As to the charge of great bodily injury on a child, the state must prove beyond a reasonable doubt that the defendant or defendants inflicted great bodily injury on a child. Great bodily injury means bodily injury which creates a substantial risk of death or which causes serious injury or permanent disfigurement. or protracted loss or impairment of a bodily function, member, or organ. As to criminal conspiracy, the state must prove beyond a reasonable doubt that the defendants combined together for the purpose of accomplishing a criminal or unlawful object, or an object neither criminal nor unlawful, by criminal or unlawful means, to establish the existence of a conspiracy. Proof of an express agreement is not necessary, and direct evidence is not essential, but the conspiracy may be sufficiently shown by circumstantial evidence and the conduct of the parties. Now, in order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, extreme recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. And criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says criminal intent may be shown from circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established in the same way as any other fact by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant or defendants intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or failure to act. It may arise from negligence, extreme recklessness, or an indifference to duty or to consequences that is considered by the law to be an equivalent to criminal intent. Voluntary intoxication or use of drugs does not constitute a defense to a crime, but proof of mere presence at the scene of a crime is not sufficient to find someone guilty. However, the law also says that the hand of one is the hand of all. If a crime is committed by two or more persons who are acting together in the commission of a crime, then the act of one is the act of both. When a person does an act in the presence of and with the assistance of another, the act is done by both. As indicated, mere suspicion, however strong, is not sufficient to sustain a conviction. Suspicion implies a belief or opinion as to guilt based on facts and circumstances which do not amount to proof. Now, while the arguments of counsel are a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting their arguments, counsel often refer to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. And Madam Forelady and members of the jury, I'm required to charge you the law as I've done through giving you these instructions. And that's to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I've instructed you on various subjects must not be considered as indicating an opinion that I have as to what you should find to be the facts or what your verdict should be. Now, you've been chosen and sworn to give the parties a fair and impartial trial. When you've done so, you will have complied with your oath, and no one will have a right to criticize your verdict. You must not be influenced by opinions or expressions of opinions you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after an impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and to change your opinion if you become convinced that it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. And Madam Forelady, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with me, please reduce your message or question to writing, signed by your foreperson and the foreperson only. Then pass the note to the bailiff, who will bring it to my attention. I will then respond as promptly as possible, either in writing or to have you return to the courtroom. However, I caution you, with regard to any message or question, that you should never state or specify your numerical division at the time. You've heard the evidence, and now you have heard the law. Whatever your verdict, Madam Forelady, you will indicate the verdict on the verdict form. And we have two verdict forms, one for Panalangan and one for King. And as to each charge, the verdict is either not guilty or guilty, you would check the appropriate box, then sign it at the end.
Is he not going to read them? He's not reading the verdict forms?
Now remember that although only the foreperson writes the verdict, it is not hers alone. The verdict has to be unanimous. And Madam Forelady, you're not authorized to write the verdict until all of you have to have agreed on the verdict. So ladies and gentlemen, I'm going to send you to the jury room to start deliberating in a moment. But when you get there, don't begin deliberations until you've received a copy, until you've received the copy of the verdict forms and the exhibits. And once you receive these things, that will be your signal to begin your deliberations. Once you begin your deliberations, you will deliberate until you have reached a verdict, at which time you'll knock on the door, advise the bailiffs, and we will bring you out to receive your verdict. Now, we've selected 14 people to serve on jury duty. First 12 regular jurors and then 2 alternates. Before asking any question about whether you can continue with deliberations, I want to inquire of the jury whether anyone has made an effort to contact you about the case, or whether you've viewed any media.
If you've been in chat, you have to own up to it now.
Then otherwise to expose any other information about this case other than what you received in the courtroom. If you've seen or heard anything else outside of the courtroom or been contacted by anyone concerning the case, if so, raise your hands. And no hands are raised. Now, if we have 2 alternates, 2 very capable alternates over there, if for any reason any of the first 12 of you selected cannot continue with deliberations, please raise your hands. So all the first 12 jurors are good to go, which means that the 2 alternates will not be able to participate in the deliberations, and when they go to the jury, if you all will hold your position right there. So I'm going to send you to the jury room now and wait for the verdict form and the exhibits, and that will be your signal to begin your deliberations. So please go to the jury room.
Okay, so I'm going to start the verdict watch now, even though they are waiting for the forms. We probably won't see exactly when the forms get hand delivered to the jury. So as soon as they're out of the room, we're gonna start the timer here. Apparently, we're all alternates. None of us get to go back there. All right, the clock has started. Okay, I want to talk about this, but we're going to give them a minute because they're going to do a little bit of business right here. So let's listen.
Will they close the door? Is that door closed?
Oh, it's closed. It's closed and locked.
Are there any additions or exceptions to the charge?
No, sir, none from the state. None, thank you. None from the charge, Your Honor. Whenever the appropriate time is, at the matter of law, hearing, closing, you can put that on.
All right. So if you all then can review the exhibits that's going back to the jury, along with, we're going to pass up the verdict form to them as well.
They're going to decide what evidence goes back to the jury.
Send the indictments back or just the jury?
No.
Indictments still go back. Basically, the video's going. You know, the defense for Rita is going to make sure that little video clip that he probably cut from like Law and Crime or Court TV or something of the officer saying, "End of story. You can't make the lights flash with the fob." He wants that to go back there because that's like his This is his big win. He's not going to get it, though. I mean, it'll go back to the
While
jury. They're not going to watch that.
These exhibits for submission to the jury room, I'm going to discharge alternates now. I don't know if you have to take that.
Alternates going to get discharged right now. Sometimes they get outed right here as well.
I'm sorry, did you say yes? Yes, yeah, maybe so. Yes. Okay. Let's let the alternates go, then get back to that. To the two alternates, thank you all very much for your efforts during this trial. Whenever people appear for jury duty, they're quite often hesitant and hopeful that they don't get picked. But almost everyone who gets selected to be on the jury, by the end of the trial and during the course of the trial, they become heavily invested in the trial and they want to see it through to its conclusion. So I've noticed you all being very attentive and very good jurors. But the luck of the draw, the first 12 selected are those folks, and you all were standing in the wings ready to join the jury if you needed to. So we're going to release you from jury duty now. I would suggest that you not discuss what you think the verdict should be until you hear from the jury as to what the verdict is, at which time you're willing to, you can talk to anyone that you might want to.
This is weird because they're getting released, but he sort of wants to keep them on reserve.
And I want to thank you on behalf of all the parties and your other fellow citizens of Colleton County. And so you're excused, Madam Clerk. Any other comments for the jurors?
Grab your dozen eggs and go home. That's what he said.
Okay. You normally tell them that you're going to send them a check or all right, I've got you.
At least validate the parking.
You don't explain the checks anymore.
Okay, so about 80% of us think that we're going to get a verdict today, according to our poll. About 84%. We are sitting at about 2:30. That's what he just said as well. We're sitting at 2:30, so we're going to watch this a little bit. I'll keep the audio on and listen, but we are in verdict watch. Let's see, camera 2 is going to be 4 here. Oops. The part I wanted to talk about briefly, I put on the screen just for a minute, and maybe here. There we go. Okay, I want to put it on the screen just for a minute. During the defense for Rita, the lawyer, first of all, we knew that he was going to just talk about the law and try to use his whole defense is the jury instructions. Really, that's where he put all his cards, and so he talked about that whole ton. But he brought up the defendant and said, "Come on up here," and wanted to present something. He wanted to present the defendant to the jurors. And for some reason, it struck me as wrong, okay? Because this defendant has the right to testify in trial, to present her story to evidence in whatever way she wants to do it, whether it's through, her emotion or something else. She can do that from the stand, but she opted not to. And then during this closing, which is not evidence, they brought her up and they got to present that in a way that they could not be cross-examined. It just seems like it's like an end run to try to make her look really, really human, look, frail, weak, sorrowful, and whatever else. They wanted to bring that around and to have the jury see that without having her be cross-examined. And I was surprised there wasn't an objection. Quite honestly, it was surprising. Okay, we're trying to get. Let's see. Yes, my studio's a mess, unfortunately. I'll try to cover up parts of the cables that are on the floor with my face. Aski Yishka says, awesome studio. Thank you very much. It's a lot of fun. Holiday weekend, odds are pretty solid for a verdict today. I believe you're right. The holiday weekend, everybody has plans. And I don't think the jury would be rushing this either. This is not a case that has 3 months worth of testimony and expert witnesses to go through. It seems pretty cut and dry. So much so that there are some parts of the the charge, specifically conspiracy, the state didn't even call any witnesses for it. They just played a video and said, look, it's obvious, it's cut and dry. We can leave it at that. It speaks for itself. So I think the state thinks it's it's an open and shut case, and the jury might be able to just vote right now and be done. Let's see. We have, what's the holiday? The holiday is Labor Day. Labor Day on Monday, so it's a long weekend. Where's the eyebrows? I have Brandy's juror or the verdict eyebrows here. That adhesive, but the adhesive is gone. I don't know if it just dried out or what. I would need to either hot glue them or super glue them to my head, which I'm not a big fan of because removal then becomes an issue. I can't put these on in the mirror. It's impossible. It's like I can't look at my face flipped and do that properly. So no verdict eyebrows for this. No eyebrows. They creep me out, so it's getting me. We do have a 3-day weekend coming. Court is just showing us that. We don't have any audio, so we'll just keep an eye on that. And actually, I'm going to keep an eye on probably on Twitter to see if anybody locally can get a little buzz from the courtroom before we do. All right. 3-day weekend. Yes, let me take a little break to tell you a little bit about my 3-day weekend. Monday, since we do not have court. Whoa.
I wouldn't be able to put up with that myself, Judge. So
you can imagine.
No, sir, I can't.
45 minutes.
We went.
We're off the
We went through everything on Wednesday.
Yeah, right. If you can believe it, they've listened to the case for an entire week and then got the instruction, and then they go back
and wait for
45 minutes while everyone is going through page by page all these exhibits.
We had a really bad one on the
Really?
Yeah. The judge is upset about something. I think he's saying that they have to wait. The jury's waiting for 45 minutes for them to decide what evidence goes back there. They can't deliberate until they get the evidence and the juror forms or the verdict forms and the instructions. Carol, you're skipping a step. Sentencing may be, well, it depends. If there is a minimum mandatory sentence that is also the maximum, then sentencing is usually immediate because there's nothing to do a pre-sentencing investigation about. But if the sentence has a range of possible sentences, that's usually where you get the PSI ordered, and sometimes it can be a couple weeks, and sometimes it can go as far as 2 months out, depending on the court schedule. So we're going to have to wait to see what the verdict is first of all, and then we'll go from there. The judge will tell us what the sentencing schedule is. How can they not be ready? This is actually a normal part of the trial, Jenny. Sometimes we'll see some of this discussion or this little court work completed before everything's done. They might gear up for it and get a lot of the work done ahead of time. But basically, the lawyers have to confer and say, this is what we agree should go back with the jury. And sometimes they'll say none of it. Right? I don't want anything going back there. Make them ask for every single piece, and then we'll talk it over. We'll discuss it amongst ourselves and decide if we get to send it back or not. And sometimes they'll say send everything, and so oftentimes they'll say, well, you can don't send the murder weapon and the ammunition. Okay, don't send those back there. Only let them have one or the other, but don't put the two together. But so the two sides are going to view this. They're probably. Let's see, I don't know what their rule is as far as exhibits and what was admitted as evidence. That's usually a point of contention where one side has a poster that they're like, we want this, the how much meth was in their system, the blood test. Let's put the verdict clock back on here. Just 1 second. Camera 2, camera 1 is going to be 2. Nope. Camera 1 is going to be 6. Camera 2 is going to be 2. There we go. Okay, there's our verdict clock. Anyway, the demonstratives usually don't go back. unless they've been admitted as evidence, and usually that doesn't happen. But so they're going to argue back and forth what they should get and what they shouldn't get. Obviously, if there's any benefit, if they think there's something that makes their client look really bad, and there's a way they could say, hey, this really shouldn't go back, they're going to try to push that. And the state will do the opposite. But they'll find the middle ground where the judge will rule on it, and then it'll get sent back. We have started the verdict clock. We're just over 10 minutes right now. We had 84% of us, I think, all came in under 4 hours of verdict, which would put it basically today. We're at 242 right now in South Carolina. Let's see. Simplified jury direction, just pay attention to the facts. It's funny when both sides say, listen to the facts. This is just look at the evidence. It's obvious. Because it might be obvious to one side, opposite to what you think. And that comes back to bite you when you say, just look at the evidence. It's obvious. And the jury comes back and finds your client guilty. And they said, yeah, we looked at the evidence and you were right. It was obvious. Okay. Any
shooting her in the head, referring to Christina. The previously sustained hearsay objection I had regarding what Rita said, you had sustained that during the trial, and the solicitor relied on that inadmissible statement in his closing. Relied on
it's a mistrial. It's a
photo
mistrial
of the gun
motion.
that I previously objected to, as well as the testimony from Lindsay Lewis and Brittany Honeycutt that I argued was under 401 not relevant, 404B as inadmissible propensity evidence, and 403 that any probative value of that was substantially outweighed by its prejudicial effect. I believe this hits the touchstone of a mistrial in regarding the manifest necessity that's been a deprivation of Rita's right to a fair trial. And it's been calculated, the closing was calculated to arouse the passions and prejudice of the jury that crossed that threshold, rose to the level of a mistrial. Thank you.
He's moving for a mistrial while the jury is deliberating.
I think we've covered all the arguments legally. I don't believe that I referred to anything in front of the jury that you kept out of evidence. I don't believe I did that. Otherwise, Your Honor, all the other legal arguments we've already made.
Anything further?
And just to be specific about the statement, I believe that question was asked of Larry about what she said as far as it would be cheaper not to bust out the window to go get the key fob. I objected under hearsay, and Your Honor sustained that objection.
Statement by.
I believe that question was asked of Larry about what she said as far as it would be cheaper not to bust out the window to go get the key fob. I objected under hearsay, and Your Honor sustained that objection.
Statement by co-defendant.
That's correct.
It's being hearsay.
Yeah, and you sustained it, and they relied on that inadmissible statement.
He shrugs.
I don't recall sustaining a co-defendant's statement.
Co-defendant was testifying and went to say a statement that Ms. Panalanigan made. I objected as to hearsay.
The statement stated by the co-defendant.
No.
Defense attorney's right. I remember this.
Rita Panalanigan. During Larry King's testimony.
Right.
And you sustained the objection.
All right. Everything is a matter of record, and the record is preserved, and I overruled the motion that's currently being made and all other motions that I previously overruled or denied. And the jury can keep rolling, and we'll take a break waiting for them.
Thank you. Thank you, Your Honor.
Yep.
He's shaking his head. He's like, oh, man. So yeah, last ditch effort. He's brought up the mistrial word so many times in this trial. He's really wanting to grasp any straw he can possibly reach. Didn't the defense attorney also try to use the emotion during his closing? Oh yeah, they did. But his actual complaint there specifically was talking about, if you remember when Larry King was on the stand, he was asked about what they were doing outside the car, and the conversation came up to, why didn't you break a window? And he starts to answer and say that Rita said no because it's expensive. And that's about how far he got in the response. There was an objection. It was a hearsay objection. It was sustained by the judge. And then he's saying that in closing, the closing got too close to that. Basically, they made the same sort of statement in closing that was sustained as an objection, so that was never offered in trial. It was weak. It's a weak objection. It's not going to I don't think it the pivotal point of the case turns on that moment. But that's what he's doing. And honestly, he's desperate. He's doing a good job. He doesn't have a lot to work with. If you're dealt two cards and you're playing 5-card poker, you play what you got, and it's not going to win. And so, well, I guess that's normally what you're dealt, right? I should study up on my. You get 2 cards. If you dealt 1 card and you're playing 5-card, everyone else gets 2. That would be a better analogy. There's never going to be a royal flush if you're missing 1 card. Let's put it that way. Defense is just trying to make the court TV and law and crime highlights. He's doing his best. He's got a couple spicy moments. I think the judge has been a little frustrated with the defense lawyer because he wants to renew. I want to go over and renew and preserve and for the record. And the judge is like, the record speaks for itself. It's already on the record. You don't have to remake the record every single time you stand up and say, I'd just like to reread. And it's like, you don't even have to read the motion. You've already sent it to me and said you're going to file it. Just file it. It's on the record. That puts it on the record. Don't waste my time. And that came up often. Ask Yeshka says, did you see any mistakes during the trial? The one I saw today, that we talked about a little bit already, was when the prosecutor in his closing said the defendants may have thought the air conditioner was on. Why? Why would you say that as a prosecutor? Why would you give them that grace, that gap? No, don't go there. And immediately both sides on the defense did jump on that and pick up and say, yeah, they thought the air conditioner was on. And so that made the prosecutor then have to go back on his rebuttal and his closing. He had to go back and say, what they thought doesn't matter. They were high. They thought all sorts of things, but they were high and it was wrong and it doesn't matter. So that was a big one. Any other mistake? I think I remember at some point that thinking the state should be making some objections that they weren't making. There was a lot of leading, I think, that they didn't object to, and funnily, is that a word? I just use it. Funny, today there was an objection by Rita's lawyer about leading when he was on cross, when the prosecutor was on cross. And he's like, I'm allowed to, I'm on cross. And he's like, oh, never mind, I forgot. I withdraw my objection. So that was funny. He's defending as hard as he can. He's earning his money. He's doing a great job. He just doesn't have a lot to work with, but he's pushing all the buttons. AJ, good to have you here. Good luck with your case. Let's see, going back to the record in 10 minutes for a jury question. Yeah, I hope we can be done today. Probably not. I wish you luck, AJ. We hope you get a win for your side as well. Does this judge allow jury questions? Listen to learn. Trick question. Yes, when they're deliberating, but no, not during trial. As a matter of fact, this judge also does not allow the jury to keep notes. So think back to the Alex Murdaugh trial. No notes throughout all that trial, all that testimony, all the financial stuff. They just had to just hold it in their brain, and then couldn't discuss anything until deliberations. Now that they're deliberating, they can ask questions. Usually, you'll find out that the judge is going to say rely on your memory of what was testified, or we'll send the evidence back, but we're not going to answer the question for you. You have to come to that own conclusion. He can't steer the thought process of a jury to a certain outcome. So really, any reply he makes to a question is going to be very, very impartial, and it will be run through both all 3 counsels before the reply is sent back. Okay, do you want to play poker sometime? I'm going to lose apparently. I have a confession. I play Governor of Poker on my phone. I'm very, very bad at it, but I do play. It's a free online game that sometimes I play just to get a little break, because you can play for like 2 minutes and then be done. Let's see. Rudy Patootie says, like telling your teen, you may have thought I said midnight to be home. Yeah. The Yes King's lawyer was leading the heck in his direct. Yes, he was, and it was not objected to. I think the state missed a lot of those. Forgetting the head security cameras was a mistake for sure. Richard, there were times, specifically when they came back from getting the key fob, that I looked at the behavior and I said, this looks different to me. This looks like they're acting. This looks like they know there's a camera on them and it's recording, and they're doing things dramatically for the camera. But I think I get the feel that they definitely weren't doing that at the beginning. Almost that it was just an afterthought. I mean, I get so used to being in my studio. There are days that go by I don't think of the bright lights that are shining on me. They're there. Anyone else would walk in and be like, whoa, there are lights here shining on you. But it just I get used to them. I get used to seeing it, and I don't think about them. As long as they're on, it's recording, everything's fine. I think they might have been that way with the cameras. That at least Larry was that way. The thought that the cameras were there, even the screen was in his room showing what the cameras were seeing, didn't register. It's not like, oh crap, what do you think that camera caught? Did it catch us doing something we shouldn't have done? Not at least until not later. Let's see. Does anyone play 31, the card game? It takes 4 quarters. Never heard of it. Connie Muster says, I just got pop-up ads. Is that normal? I've never got them before. YouTube is changing. I got this morning when I created the live stream, it started asking me all sorts of advertising questions, which I'd already preset and said, no, I don't want pop-up ads. There's the one pop-up that's skippable when we start. And that's how I wanted it. But it's pushing really hard. Like there's pop-up windows for me saying, here, just click this button and YouTube will make all your advertising decisions for you. And I'm like, I didn't want that. I don't like watching ads. I've never told it to give you ads either. So I'll have to talk to them and see why they're pushing ads when I say no. Let's see, it's been 20 minutes. They should be back by now. Give them a second. They're just getting the forms right now. I vote for every future confession you play the sad music during it. On the close, as far as the defense, it's hard, especially when there's a child involved as a child victim, to bring levity to a trial like that, because it's a delicate walk. Let's put it that way. I can play the music now. We can have the sad music and you can think about it, but I don't want to make fun of something where... Oh, the phone's ringing too. Hang on one second. We're going to have to... Let's see who's on the phone.
Call from Charmaine Fossinger.
Hey, Charmaine, it's Recovery Addict. How are you doing?
I'm doing good. It's been quite a while since I spoke to you.
It has been a while. Do you want the sad music in the background, or do you have something more lighthearted to say?
And I just wanted to tell you, after that last trial, I had to take a break for a while.
Yeah.
And I want to tell you, I really like the beard on you.
Why, thank you. It's going to go soon. I know it just can't.
Oh, you look really young with it.
when I take it off, you'll be like, "Who's the kid in RA's seat?"
Yeah, who's
like, is that your son? That's what you'll say.
But yeah, it's been a while. I'm going through a nasty divorce. Shane got moved to a higher level, which is good. Mm-hmm. They're trying to get him released. But after that last trial, it just took a toll. That Letitia, every time I hear that name, and and then this poor girl that the parents. Oh my gosh! I mean, we don't care if they were on drugs or what. You don't put an animal in a car. And she's disabled, and just really pisses me off. So, but I just wanted to call in and check in and say I miss everybody. Yeah. And wish you a great Labor Day weekend. Yes,
I've got some plans. I'll tell you what my plans are here in a minute. Let me first say on that mental health note. Yes. Anybody who's listening, who's a true crime fan. A lot of us watch this, and then a lot of times we're like, man, had I known that this was going to be in it, I might have watched something else. We would have followed a different case. And it can be really tough. Take care of yourself first. Watch your mental health. Don't get in a bad spot. There are lots of people here who are, either on the show or not that would want to talk to you if you need somebody to talk to. The burner phone, I can put you in touch with people who can just be a listening ear if you need to talk.
It triggered a lot of things. I actually had to go to the hospital for 5 days, 6 days. It triggered it brought a lot of things up. And I like true crime. I've watched it for years of different things. And it just, something it happened to me, and I'm just, I just had to step away and take care of myself. But I'm going to be watching your show again. And I just wanted to say thank you for all the support. And I am going by the name Red Tail because Charmaine Fossinger is too hard to say.
I will forget that you were Charmaine, though. I'm like, who's this new person?
I know, yes, and thank you so much for your help and guidance.
Oh, thank you. I'm glad things are going well for you and your son as well. It sounds like things are moving up there
Yes,
in the right
they're
direction.
Yes, correct.
Wonderful. Hope you have a fantastic weekend and stay
Oh,
safe
I will.
and everything
I will.
else. Thank you, Charmaine.
I will.
Good to hear from you.
Thank you.
Yep, we'll see you.
Bye-bye.
Bye. Let's see. I was referring to putting the music behind your confessions about the card game, not the trial. Okay, so true confession. Ready? The other day, if you missed the live stream, I was live streaming. We had the live view connected with cameras. I had an in-camera mount with the GoPro as we were driving around looking for flooding in my area from the hurricane, and had the kids in the back seat of the car. Maybe had a couple distractions going, and pulled up to a light. The light was red. The light was red. I did stop. I made a full stop. It was behind the line. I did look both ways before proceeding. I won't tell you what color the light was when I proceeded, but as I went through, I was suddenly alerted to something I had done, and I won't tell you what it was, but there on the live stream, you'll have to go back and watch it and just make sure I was fully legal as I think I was. I think I was legal. So just as a note to anyone who has a camera going, don't commit crimes on camera. Shed, thank you for your support. Support? Question mark. Anyway, there's my confession. True confessions. It was bad. And Matthew's saying, shut up. Matthew Harris, don't talk. Was that you, though? Really? Was I on camera? I mean, you saw hands, but were they my hands? How do you know it was me driving? Breaking the law. Is that Judas Priest that sings that song? Good little guitar riff if you're into electric guitar. Nathan, why would you say that I ran a red light? Of all lights, I don't know why there's a light there. Honestly, a little speed bump would be fine. You could have this. It's a T intersection, right? It's like a four-way. You could have that with no stops, and you would never have an accident. There's never enough traffic there to cause an accident. Everyone could just go at normal speed and never slow down. There would never be a problem. But no, the city of Greenville, in their infinite wisdom, decided that this is a great place to erect a full-on traffic light with everything that goes along with it. And so, in my defense, well, that's not really a defense. Now he's blaming the lights. Oh, I've got a friend who might be watching, who might also be in law enforcement in Greenville, but he's more of like a gang crime sort of officer. So the light was broken. It's not, though. Yeah. Anyway. Brandy's putting on their eyebrows. I would. Mine are no longer adhesive. They're like furry things that fall off my face. I don't know where I was going with that. Scratch that. Will you be streaming Labor Day? Nathan, I keep saying what I'm going to do on Labor Day. At least I start saying, and then I get sidetracked with the squirrel thoughts. Labor Day is, I'm going to be going to, I believe, White's Lake in North Carolina. White's Lake is a lake that is like crystal clear, very clear water, sandy bottom, extremely popular for tourists because it's nice water, it's shallow, it's clear. We don't have a lot of clear water in this area of North Carolina, and it's clear because it has like underground springs and everything, so it's just constantly kept fresh. Other lakes in the area that look very similar in nature are like completely stained water, and like the one I went and camped at and I showed you out on the dock when I did a live stream from there. So I will be going metal detecting there. The only catch is I do not have a beach scoop because somebody stole mine. And, you know, may they rot in. Never mind. We won't say that. But I need to get another beach scoop. I'm probably going to go pick up like a kitty litter scoop from the store, like from the scary Walmart. So if I survive my trip to Walmart, I'm going to be going metal detecting and hang out at the beach and maybe score some rings. That's my goal. I want to score maybe a gold and a silver ring the same day. That would be nice. And we'll do that. Okay. Could it be Mrs. R.A. with her exercise music the reason why you're getting pop-up ads? That's the reason why I have very shady-looking videos on my YouTube feed.
Oh, that was terrible. I apologize.
If you're a defendant in court, wear the eyebrows. No witness could identify you. They'd be like, no, he's the guy with the big fake eyebrows. Okay. Let's see. You didn't run a red light. You just jumped the light. I'd like to think so. Whoa. We got sound again from the courtroom. Judge is back. We've got a note. We might have a question. Looks like we have a question.
Thank you.
Jet. You know, I've lost my defendant running to the tree.
Y'all may be seated. Y'all look at this.
Y'all look at this. Y'all look at this. That's how he says we've got a question. Well, okay, I like that they're on it. They're quick. They clearly are not rereading all the jury instructions. They're starting directly with deliberation, trying to get done. They want the footage. Or can you please bring us a big screen TV and lunch?
Bring the jury.
We're going to have the sound effects up. You don't have to like spam them right now, but I'll have them up later. Oh man, Atlantic Beach, that's a lot of fun. Morehead City, that's not far from me. I'm going to be inland though. Just hold the eyebrows in place. Just long enough for you to clip it. Is that what you're saying?
Is that correct?
That's correct. I've never seen a question the first 30 minutes. This seems really
How does he
fast.
do that?
I don't think we could be hung this quick. Did you send the alternates home? Yep. There's zero sticky on that.
Scratch all that. Oh, that was terrible. I apologize.
There's zero. Well, hang on. If I like slide my finger across it, it becomes sticky again. There must be like, oh man.
Yeah, can I excuse myself from the court for a moment to find my counsel and my defendant? Should I stay
Yes, sir.
Can I?
We won't leave the courtroom again.
Can I find my counsel and my defendant? It's like I'm on my own here. This don't work very well.
Because he's the guy.
They're way too far apart. I need a monobrow for this. There we go. That's all we got.
Confer with each other.
I want to hear the question here.
And now let Murdoch stole it.
Yes, he did. Prosecutor doesn't look happy. Is the defendant happy? I mean, defense? Okay, let's hear this. What's going on here? Yeah, we need to know. Inquiring minds want to know.
There's a lawsuit. Oh.
Stephen Pendleton, thank you very much for clicking the subscribe button. We call that admitting to being an addict. You're one of us now. You can never leave. Trying to keep an eye on Twitter to see if something's happening here. I think we've got the Corey Richings hearing today as well, right? I haven't heard from what's happening there. I want to follow that too. Let's see. Yeah, I'll pull the commands down for just a minute.
The jury has now sent out 2 notes. First one is, can we get a copy of the laws and definitions as stated?
No.
I answered that no. They've now sent out another note. Is it possible that we can get a laptop to view video? It says the state.
I don't have any objection to any way Your Honor wants to do that. We've got a laptop we can send back. Obviously, there need to be some instructions from Your Honor that says you can't go playing on the internet or looking through the laptop. You just got to watch the video. If there's a better way, I don't have any objection one way or the other.
My position is that I like it in a controlled environment. They can come in here. Dylan's well versed, and we can play the video here. It's a controlled environment.
Jury deliberations are not a controlled environment.
Understood, but they can watch the video and then go to it. It's my position.
Yes, sir.
Your Honor, I have been in courtrooms where the clerk or the court has a pristine, clean computer.
Well, the court has no pristine anything. My computer has 20 years worth of work on it.
No, I'm sorry, I wasn't referring to, Your Honor. I'm talking to the courthouse itself, where they make that available. It doesn't have internet access. It doesn't have anything else, but it can play the. If the laptop has other stuff on it, I object to it going back. If it has internet access, I object to it going back.
How are you going to go?
If there's one that has nothing and it's simply a video player, I do not have an objection to them having it in the jury room.
Yeah, well, this should not be rocket science for any lawyer trying a case in 2023 when videos are presented during body cam, videos of various sorts are used during almost every trial.
Yes.
And it's incumbent upon the lawyers to deal with that issue. I do not believe in having jurors deliberate in the presence of an audience, such as Mr. Phillips is suggesting. Though you're shaking your head, once the jury gets the case to deliberate, they should have evidence in the jury room as they were given the video to take into the jury room. It's incumbent upon the parties to make it such that they can view that evidence in the jury room as they have requested.
As I did not introduce any video, I don't think it's incumbent upon me to
accommodate. So you're out of the conversation. It's not incumbent upon you.
So sit down.
Excuse me?
You're out of the conversation.
He says, shut up and
it's
sit
not
down.
incumbent upon you.
I don't mean to take. I'm making the argument that it's not incumbent upon me. It's incumbent upon them. And if Your Honor won't send instructions in the law back to send a computer from the solicitor's office back with God knows what's on it.
Well, I understand that. So obviously that won't happen.
Thank you, Your Honor.
That's like police body cam of a DUI traffic stop that has 30 DUI stops on it.
Thank you, Your Honor.
So we don't do that. Yes, sir.
The burden is always on the state. We have no burden in here. And as far as
exhibits,
there's no law that requires the defendant to have a laptop ready for the jury that I know of.
Absolutely, you're correct. It's incumbent upon the lawyers as far as if you introduce the video and you argue to the jury that they can watch the video, but you made no provisions for the jury to watch the video that you introduced. And so, it goes both ways. That's why, as I'm stating, it's incumbent upon the lawyers who are presenting cases to make provisions for the jury to view their evidence if you want the jury to review it.
Your Honor, respectfully, I believe that would be court administration through the clerk of court's office, and that'll be my position. Thank you.
Yeah, well, it's not incumbent upon court administration, and it's not incumbent upon the clerk's office to make provisions for jurors to review evidence that's introduced by the parties. That's the responsibility of the parties.
The judge is not. The judge is not owning this one. This is on them.
And I think even sending a bailiff back with the computer, but whatever, again, do whatever you want to.
Yeah, Mr. Ford's right. I mean, you have some pristine computer with nothing on it.
Somebody run to Best Buy.
Of having jurors be able to view it, but apparently you all have not done it in this case.
And I guess potentially for the appellate record, I know for other cases, since the state has the burden of proof, they will have a computer with no internet, no access to play the evidence, because it's their evidence for which must cross that burden of proving beyond a reasonable doubt that my client is guilty. So it is their burden.
The jurors request many things that are not in evidence, including a computer or a laptop. It's not in evidence. Jurors get the evidence, and they have the evidence, and they're deliberating. If the parties are interested in jurors viewing their evidence, then it's incumbent upon the parties to work that out, to enter into some stipulation, which should be done in advance of making an argument to the jury saying, watch my video, and you've made no provisions for them to watch it.
Okay, so I'm trying not to think of how many ways that I would be able to answer this and get this done.
So the question posed by the jurors, is it possible that we can get
Apparently
a
no.
laptop to view video? What says the state?
I would say, my answer is yes, sir. We have a video, we have a laptop. Your instruction could be watch the video on the laptop. Don't get on the internet. I don't know what other than that. Yes, is the answer to that.
What else is on the video other than exhibits in this trial?
You mean what else is on the computer?
Yes, ma'am. Sorry. Yes. What else is on the laptop other than exhibits in this trial?
It's probably a lot like your computer. You spent probably 20 years worth of work on it.
Yeah, that's not going back.
The internet is
A few Disney movies.
I think that part's pretty easy. And whether a bailiff could go with it, we would have no objection to that either.
The bailiff's not part of deliberations of the jury.
The bailiff should be
No,
outside.
I'm trying to focus on your own.
This is crazy. This is brand new.
Maybe this one is no. Okay. Judge, I think we have a way to do this.
Okay.
But I've had to ask somebody that has better intelligence on technology. If I could just allow him to explain it to you. This is Dylan Hightower. I know you got introduced him earlier.
Yes, sir. Mr. Hightower.
Yes, sir, Judge. What we can do is we can create a new profile through Microsoft OneDrive and just put these two files on there, the two camera angles, and then allow them to view it from there on out. They won't have any access to any other additional.
Will not have any access of any other information.
Yes, sir. Everything else would be passworded, so you wouldn't go to it. Wouldn't be able to get to it.
All right, Mr.
Including the internet.
Mr. Phillips.
If after review that is done in the way they described, I have no objection. I would ask that the video that Your Honor referenced as far as mine would be put on there as well. Certainly, we don't have to.
So do you want to prove to Mr. Phillips what you just said?
Yes, sir. And I have about 5 or 10 minutes, and I give him a perfect example of how it will work.
I think, and I've known Dylan since he was in middle school. I was in his brother's wedding. I don't know Frank trust, but I wanted to explain.
The youngest guy in the courtroom is now providing the solution for these seasoned lawyers.
And explain it to everyone before they.
So basically what they're saying they're going to do is they're going to take the laptop, they're going to make a new user profile that is limited so they can log into this new profile. The profile will only have specific privileges. Hopefully they'll turn off the internet functionality, and it also will not be able to see any of the folders on the other drive. They have to make sure that nothing's shared like globally on that drive, because that would show up. But they're going to make a new thing. It's going to look like a new computer, but just logs in, and it's called Jury Deliberation Room or something. And they log in, and all they get are those two videos. That's one way to do it. I'm a fan of even a cleaner way. I've got a Blackmagic Design Studio HD shuttle on my desk. It's my replay machine, so you can record. You can put a jump drive in. You can put a hard drive in that just has your files. And you hit play, and you can scroll through, fast forward, slow motion, whatever you want, all the way through everything. Switch between your files, and it's done. But I don't know. That's too difficult, I guess. It's just an HDMI plug as well, so it's no access to the internet. We did a poll. Yes, Ernest. Looks like about 84 of us are saying they're both going to be guilty. About the same percentage think that they're going to be found guilty today, the jury's going to get an
Okay,
answer.
can we get a clear definition of criminal conspiracy? We cannot decide on a verdict until we have a clear understanding.
Whoa. Question number 3.
We have a clear definition of criminal conspiracy. We cannot decide on a verdict until we have a clear understanding. Says the state.
Sounds like they need to come back out and we need to charge the conspiracy that you charged earlier.
Yes. All right, Mr. Phillips.
Yes, Your Honor.
All right.
Bring the jury. Bring the jury.
No, not yet. We're still working on this other thing.
So apparently the jury did not get the charge. They're going to be recharged. Charged again.
Bring the jury.
Okay, Debbie, I'm not worried about this. I would be more worried if, if an hour from now they asked for a copy of the video. It sounds like they're doing their preliminary investigation. The fact they don't have the video is not slowing them down. They're still proceeding. I think they want to review it again or maybe talk about specific parts that they saw, but I don't think that's an indication that they're stuck or having trouble. Yeah, I think this is a good sign, if nothing, for a quick verdict. It's possible. Just realize it's possible that they have not even done a straw poll. A lot of times judges, say like Judge Warner, I think in the Letitia Stout case, said, I would advise you not to do a straw poll, to just first go in and look at the evidence. So that might be the case. They might have just started and sort of rehashed everything over in their heads, and they haven't even figured out that they're already on the same page. Why can't they get a copy of the law? They only get the evidence back there and what they're provided by the judge. I don't know why they didn't. I thought the jury got the copy of their charge, but possibly not. This would be helpful if they had notes. If somebody could scribble a quick note, because all they're going to do right now is they're going to say conspiracy. The common law crime known as conspiracy is defined as a combination between two or more persons for the purpose of accomplishing an unlawful object or a lawful object by unlawful means.
Okay.
That's what they're going to get.
I want you all to check out for a few minutes. Would they know who they are? I don't either. Are those transport police uniforms? Oh, let's see. Sheeta knows. Are those transport police uniforms? Or Colligan County? Oh, okay. They can come back with it.
How can they follow the law in verdict deliberations if they don't know the law? That makes no sense. They've asked for a copy of the law, and they're not allowed to do that. They're not. The judge determines, the law, and they determine that they're aware of the facts. No, they should not ask verbal questions to the judge. All questions should be reduced to writing and should be signed by the foreman, the Madam Foreman, and she's going to send it to the bailiff to the judge. Judge told them they should use the law as he told them it was. It would be nice if he allowed them to write it down. I mean, if it's important enough for him to tell them specifically what it is for this case, it would be nice if they had a copy of it. I don't think they're allowed to take any notes. This would be an easy solution. The only catch is the video. The 5-hour video might be too big for a USB drive. Some TVs might struggle to play that. They don't really have really strong
ready for the jury to come in?
internal components.
Okay, Mr. Bailiff, you bring the jury.
Bring the jury.
Kath, the judges that don't allow notes, either it's a state law, like D&B Second has said, or they might feel that writing notes could be a distraction where you miss important testimony.
Coming in, I've read what was submitted and agreed upon by the party, states request number 3. And I kind of hesitated as I was reading it. 2 or more persons gathering together for the purpose of accomplishing a criminal or unlawful object, or an object neither criminal nor unlawful by unlawful means. Is that the right word, object, or should it be act?
Object is the right word.
I try it's options because I've always thought it was a I think it's too. I try to get that directly from the case and add the quotes.
I got you.
Object as an objective. There it is. Connie, thank you very much. You beat me to it. It's not the mama as well.
Sure.
I have a statute here, and that's counsel of representatives.
Okay.
Okay, jury's coming back in.
All right, welcome back. Received a couple of notes here. Is it possible that we can get a laptop to view video? And the answer is yes, and that'll be submitted back there for you to use. Second question is, can we get a clear definition on criminal conspiracy? We cannot decide on a verdict until we have a clear understanding. A criminal conspiracy is defined as a combination between 2 or more persons for the purpose of accomplishing a criminal or unlawful object, or an object neither criminal nor unlawful by criminal or unlawful means.
That's the worst definition.
To establish the existence of a conspiracy, proof of an express agreement is not necessary, and direct evidence is not essential, but the conspiracy may be sufficiently shown by circumstantial evidence and the conduct of the parties. And that's what the definition of a criminal conspiracy is. So, I ask you all to return to the jury room.
And he kicks him right back out. That's all they get. Yes, there are ladies on the jury, at least one. We know that the foreman, the forelady, is the lady. The judge in this case selects his own 4 people for his jurors. The juror 4-person. That's just his practice, and he does that. He did that in the Murdaugh trial as well. That definition is not very simple. It is a legal analysis, and lawyers, it'll make sense to them, but it's not a common type expression. It's got too much legal speak in it. The whole 2 or more persons.
Any additions or objections to the charge?
Unlawful object.
No, Your Honor.
Okay, let's give them 3 minutes to see if they have a verdict. They're moving. I think if they are confused still about what conspiracy is after that, then it will be very difficult for them to find it guilty of conspiracy. Okay, audio's off again. The portions of the video they're going to watch are going to be the portions that have action on them. And they're going to watch probably the girl being put into the car, first of all. Christina being put into the car by Larry. They're going to watch probably anytime they walk up to the car, whether it's trying to poke something in or, try to open the doors. They're probably going to watch the lights flashing even though I think that makes pretty much plain sense, and they're probably going to watch the very end of the girl getting brought out. Those are the parts that they're going to see. Can I decipher the definition, Connie? I'll try. I'm reading this from South Carolina Statehouse.gov. So this is the legal definition. This is section 16-17-410, conspiracy. The common law crime known as conspiracy, so basically the crime of conspiracy under the law, is defined as a combination, so it's got two parts, between two or more persons, or so it has two or more parts. So two or more people get together to do something that's not legal, or the end result is not legal. A person who commits the crime of conspiracy is guilty of a felony, and upon conviction must be fined not more than $5,000 and imprisoned for not more than 5 years. That's the sentence. A person who's convicted of the crime of conspiracy must not be given a greater fine or sentence than he would receive if he had carried out the unlawful act contemplated by the conspiracy and had been convicted of the unlawful act contemplated by the conspiracy. So you can't be sentenced to something more than if you were just charged for doing it on your own. So basically the penalty is no worse than if you did it just by yourself. So two people getting together to do something that is unlawful, or the end result is unlawful. It seems like a wide open definition that way. We are in Verdict Watch. We're approaching the first hour of Verdict Watch. The jury has had 4 questions already. First one, they wanted like the law book, the big law book, so they could read all the definitions, and the answer was no. They also wanted a computer so they could watch some videos. They wanted a definition of, Larry's got some culpability on his hands there, I think. They wanted the definition of conspiracy, and let's see, what was the last one? I don't remember. Greeners was typing them out for us. Why is a jury of your peers expected to be experts of the details of the law? They're not. They're not expected to, but they're expected to be able to make a decision based on what they're told the law is by the judge. Oh, so 3 questions only. Those are the 3. I thought the first one the judge said no to was they wanted the law book. They're like, can you give us a copy of all the laws? Can we get a copy of laws and definitions as stated? That was the first one. Thank you, Greeners. That was the first question. The judge said no. Every state's a little different. I thought the jury instructions went back there. Apparently they do not in South Carolina. Love me some Judge Newman. We all do. Well, at least most of us. What are your thoughts on this one? Are we gonna have a verdict here before dinner time? Dreamscape, he said, Larry tried to pretend he didn't even know Christina. Christina was the daughter, the one who passed away. He was with Rita for over 2 years. And in addition, Larry, when he called 911, his description to 911 was that his daughter was in the car. He called it his daughter. That's very telling. I'm not sure why they didn't play that. Gilly May, I think his goal was Judge Newman's goal was just to get the case to the jurors before the end of the day today, and now it's in their hands how long they deliberate.
You also, before you gave us the standard charge, you said this is a more clear, or this is a clearer definition than it is.
I don't recall saying those words. I'm not disputing you, but it doesn't sound like me. But go ahead.
Since they asked for a clearer definition, and this is one, and it is a correct statement of the law, I'd ask that you charge.
Well, thank you. I thought you were going in another direction.
No, sir.
Okay. It says the state.
Do we have another question?
I'll be honest with you. I don't know if it's any clearer with all of that than it is without it. Conspiracy has always been a relatively confusing crime, so to speak.
Well, it gets back to the words that I said, an unlawful object,
right,
as opposed to an unlawful act. That's the essential difference that further explains it to me.
Kathleen, thank you for the super chat. No, he's charged. They're both charged identically.
Give me a case from 1963. I imagine conspiracy was pretty confusing back then. State v. Fleming.
There's a lot of things I disagree with what was happening in 1963, so I think the proper statement of law is appropriate.
Especially the case that was handed up from Clarendon County. So there's no objection to me bringing them back out and giving the standard conspiracy charge. Is that correct?
I would request.
Requested by defense.
They're going to do it again.
And agree to about the state. All right. So let's bring the jury back.
Oh my goodness. Ace King, thank you. Looks at that new courthouse color by your name. Appreciate your support. So jury's getting dragged out again to be told the same definition, or in a little bit different words. They're going to use the standard definition that's straight from the charge, like they did before. Yes, the only thing I don't know is I don't think they asked again for a more clear definition, or if they just in deliberations decided they wanted to redo the answer. I think it's a redo. Kathy Keller, welcome to the gallery. Thank you so much for joining us. You're one of us now. You can never leave, but you'd never want to anyway. Thank you for being here, Kathy. Jury does not understand the definition of conspiracy. Criminal conspiracy specifically. Greeners, you're killing it here on these verbatim jury questions. So we're clarifying the clarification. The judge does seem to have a yellow paper up there, so they might have asked another question or asked for additional clarity. They're not able to just openly discuss this in court. I wonder if they've already got the big question answered. If they're already, united on murder, and now they're just looking at the other charges. You'd think they did it in order, right? So the first one is murder. The second one is, what was the second charge was great bodily injury on a child. And now they're asking the conspiracy question. That was number 3 on the charges. So yeah, I would be nervous if I were on the defense.
Manifolded members of the jury, the defendants are charged with conspiracy. The state must prove beyond a reasonable doubt that the defendants combined with one or more person, the defendant or defendants, combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that a defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that a defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict a defendant of conspiracy, the state must prove beyond a reasonable doubt not only that a defendant knew of the unlawful conduct, but that a defendant agreed or combined with the other person or persons for the purpose of accomplishing the unlawful conduct. And that is a criminal conspiracy. You all will return to the jury room.
All right, I think this was just a clarification. I don't know if they had asked the question or if... I bet they had asked the question. They had to have asked that. Asked for a more clear definition. But man, this foreman has got them just working overtime. They're just crunching through this. I bet they don't even have the laptop back there yet.
Thank you. Okay, any additions or exceptions?
None.
All right. And how we coming with that project?
You ready?
Good.
Bring in those.
Conspiracy is a tough one. The first part of the definition seems like it's really hard to meet, but then once they say that the last part, they get to the, there doesn't have to be any, firm plan. Basically, them just acting together or participating in it could be enough to prove that there was a conspiracy. Look at the video. Look at the part where they know that she's locked in the car. They go in the backyard. They talk for a long time, and they drive away and leave. I think them leaving while she was in the car, in the hot car, is enough to prove conspiracy. That Larry was driving, and they clearly went to go get this. The testimony is they went to go somewhere else to get a key. I think leaving her in the car proves conspiracy. Let's see who's on the phone here.
Call from Bree.
Hey, Bree, how are you doing? Good afternoon.
Good. How are you? Verdict Watch is spicy today.
It is. It's a good one.
Well, I called for a one-off for everybody in the chat. I live in Santa Fe, so I don't know if anybody's aware of this, but Burning Man was basically established because of a tradition here in Santa Fe, and it's called the Zobra. It's burning a Zobra, and so every year people put their woes and their worries and things that have been bad throughout the course of the year in this 50-foot marionette puppet, and they burn him to the ground basically today. So it's the Friday of Labor Day holiday. So if anybody's interested, they can Google Santa Fe News. It's KOB4, but you can watch it on the news, and you can submit your woes for the next year. So, with all the Letitia and all this crap that we've witnessed, we can burn all that crap down next
You're going to need a bigger puppet. A bigger puppet
he's
for all of our
already 50
woes.
feet tall. But I just wanted to give somebody kind of something that's just kind of really cool just to kind of see and stuff like that. And so it's on the news. They live stream all the coverage. Mm-hmm. So if somebody wanted to do something different after this, then I just kind of wanted to let you guys know that that's something that happens in my little town today.
We can watch all of last year's troubles go up in smoke. That's what you're offering, which is awesome.
Absolutely.
Bree. There's a lot of what happened last year that we need to just. It needs to be gone. It needs to be gone.
Just burn it down and start over.
If we could also include maybe running a traffic light, running a stoplight or something, if I could include that and get that included with last year's trouble, so that's gone as well, that would be good. If you can make that happen.
Absolutely. Cars that get wrecked, whatever. Things like that just happen throughout the year.
Yeah.
But I just wanted to let everybody know. So, it's KOB4, but if you don't remember, just go to Santa Fe News and look up the Zobra. But it's everywhere now, and you can see the 50-foot puppet from across town.
Is it a
really
nighttime thing? Do they wait till dark? So that it's okay.
So the event starts today at 4, which is 1:30 here, but they don't actually catch him on fire until 8 o'clock at night. But it's really cool because this year, all the last few years, they've done decades. So this year it's like the 2010. So they have all music from that genre. They have fire dancers that catch him on fire. So it's really, it's really one of the coolest things that I've ever seen. We went to it last year, actually. Yeah. But it's just really something like, it's almost one of those things like Balloon Fiesta you have to witness firsthand, but it's really cool. So I know some of these. I
watched the Guy Fawkes Day celebration over in England, and I forget what town I was in, but they had this. I mean, when you talk about a bonfire, it was huge. Yeah. It was massive. It's like a structure. And it completely destroys the soccer field it was built on. It just torches the whole turf.
Yeah, this year is going to be big, but next year is going to be crazy because this year is the 99th year. Next year will be the 100th year. So next year is going to be silly.
All out for 100 years.
Oh yeah, they actually after last year they had 75,000 people in this park to watch it. So they've limited it to 50,000 this year just for safety reasons, just to make make sure nothing crazy happens. But
do stay safe, have fun.
We'll
keep an eye on that and.
All right.
There go all our troubles. Thank you.
There we go. Hey, I'm trying to get us a good wave. Bye-bye.
Thank you. Bye. Awesome. That sounds cool. Ivan, this is pure evil, he says. No, that's funny. Let's see. It's been a few minutes and the jury hasn't asked a question. I was wondering what's wrong. The level of professionalism displayed by the defense attorney for Rita. Rita ain't glad to meet you. Makes me wonder when the heck Walmart opened with their own chain of law schools. Okay, Mary Bell Vega. There was a couple points where I think what you're getting at is Rita's lawyer made some very basic mistakes, like not realizing that on cross you get to lead.
Contribution to our next FOIA request fund, smiling face with smiling eyes and hugging hands.
Samantha, thank you very much for a super generous contribution to the FOIA fund. We have a couple of requests in there we're waiting on. Still just waiting for the bill so we can pay it and get some video and some documents. Did you run any red light in England as well? Their traffic lights are crazy. Stephen, in England, they've got the roundabouts. They use roundabouts almost everywhere. And so more so than traffic lights, there's just... everyone just goes, and they work together. It works great. Especially Hemel Hempstead. If you ever get a chance, go to Hemel Hempstead. Is the Kodak building still there? Go up to if you can get on the Kodak building and look down and take a picture of the Hemel Hempstead roundabout. It's a magic roundabout with 6 little roundabouts around it. So it's hard to imagine, but it's like 6 different roads come in and connect, and you can drive around it either clockwise or counterclockwise. It doesn't matter. You can do either one, and there's like 50 cars in there at all times, just going all at the same time, and it just works. It's a thing of beauty. All right, in the Netherlands too, there's a magic roundabout. I see Judge's head. I do. He's might be getting ready to read another note. We have our first roundabout here in town, and I don't like it because they put it on an intersection where there is no traffic. There's no cross traffic. There's literally a dead end in a cornfield on one side, and it has its own route. And then there's a road that no one's ever driven on in their life down the other way. And so now instead of being able to just speed straight out of town and get out to the bypass and off you go, now you have to like slow down and go around the median and then keep going. Nobody uses it for an actual intersection. It's just like a traffic slow down method. Okay. Let's see. Planning for expansion. I remember my first driving a roundabout. Couldn't even get off. I kept going around and around. I think you can only go around like 8 times before you have to exit. I think that's the rule. After that, you start getting dizzy and you're a traffic hazard. The thing that I don't like, I realize functionally they work really, really well. Like they're excellent for traffic mathematically on paper, but I hate them as a driver, and that's the bulb, the drive through, and then the bulb turnaround to no left-hand turn through the intersection. Oh, I hate that. Whoever thought that up needs to, obviously be forced to drive in it. Okay. Trying to answer questions, court-related questions here. Like the new verdict watch clock. Thank you very much. It has a label because I've been accused of putting up things in the corner with no labels, and then everyone has to answer the question. Did you miss the last question? Did they ask the same thing? I think they asked for a more clear definition of criminal conspiracy, and so they just read them the charge again. And hopefully that's good enough. Do we have any plans for the holiday weekend? I want to go metal detecting. I don't think the family has any plans. I think I'm going to take a day on my own. I don't want to take any kids because I'm going to be underwater for a fair portion of the time, and I just won't be able to watch them. And I don't like, I wouldn't leave my kids in a car. I wouldn't leave my kids in a lake without supervision. Trouble says, did you get your tongue wrapped around your eye tooth and couldn't see what you were saying? Happens a lot. I get tongue-tied. Okay. Do they have to find guilty on all the charges? Lena, that's a great question. Actually, they don't. They could, in theory, anything is possible. With either defendant, they're independent as far as the sentence on the verdict on one and the verdict on the other. They could find not guilty. So you've got 3 charges, right? So you could find not guilty on this one, but guilty on the other, and same with 2 and 3. So you could have 2 guilties and 3 not guilties, or any combination of these 2 charges. Judge is back. We're watching. Let's see. Not sure who's calling here. We'll keep the burner phone open for a little bit.
K-Mets.
K-Mets, how are you doing? This is Recovery Addicts.
I'm doing great, but I'm confused, just like the jurors are.
Okay.
Maybe you can help me.
I might not be able to. What?
The conspiracy, is the charge conspiracy to commit the murder or cover up the murder?
Okay,
because if it's to cover up, I can find it easy. If it's to commit it, I can't, because it doesn't, like the me when they saw her in the car and then they go and they talk and then they leave. At that point, they're conspiring maybe to cover it up.
Okay, so this is a fabulous question, first of all, and it's a problem. It's a question that the defense actually brought up as an objection to this charge, because the charge, or the crime that they're charged with is just conspiracy, and they said, conspiracy what? A conspiracy to do? Is it conspiracy to to rob a bank? Is it conspiracy? And the charge is just conspiracy. All they have to prove is that there was some conspiracy to do something illegal. So under that broad definition, and the fact that they left it blank and were permitted to leave the form blank to just say a conspiracy occurred, you might say they had conspiracy to do drugs, okay, to illegally participate in drug use. And if they find it's possible in theory that they could reach that sort of conclusion. One juror might vote that yes, there's conspiracy because of what they did, in relation to driving away. Another person might say, yes, there's conspiracy because of what they did in putting her in the car. It could be different how they reach that conclusion.
That's exactly where I'm at. Like, I can come up with, they conspired to hopefully find a way to cover it up.
Yeah.
Make it look like an accident, whatever the case may be. But to conspire to put her in the car for her to die, then no. So I was curious as whether it was the conspiracy to murder, but now you answered my question, so thank you.
Yeah, it's sort of bizarre, and that adds to the confusion for the jury, because it's not clear. It's not like they said, right, we are saying that they conspired right here to accomplish, this is the moment when conspiracy occurred. It would be much easier for them to look at the evidence there and say, either I see it or I don't. But they're just saying, there was a conspiracy that happened here. If you agree, find them guilty. And so now it's interesting. But great question. Thank you so much for calling and asking that.
I'm going to let it all go, and hopefully we get a verdict soon, and maybe not too many more questions.
Maybe. We'll see. Thanks, K-Matt. Appreciate you.
Have a good one.
You too. Bye. Man, you guys are smart. Conspiracy to itch a scratch. It has to be illegal. And what happens between 2 consenting adults? I don't know. See, I'd like to give Mrs. R.A. an idea for the kiddos they'll absolutely love. Dodie, probably take that one offline. Send it to the burner phone if we can. That would be great. Just in a text message. Would that be all right? Or maybe when we're done. Ooh, who's standing? And why? Two people stood up at the same time, which generally means something's happening, but I don't see the judge. I think the jury thought maybe they had to decide if they talked about killing her. If you return the laptop to Best Buy within 2 hours, do they waive the restocking fee? No, they need to keep the laptop there in the court. Just have a clean laptop to just play videos. Let's see. They conspired to put her in the car, then conspired to leave her there, then conspired an alibi. The alibi is probably going to be the easiest one to see conspiracy on, because the putting someone in a car, and Larry's lawyer brought this up, just putting her in the car and strapping her in, that would look the exact same if they were leaving as if they were going as when they were going to as if they were planning to leave her in the hot car. So if Rita was going to be leaving immediately, his actions would be identical. That would be hard to prove conspiracy for that. Hey, this is a recovery addict. Who am I speaking with? Nobody, apparently. They hung up. I tried. You guys are my witness. Judge seemed to get up and walk out. Maybe they stood up for him as he was leaving. Red Pen says, I'm blown away that the prosecution didn't have a clean laptop for the very purpose. What a big oopsie that was. Why not a DVD? I mean, I realize it's a dying technology. DVDs are going out because we have, digital, solid state media and things like that. But why not have a DVD player, a TV, and they can just drop the video in? You can put, especially video footage like that, which was very low resolution, you can put that on a drive and fit hours and hours and hours of video on there. Conspired to commit an unlawful act or a lawful act by unlawful means. So you're saying the lawful act was putting her in the car as if it's time to go, but the means was still lawful on that. I think all the means was okay is putting her in the car, other than the method. Okay, I do think that how he put her in the car could, on its own, if we had better view of how that was done, could even raise to the level of abuse. They left her in the car when they went to get the other set of keys. Isn't that child endangerment? Yes, I feel that. That's that point when they get together, they talk about something and their hand motions. They know that we know that they know that she's in the car, and they decide to leave. I think that is enough that they could prove conspiracy there, as well as when they come back with the car keys and they're talking it over, and then they go and unlock the car. I think that's both of those could prove conspiracy under that open definition. Could they find one defendant guilty of conspiracy and find the other defendant not guilty of conspiracy? Yes, they could, but it would be a little bit of a brain scratcher, head scratcher, because you have to have two people to say conspiracy. And so you've got basically it would be a something went wrong here moment, because who would they have conspired with if not somebody there in court who's been accused of a crime? So I think that conspiracy charges will definitely go together, whichever way they go, either both guilty or both not guilty. Rocking the car was disturbing. Why would they both leave? I think it was his truck and it was her house with the keys at it. So okay. Hey Amber, how are you doing?
Present and accounted for. How are you?
So it's the bare minimum. Is that what you're saying? I'm alive. Oh, it's Friday, though. That's something to be happy about.
Most would say, sure. We're just not going to get into that. So I kind of can't really explain much in comments because I'm kind of tied up with work. But what the instruction that was given stated was conspiracy to commit any unlawful act or any lawful act by unlawful means. So it could be when, and I haven't followed this case as closely as I have others, but it could be they conspired to go back in the house and do more drugs. It could, I mean, it's way too broad of a charge, in my opinion. But again, I haven't followed this case quite as closely as I have others. So
the broad charge should mean that it's easier to get a conviction on, right? More
you would
fits
think,
within
but
it.
yes, but then no. I think they took a big risk going into such a broad charge. They should have, in my opinion, narrowed it down to something more solid. Drugs could have been a good one to go for because we already knew that they had drugs in their system.
The problem is we couldn't prove that they used. There's no proof that they used any time between when the video started and when the police showed up.
Right, but it would be more clear of a definition of saying what did they conspire to do. Any unlawful act leaves it way too broad. I mean, I'm sure as your attorney's sidekick, I didn't want you to keep talking about your driving experience, but all of us at some point have conspired to do something unlawful or lawful by unlawful means. Mm-hmm. If you think about it, everybody has. And if you haven't, then you're an absolute saint. And I'll leave it at that.
Yeah.
So it's just such the broad conspiracy to commit a crime charge, which is an unlawful act or a lawful act committed by unlawful means. I mean, that's way too broad.
Yeah.
Me personally, I would say not guilty on that because I need you to narrow it down for me. What exactly are you trying to say conspiracy for? I
can see that. Yeah, I can see that. They left it so broad that they're like, we can't move forward. We just don't know what you want. Okay.
Right.
Great advice there, Amber. Appreciate that.
No problem. I'm going to go back to
work.
Back to work now.
Okay, good luck. Thank you. Good to hear from you.
Maybe we have a verdict.
All right. Thank you, Amber.
Yep, anytime.
We'll see you.
All right, bye.
Let's see. I believe the drug use on its own was an illegal act that led to Christina's death, thus conspiracy, says Gayla Rue. Jettas are horrible. This is just statement of fact, apparently, by Sean B. Not a fan of Volkswagen Jettas. My first experience with the Volkswagen was the Volkswagen Rabbit. And my neighbor had like they delivered newspapers. The neighbor boys delivered newspapers, and they had like 200 routes. They're one of those people who had collected routes until they delivered for the whole city, instead of just having like a small route. And so the papers would arrive, and we'd all go up there and we'd help fold the papers, and then we'd jam the whole Rabbit full of papers. And delivery was a 2-person, sometimes a 3-person job. And your job, if you were in the back seat, which was like crammed in the newspapers, is just to start handing newspapers to the front the driver and the passenger, so they could then, as we swerve and zip, speed through the city, they could chuck the newspapers at all the neighborhood kids as they went around. And then, of course, the stereo was cranked to full volume to Van Halen the entire time. And that was my first experience with a Volkswagen. I was impressed, honestly. It was pretty cool. I'm not sure why I'm talking about. Oh, the Volkswagen. That's why. That's what I had. A Rabbit. I think Mrs. R.A. has a Volkswagen story way back in the day. I think the car was named Betty. You'll have to ask her about that sometime. Yes, Tiguan was in a previous trial. Not Bohemian Rhapsody. A little Queen would be appropriate as well, but mostly it was a little David Lee Roth action. It was, Van Halen stuff. Is having drugs in your system a crime in the U.S. because it's not here only if driving, etc.? They were driving, so maybe there's conspiracy there. I think some states having drugs in your blood system. I mean, look at alcohol, for instance. Is a sign that yes, it would be a crime. How long to reach a verdict poll? 84% of us think we'll be in the first 4 hours. 40% said in the first 2 hours, or 44% in the first 2 hours. Might as well jump. Go ahead and jump. In this case, actions definitely speak louder than the words. They definitely did, even though it was a silent video. That was powerful, powerful testimony. Benny, could the story of her cheating on him and wanting her to leave be a lie they made up? Maybe it was on purpose that she died and they were covering it. Benny, that would indicate that there was a lot more. There would have to be a lot more collaboration and planning ahead of time, because so much happened during that time period. It would be easier for me to believe that him finding out that she cheated on him, and then they talked it over and decided to make up. That seems more. It's easier for me to buy that story based on what I saw. When caring for children, it is neglect and child endangerment, if I'm not mistaken. Both adults at any time could have acted independently, preventing the death of Christina, as both knew she was there. Together, they ignored the situation. Wouldn't that be conspiracy? Possibly. Obviously, this definition is one the jury's struggling with, and we are as well. Okay. How long's the jury been out? Elizabeth, they've been out for 1.5 hours, roughly. They've been brought in for a couple breaks, and we've kept the timer going for that. But those are short little breaks. Jenny in Georgia says, I don't think it was planned. Then in that case, you're going to be a no on the conspiracy. Would you then be a yes on the murder and the grievous bodily harm to a child? And if so, for both or just one? Didn't Murdaugh jury only take a couple hours? They were pretty quick. They were fast. Okay. Do you think the jury will watch all 5 hours of video? No, I don't think they will. First of all, they know, they've seen it already, one, and they know that hours go by with nothing happening, and so you can fast forward. I think they'll skip to the pertinent parts they want to watch, and those parts will be when Rita and Larry are out by the car. Whether they're on the porch, whether they're next to the car, whether they're putting Christina in the car, that's when they're going to be watching. And maybe when they're in the backyard in the truck as well. Dreamscape, they did not prove that. I don't know if they have to prove that element for any conviction. Are you talking about malice? Because under the definition of malice, the majority of it does sound like you have to prove some sort of, anger against the victim. But the last part the judge included in the reading was that there doesn't have to be specific, ill feelings toward the victim for malice to occur. We are seeing a little bit of motion in the courtroom, Tracy. I think all the attorneys are still there, just because we've had a lot of questions come in pretty quickly. I think when you have a disabled child, your standard for care is even greater. The need is greater because they're not able to do anything for themselves. It's basically like having a child that doesn't grow up in some ways, because they're constantly need to be cared for. Learned to drive a stick in a TR6. I learned to drive in a Volkswagen Rabbit. I did a very, very bad job grinding the gears. I didn't understand that the clutch had to be pressed to shift. Learned to drive a motorcycle on a Honda. What is it? It's the 90, the Trail 90. Honda Trail 90 was my first motorcycle. My friend had one, and he wanted to let me ride it, and I ended up doing like I don't know what you call it, whiskey throttle or something, where you ring, and I was going fast and slow, and I ended up dumping my friend off the back, and I fell off the side, and we crashed. And he didn't let me drive it anymore, but he did let me drive his little mini bike, which was powered by a gas station, or a gas lawnmower engine. But there was testimony of Rita leaving her in the car because she was inconvenient. Yes, there was. I would say there was testimony and video to that. So that's a good point. I think the planning, I'm agree. I don't think that there was a plan beforehand to say, hey, here's how I'm going to get rid of Christina, and this will make my life easier. I don't think that was the case. I even would go so far as to believe the daughter that for a large portion of her life, she was very loved and treated well. Probably when the drugs came into play, things got worse. Lawyers stay in the courtroom with the defendants. Sometimes the defendants are let out or held in a holding cell at the courthouse. Just depends on the time frame and what's happening. Off topic, my 401k is making money. Did you stay at a Holiday Inn last night, though? I mean, that's good news, though. Retirement, it's looking good. I don't know about negligent homicide charge. I know that we didn't hear anything about lesser includeds. So it sounds like they just have the 3 charges. Tag named your 85 Chevy Astrovan Big Bertha. Big Bertha. We had a Chevy 15 passenger. It was like a lunchbox van. The front tires are, it's so top heavy. Corners, the front tires just wear out. You put a new pair on, and like a week later, they're bald on the outside corner just from turning the corners. We had that. We sold it, I think, for way too little money because I told my mom it was probably worth almost nothing. It's probably worth a lot more than she sold it for because of me. Let's see who this is.
Call from Nola Chick.
Nola Chick. This is Recovery Addict. How are you doing?
Good. How are you?
Doing great.
Good.
What's on your mind?
Listen, I wanted to make a comment. I know I'm kind of late, but I wanted to make a comment about the roundabouts that you guys were talking about.
Yeah.
And we have one in our city in Hammond, Louisiana, and we call it the Circles of Death because nobody knows how to drive through them, and everybody honks at everybody, and it is a huge mess.
Is it 6 little roundabouts that make one giant roundabout?
It's 3 of them, actually.
It's 3, okay.
3 of them, yes. And our exit has tons and tons and tons of 18-wheelers, and there's actually damage to the businesses around the roundabouts because the trucks run into the fences around the businesses when they're trying to go through the circles.
It's awful. I realize in England they work really well. We just don't know how to do it over here. So
no, and you are exactly right. It works on paper, but once you put it into practice, nobody knows how it works.
There's just so many places to be mindful of people coming. It's like normal traffic. You come to an intersection, you know where the lanes are. Here you've got curves and people that can appear out of nowhere and coming around the corner, and here they come. They're awful. I hate them, but at the same time they're fun to play at. In the right vehicle in a snowstorm, rear-wheel drive vehicle. I don't know. I'm just saying.
Well, I hope we get a verdict soon. We're sitting here waiting impatiently.
Where did you vote?
Cajun Girl.
Yeah, you and Cajun Girl. Where did you vote as far as the poll? Do you think it's going to be 1 to 2 hours, 2 to 4, 4 to 6, 8+? What?
I'm going to vote 2 to 4 hours just because I'm hopeful that they'll do that in time. That's what I want.
Pre-dinner. Okay, sounds good.
Right.
I'm going to hold you to that. All right. Okay, good to hear from you. Thank you so much. Have a good one.
All righty. Have a good one.
Yep.
Bye-bye.
Bye. Roundabouts are easy peasy lemon squeezy, so it's fun and funky. We have 3 roundabouts in a 6-mile span, and we pretty much stop when trying to enter them. And that's a problem too, because the design is to keep the traffic flowing as long as there's no traffic coming the other direction. That's why the roundabouts are so much fun. Red Pen is in the snow. There is still snow to slide around and do donuts. Ever had to drive through a diverting diamond? Paul Mack, I'm not sure if I have. If I have, I didn't know it was called that. I've done some of the driving down in Houston where they have lanes that change direction. Like sometimes people go one way and sometimes people go the other way in a narrow thing. I was always worried someone was coming the other direction, even though I guess it can't physically happen. I think you should be able to tell your navigation system to route you on routes that keep you away from roundabouts. Sort of like avoid roads or avoid toll roads. You could do avoid roundabouts as well. Okay, we've been almost half an hour with no jury question. A little over half an hour, actually. No jury question. No eyebrows for the verdict watch. I'll play the music when it's time if we hear something. But speaking of which, Amy, I did get your text. I'm not sure how to answer that yet. You're having trouble with comments on another channel. I could try to talk to the other channel and see what happened, but there's a diverting diamond. Oh, going out of Brigham City onto I-15. Okay, so a diverting diamond. This is where I know the intersection you're talking about now. I've been on that one. I think what they do is they take typically in the U.S., you're driving on the right-hand side of the street and you have to make a left-hand turn. You're crossing oncoming traffic. But a diverting diamond takes the oncoming lane and moves it over. They switch lanes. So the oncoming traffic is now, it makes a close turn. It doesn't have to cross oncoming traffic. That one's not so bad if the lights are managed correctly. It's a little weird with the fact that the road's just sort of like, and now we're switching. But I've been through one of those. Okay. They're ready for the 3-day weekend. Aren't we all? While we're waiting, quick poll. We're going to try to see who has the best plans for this weekend. Not to what you wish your plans were, but who actually has the very best plans for the weekend if you get a little bit of holiday. Go ahead and put it in chat. And then if somebody else has better plans than you, just comment their name. But you can only choose one. So as soon as you find somebody who's like, oh, this is the winner, then comment their name, and we'll see whose name starts popping up more and more. I'll read some of them here. Let's see. Ace of Swords says Cleveland Air Show. Cindy's Crazy is going to be sitting at her house. Jill Ballard, I don't think you're going to win this one. I'll be working. Great Wolf Lodge from Alabama. That's nice. Camping for my birthday right now on the lake, says Kayla Newell. That sounds great. Hopefully doing some fishing or just enjoying the sun. 3-day weekend into a 10-day weekend. 6-fold. Where's my invite? Sleep, shop, and eat. That sounds good. I have nothing, so I lost already, says Karen. Off today and tomorrow, working the rest. Double time pay, though. That's nice. Horseback ride through the woods. I could do that. Making candles. I'm wondering if you carve the candles or if you just dip them. Curious. I've watched a lot of videos on that. Doing nothing, staying home and relaxing. That's 2 votes for that. All-star sprint chases, sprint car races. That sounds loud, Judy, but also very much fun. Doing only what I want to do and not a thing more. Let's see. Tons of money off crazy drunks, says Ivan. I think that's your plan every weekend. Lake and Casino in Murphy, North Carolina, says Tipsy Tracy. Steamboat Springs for a little fun there. Train ride on a steam train. Then my business has been chosen to work at a Cornish market. That sounds both like a lot of fun and then a lot of work. Oh, everyone, Holly's invited us over for apple pie or apple dessert. I'm not sure if it's apple pie, but an apple dessert. Let's see. The Great Guega Fair. I don't even know how to say that. Guega. 6-volt. You know I can't pronounce words. I need a pronunciation guide on that. I know you read my eyebrow comment. I did, Bug Dugger. I'm ignoring it. Let's see. Monday's also my birthday. Jill, happy birthday on Monday. That is exciting. You get a holiday for your birthday. Plan to not spontaneously combust. It's hotter than the surface of the sun here. Let's see. Harley ride. Beach or mountains. Haven't decided. Either one is a win. Although I will say this. I like curvy roads on a motorcycle. They are so much fun. And Harleys are comfortable to ride as well. So hopefully you take it up to the canyons. It may be a little bit cooler up there. Do the mountains. That's my suggestion. Also, I don't have that option because I don't have mountains around me. Or a motorcycle right now, even though I have a motorcycle license. Need to fix that. Oh my goodness, there's tons of suggestions here. Yard work. I probably need to do some flooring on the apartment. Chips in college football. That sounds fun. Go team. Yay sport. Preparing the house for my knee replacement. First surgery November 1st. Woohoo. I guess you can look forward to the after recovery side of it. I've heard the knee replacement surgeries go very well. And recovery is amazing once you have a new knee. Let's see. Not even allowed to barbecue here in Louisiana Southwest due to wildfires. How do you eat if you can't barbecue? Headed to the boat, says Bug Dugger. Mount Scott to have lunch on the mountaintop, then we'll go to the Lake Lawton below it. Texting drunks all weekend long. Convalescing. Gardening and canning, being a couch potato. Mixed media art projects. Okay, so we're going to stop accepting nominations right now, and I need you guys to scroll through and see which one is the best, and then let's all go there. Amateur Town Ball State Tournament, painting rocks, dipping, like skinny, or maybe are you talking like artwork? My mind went to skinny for some reason, then I couldn't think of anything else. I'm sorry, I apologize. I bet he regrets having those security cameras right now. Probably he does. Staying home and relaxing, staycation, laundry. Ooh, always laundry. Sprint car races, there's 2 for that. Staring through the window, crying, waiting for you to stream. Adam, I can picture this. I can see you doing that. Beach. Lois, that'll be great. Hope you have a fun time. Painting the kitchen, studying. Copious amounts of alcohol and possibly the pool, or maybe just sleep. What's RobCon? RobCon preparing for cosplay. I'm not familiar with RobCon. Is it like a Comic-Con, or is it Robbery Con or Robber Con? Are you doing true crime? Going for walks back at the lake. Getting a little bit of adult beverage. Closed today at House on the Lake, $25,000. We got a steal, and we're celebrating this weekend. Yeah, $25,000 House on the Lake sounds great. Sign me up. Let me know if you're going to sell it for the same price. Hanging out at home. Unique Detail says, "What's your P.O. box? I'm sending you a gavel and some awesome hair moss." I have a gavel. Tish gave me an amazing gavel, and not only that, it has this. But if you want to send me a gavel, I won't stop you from doing that. I just warn you that my kids will probably use it as a weapon against each other. If you type !box, I think it's, what is it, ! address? What is it? Help me here. I don't know my own codes. Is it box? It's address. I think it's address. There it is. There's the P.O. Box. P.O. Box 775 in Aden. That'll get to me. I forgot Dr. G's members only live tomorrow. Woohoo! I'll have to go over. I'm a member over there. Attending a hair convention. RoboCop. Let's see. You didn't see mine, says Dodie. I missed a lot of them because it updated and I missed a ton. San Diego State football game. Still going to be raking apples off my lawn so I can mow. Rudy, don't you know you just lower the mower down and just go over the top of them, and it fertilizes and you get this nice apple juice smell as well. The rain all went to the ocean. It is gone now. I don't have any more to give away. apologize. There's a ton of comments that I can't get to just because there are a million of them. Little Miss, I'm in North Carolina. The video we're watching is in South Carolina. This is the same place that Alex Murdaugh trial was held in Colleton County. Harleys are comfortable to ride. You've obviously never driven a Sportster. Sydney's crazy. I consider Harleys comfortable to ride because I rode a dirt bike for long distances. And getting on a Harley after riding a dirt bike is like getting off, the Harley would be like the lazy boy, where the dirt bike would be like sitting on the small end of a baseball bat with a doily on it for comfort. It's not, you can't even compare the two. Okay. Yes, it's like Comic-Con, but it's the artistic drawing side of comic books. RobCon. That's cool. That's definitely an art form that I do not share. I don't have that ability. Wendy and Jill both have birthdays on Monday. We might have to sing to you on Tuesday. Is that all right, Wendy and Jill? I hear like sawing, like somebody's cutting down a house or something. It's probably my kids. Okay, we're coming up on the 2 hour. Yeah, we're coming really close to the 2 hour, Kim. Watching the Houston Astros hopefully sweep the New York Yankees. What do you have against guys in stripes? No, good luck on that. Go team. Shopping for floor paint. Pussycat, we're approaching 1 hour and 52 minutes of verdict watch. So we're 2 hours. The first probably 45 minutes we had 3 or 4 questions. And then it's been quiet for a little bit. They might be watching video right now. That would be my guess. They just barely got a laptop provided to them so they can watch that. Can you get a lunchtime sing? Yeah, we can do that. Or call me on the burner phone. I'll serenade you just specially just for that. You're laughing that I know what a doily is. A doily is like one of those little decorative little knit. It's like, think of it like a placemat, but for something decorative on a table. Like it sits on an end table underneath a. Yeah, that's what it is. Let's see. I'm reading lots of chats that I can't put all of them on the screen. DMB says, I heard blasphemy against my Yankees. That's the problem. It's like, DMB, it's like with farmers. Okay, there's one farmer out there who just wants to plow his field and get seeds in the ground, and he's praying for dry weather, so the ground will be dry enough for him to plow and seed. And then there's another farmer who's already planted his seed and is just praying that the rain falls and the seed will germinate and it will take off. Somebody has to lose, unfortunately. Baseball is not like European soccer, European football, where both teams can score a goal and they can say, well, it was a good game, we tied. Somebody has to lose, unfortunately. Picture RGB neck collars on an end table lamp, under a lamp. Maribel, you're really sold on the 2 hour thing. You're going to call Monday for a special birthday sing. Sounds good, Jill. Doily is crochet. I've never made one. I just know they're all neat and fancy. I don't know how we stopped talking about true crime and court cases, and now we're talking about doilies and other things. Ooh, touring motorcycle is a BMW. Does the curves, kinda. It's comfortable, and the engines last forever. I have an older one without all the electronics. Like the one the police ride. What is that? Is that 1250 or something, or 1600? They're huge engines compared to what I used to drive. I had a 650. It's the biggest bike I've ever ridden. At least I've ever owned was a 650. I've been on Harleys, but I didn't own them. They're expensive. Rained here for 3 days. My tomato and pepper plants grew another foot. And now it's going to not rain for a long time. Your pepper plants are going to get spicy, really spicy. Julie, you lost the voting game. You got 5 minutes here. It could happen. A few friends going to a Christmas event, I think, in your area. Are you familiar? I'm about an hour and a bit. Is it worth the trip? I don't know what the Christmas event is. Is it the parade? If it's the parade, I would say yes. But not only that, we have a parade on, not tomorrow, but a week from Saturday. We have the one and only Collards Festival. Yes, where we celebrate the eating of greens that should not be ate. Yeah, we have the Collards Festival coming up. Maybe I can live stream that. Yuck, collards. I'm not a fan. I've eaten them, and honestly, if I had to, if somebody served me some and they had made them and said, "Here, I made these for you," I would eat them. But I could also eat lawn clippings and have a similar experience, and I don't like them very much. Anytime you have to use leftovers from cooking real food to flavor the food so that you can stomach it is not good. Another Stinking Verdict Watch podcast. It's in the works. I might have to take a look here at the rundown and see what's going to get bumped with a Verdict Watch. Dreamscape says, I love collards. Can you explain to Tara and the rest of us what collards are? They're greens, right? It's a plant that's like think of like, not spinach, chard. Okay, think of like chard, but more fibery and less flavor. And I mean, honestly, mow your lawn, bag the lawn clippings, add some water and let it sit for a while, and then sprinkle bacon bits on it, and you're pretty much dealing with collards. And I realize I can get shot for saying that where I'm at. But so collard greens. I'm just not a fan. I will eat them, though, if cooked properly. I don't think I've ever had them cooked properly. I'm getting hate from people. I'm sorry. I'm just not a fan. Now you want okra now. We've got some more motion on the screen. I was thinking something was happening. I'm sorry. How dare me? I said some blasphemous things against collards. Collards grow upright. You want the younger leaves as they're more tender. I've never made them myself. I've always had them like just served for me. I've ordered them at a restaurant, and it's just like scooped up. They're not, maybe this is the big thing, they don't look appealing. It's not something you look at and you're like, oh, yum. I mean, unless you've tried them and you really enjoy them and you're like, oh, I remember these are yummy. Just looking at it is not visually just like, wow. You know, that's a good cut of meat. I can say, wow, that looks tasty. You know, some of that rotisserie chicken at Sam's Club, I can drool over that all day long. But collards, I don't have that same, Pavlovian response. Who's next on the hit list? Brussels sprouts. I actually love Brussels sprouts. Maybe it's because I didn't try them until I was in England, and they were delicious. And nobody in my family likes them. I've never had them since I came back from England. Lots of people walking around the courtroom. I think that's the kid who set up the computer for the jury. He's with the state. Always put malt vinegar in greens. I'm a big fan of malt vinegar, and that works with our flavor of barbecue around here. We do a lot of vinegar in barbecue. Got a cut for meat for you. Wait. I've not, Cheryl. I've never tried okra. It looks too much like the fruit of a tree that I was told was poisonous as a kid. Just the way the okra is shaped, the flat sides to it. It looks like a poison thing I grew up, being scared to death of getting near my mouth. How do you fix your Brussels sprouts? I like them with salt, with steamed, and popped in my gob as fast as I can put them there. For a missile to the jury room. Everybody out. We need a verdict now. Excuse me. I normally hit the mute button for a cough, but I did not. Okay, we've once again switched. Oh, camera's shaking now. It's been 2 hours. Let me check the Twitter feed. Lots of motion in the courtroom. Nothing yet. I like my Brussels with a hint of trash bags. Oh, man. You're heartless. Roast your Brussels sprouts? Does it dry them out, or do they stay moist? I know I am not supposed to stay moist over here, but... I'm getting hungry as well. I did not take a lunch break. This is probably why we're talking about food. Every time I'm hungry here, the conversation deviates to my stomach. As soon as I try to take a break to get some food, the click has stopped on Court TV. Let me do some quick checking. It's funny that Murdaugh is trending right now. I'm not seeing the counter stopping. Did they pause it for lunch or something? Sprinkle with garlic, herbs. I think you meant herbs. Butter in air fryer oven. I still need to get an air fryer. That would be something I'd try. You promise to behave? I might go grab a little snack really quickly. It's been impossible to find corn on the cob. I tell you, I live in an area where corn is grown in abundance, but it's all for cattle, and so they grow the fields full of corn, and you've got all these amazing corn with ears of corn on it, and they just let it sit there until it just dries out to next to nothing, and then they just mow the whole thing down and mulch it into cattle feed. I'm like, why didn't you pick it when it was good? But I guess the cows eat it when it's bad as well. Coops just gifted 5 Recovery Addict memberships. Those went to Maribel Vega. Congratulations. Don ECT, Rick Thomas, the Kerno Kids, and Dave McMillan. Congratulations. Coops, that is super generous of you. Thank you, thank you, thank you. Like me, I love some sweet corn. But tell you, you know what I'm craving, and I've never had in my life, is a crab boil, or even a crawfish boil. And I think I'm far enough south that I should be able to have something like that. But I need somebody to sort of steer me in the right direction for that. That is not the kind of corn you want to eat. It looks the same from the road. I realize it's feed corn, but Lisa, unfortunately, it's not a. You can't exceed it. If the time passes what you said it was going to be, you lose everything. It's all or nothing. Lael gifted a membership as well. That one went to Wendy. You didn't have to wait for your birthday, Wendy. You got it now. Happy early birthday. Thank you very much, Lael, for that super generous gift. Would now be a good time to tell corny cow jokes? Dodie, probably. It's field corn, not sweet corn. Every time this dude stands up, oh, we do have the judges back. Judges back. We have at least a question. Let's see what's happening here. Should I play the music? They want what's the definition of murder?
We have a restatement on the definition of murder.
Can we have a brief?
They've asked you to recharge murder and malice, and you had a whole section in there. I think that's what they're asking. They asked for definition of murder specifically. We have no objection to them getting the definition of murder specifically.
And we have a restatement on the definition of murder.
Why doesn't
King, I don't think you can charge murder without charging malice. I mean, I think if they want to recharge, it's the full charge for Mr. King.
Okay, it was complete charge of murders only. Okay.
That's right. They didn't think it was particularly long.
I think that was, I'm going to recharge murder. Bring the jury.
Bring the jury. That was a quick decision. We're going to recharge murder. This is frustrating. If they keep doing this, I wonder if they'll just say, "Can we provide the charging documents for them?" South Carolina doesn't know what murder is. I don't know how they've lived this long and to have no idea what murder means, but that's where we're at. I would say this is not a good sign for the prosecution. They've got somebody who is very, very detail-oriented and probably like obsessive that everything has to be exactly perfect. Maybe somebody's got some OCD that's playing into these questions. I thought Letitia was from North Carolina.
Madam Floor Lady, members of the jury sent out a question: can we have a restatement on the definition of murder? I'm going to recharge you on the offense of murder. The defendant Rita Lincoln and the defendant Larry Eugene King, each charged with the murder of Christina Lincoln. The state has proved beyond a reasonable doubt that the defendant or defendants killed Christina Lincoln with malice forethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed. But malice must exist in the mind of the defendant or defendants just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. Excuse me. That is either by direct evidence or by inference from the facts and circumstances which are proven. The express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. Malice may be inferred from conduct showing a total disregard for human life. Malice can be inferred from conduct that is so extremely reckless and wanton as to indicate a depravity of mind and general disregard for human life. In the context of murder, malice does not require ill will toward the individual injured, but rather it signifies a general malignant, extreme recklessness of the lives and safety of others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. And that is a statement on the definition of malice. We return to the jury.
I agree. I would be nervous if I was prosecutors right now. This is the last part got it in that definition with malice. The first part of the definition of malice, definition of malice, I don't think they proved. But if you look at it just in the light of the last part of that definition, I think you could see it.
This is our acceptance to the charge.
No, sir, not from the state.
Moving on, thank you.
All right. I can wait.
Kayla Newell, welcome to the jury. You've upgraded to the padded chair. Great view. Also reserved seating as well. Congratulations. Thank you very much. Love that you've moved up to the jury. We sure appreciate that. That means everything to us. They overcharged in the Casey Anthony case, and that's how she walked, says Wendy. The fact that there's no lesser includeds. If we can't get malice, if we can't get murder, if we can't get, well, all it leaves is the grievous bodily harm to a child, which I don't know what the the penalty is, but I'm guessing it's probably a lighter penalty than most people think that these people may deserve if you feel that they're guilty of murder. Pussycat, it's not done yet. We just had another question from the jury at about 2 hours and 10 minutes. The jury asked, "What's the definition?" They said, "What's murder?" Yeah. There were no lesser includeds in the verdict forms, unless there might be, but they sure weren't read. The judge did not read. Judge Newman did not read the verdict forms. We didn't hear anything about lesser includeds. And I'm not sure if they'll walk. As somebody said earlier, you'd have to get 12 people voting not guilty to have them walk. It'd be more likely they have a hung jury. Babs Austin, welcome to the gallery. Thank you so much for joining as a member. One of the perks of membership is you get all the free custom emojis you can handle. So we have a ton of those. Help yourself to those. We also have reserved seating for you. So exclamation point seat would get you that front row seat reserved for you. You get to sit with your friends too. So that's exciting. If they walk from murder, can they be charged again for manslaughter? Or is that double jeopardy? I think that would be double jeopardy. I don't think the state would try to do that again. I think that would be double jeopardy. Only takes one to hang the jury. We watched the school bus pursuit again. Let's see. It's on our playlist. But Liven just gifted one Recovery Addict membership. Thank you very much. That went to Rhonda Rep. Congratulations, Rhonda. Thank you, Liven, for your support of the channel, for your generosity. Spicy Lady says they're hung. I'd rather be a hung jury than a not guilty. Yeah, I don't see a not guilty. That would really surprise me. I mean, that's like Florida jury type level results. We've seen some crazy results out of Florida, but the lesser included offense doctrine in South Carolina recovery, there does not need to be a lesser charge included. So they can go with a lesser. To me, the judge should have given the definition of murder is what happened in this case. Bradley, that would definitely be mistrial material. The only way you could get tried again for this, if they get acquitted on this one, is if there were federal charges for the same crime, because federal and state are handled differently. 6 volts ready for a bus chase. Going to go get the keys. If they have a hung jury, I believe they could change the charges and try again. Maribel Vegas says, can I say I've been watching trial since at least 89. Never felt so included. Thank you, friends. Thank you for being here. I appreciate it. We're a fun group. We take a lighthearted but also a sort of a kinder approach to a lot of things. So there's a lot of places you can watch true crime on the internet that have a little more of an edge than we do here. We just ask that everyone just remain friendly and respectfully share opinions, and we'll all get along. It's going to be great. What did I miss? Are they hung? Tower Hill Girl, no, we're just speculating right now. They've just asked another question, and unfortunately the question they asked was, what's the definition of murder? This is on top of what's the definition of conspiracy. So they've asked a ton of questions for the amount of time they've been deliberating. We're getting a little nervous. Part of the problem is the judge in reading this is his reading style does not lend to understanding the meaning of what he's reading. The way he breaks the sentences, the way he pronounces things and hesitates, I don't think it's helping them as much as the jury was hoping it would help. Live, and what I think happened is the state looked at this and they said, we have a child left in the car and we have video of the mom leaving the child in the car, and all these things that the common person would say, why are you doing that? You know, you idiot, here's what you should do. So they said this should be an open and shut case. But when you hold that up against the actual letter of the law and the elements of the different charges, there starts to be just little weak areas that might come back and bite them. And if this starts to crumble, I mean, if they can't prove malice and they say, okay, so there's no murder, and if there's no murder, there's no conspiracy, and we could go with the harm of the child, but if they thought the air conditioner was on, this whole thing could crumble like a house of cards. Let's see. Hang on. I'm not sure who this is. One second.
From SDS Technology, System Development Services. To accept.
Hello.
Hello.
Hello. Who am I speaking with?
Vanessa.
Vanessa. How are you doing?
I'm good. How are you?
Doing fabulous. What's on your mind today?
Okay. Have a good day. You too. I have an opinion.
Okay.
You as well. About the case. I believe that they're going to come back, find it not guilty, probably.
Really?
Yeah. I think that while she did die, maybe involuntary manslaughter, maybe. But I kind of feel like it's going to be a Casey Anthony thing.
Oh, man. That would be tough. That would be tough for everyone who's, people would look at that and say, where's the justice for that?
Yeah, I agree. I just don't know. I just don't know that they had enough. Yeah. I mean, I think they are at fault. I just don't know murder. Probably not.
I bet if we had audio on the security camera video, we would have enough.
I think so. With them
maybe,
talking and.
So maybe it's just the idea that we don't know exactly what's going on, and we're trying to guess at what's happening, and it might look like this, but we're not sure. That level of doubt is enough to say I can't be sure what happened.
I agree. I agree as well. I think if there was a lot more audio there, I think that they would get it. But I am.
You're
I'm
calling
just
it
kind
now
of feeling
not guilty on
both.
both.
Just as the questions that the jury is asking and things, I'm kind of leaning towards.
I don't know how
I
you
don't
can
know if
be
they're going to get it.
sitting on a jury and not know what murder is. Okay.
Yeah, that was odd to me.
But yeah, man, I hope you were wrong. I really do.
I hope I'm wrong as well.
But thank you for sharing the opinion. I appreciate that, Vanessa.
Yes. No
Thank
problem.
You. Good to hear from you.
Thank you.
We'll see you.
Bye-bye.
Sean B was asking this before Vanessa called. Thank you, by the way, Vanessa, for the call. Says, Scott, what did you do before your channel? Before this channel, I actually have had this channel for years, but it was a metal detecting channel, and I posted very little on it for a long time. Before I did this, I worked in a classified position with the federal government as a contractor. So I did just some fun computer work. And it was really cool. I worked with some really awesome people. The work itself was not like life-changingly like interesting or fun, but the people that I worked with there were just amazing and fun to associate with, and some of them even find their way in chat in here occasionally. But it was a lot of fun. I was a spy basically, says Mr. Upper Torso. Thank you. I was not a spy. I had a really cool security clearance, which they don't like me having any social media, so is what it is. I've got a clearance high enough that I've ever write a book and I talk about security stuff, I have to get it cleared through the government before it publishes. I was not an ethical hacker. That would have been fun, but no. Sean, they're overrated. Let me just say, it's not fun. The higher the clearance, the less you can do. You think, oh, I want to go on vacation, and now you need to get approval, and it can sort of be vetoed. It's like, oh, you can't go there. Sorry, there's an issue. You can't go to that country that you wanted to go visit. Cancel your trip. All right. Anyway, it was a fun job. It paid really well. It was really fun. It paid enough that I was able to go 7 months without a job, looking for another one. Once I finished my contract there and moved my customer off to a different data center. So looking for another job for 7 months that kept me in North Carolina where I wanted to be. I just couldn't find anything that was in the right realm, and so I started live streaming, and I've been doing it since then. It's been an amazing, I think 9 months now. Why don't you have an accent? I'm not from North Carolina. I do have an accent. People say I have an accent, especially when I say words like color, which I say correctly and everyone else says wrong. I'm not sure why, but that's it. Very British. Welcome. Good to have you squeeze in here. We're in verdict watch, almost 2.5 hours of deliberation here. I have an American accent, says Jim Bub. Scott Bond. Shaken, not stirred. They made it very difficult for him to get his security clearance. Yes. Where are you from? The Intermountain West. I thought you were going to get something to eat. I was, and then chat happened, and I didn't. Yeah, that wasn't very specific, huh? I could say I was born in Logan, Utah, right up the very north corner of Utah, up by sort of like the Bear Lake area, if you know that area. That's where that was home. It's not really close to Bear Lake, but that's just the largest thing on the map that puts you in that area. So just a stone's throw away from the Pepperidge Farm factory. That's what everyone might recognize. Technically, I have 2 jobs now. Franco, yes, you've been here for the long haul. It's nice to have a courthouse by your name now, but yeah, thank you very much. Okay. All right. So if I put, Sean B says, thanks, not trying to be nosy, but interested. You can ask me questions too. All right. Let's ask Sean a question really quickly. How many traffic tickets do you have, Sean? Like moving traffic violations? I'm not going to ask what they're for, but just how many. Hippie Chick says, I've been to Logan. We lived, when I was born, we lived on what's called the island. And there's not many islands in Logan, but there's an island. The river splits, and we lived on the island. Sadly, a little kid drowned up there when I was a little boy. He fell into the canal, and they found him way downstream. Uncivil Law says, I have doubt. You have doubt as far as this case goes. You think it's overcharged? I'm not sure I can find malice as defined by the instructions. It's only the last part of that malice where they say you didn't have to have like ill will towards the person, which is sort of weird because the whole first part says you have to have ill will towards the person. But that's yeah. If you can't find malice, then does that mean we can't have murder? Is this our logical progression, Kurt? No malice, no murder. No murder, no conspiracy. And then all we're left with is grievous bodily injury to a child. And honestly, if we don't have the other two, if it's accidental, would you still? Yeah, not sure. Anyway, Kurt, welcome. Good to have Kurt here. Kurt is a big-time YouTuber, if you don't know. You should. An actual lawyer. Are you in Virginia still or Texas? I don't know where you're at. Kurt, I think aren't you like licensed to practice in both states? No, I have not eaten today, Mrs. R.A., but I would really like to eat today. Are you offering something?
No, I was just curious.
Oh, you're just curious. You just want to rub it in? Legal Vices is from Logan. That's the only reason I know about that town. I didn't know Legal Vices was from Logan. Motorcycle zipping by. Since they charge malice murder, that would be exactly what it means. No malice, no murder. And that's the big one as far as the charge goes. The sentence, the one that carries the most weight is going to be the murder charge. The rest are smaller. I think we're talking probably half the sentence. I don't think conspiracy will get you a life sentence. I don't think even grievous bodily harm to a child would get you a life sentence. Texas and Virginia. Yep. I knew it. It was the hat that gave you away. And I knew you were in Virginia for a while. Let's see. Sounds like you're either at a sawmill or an airport today. That was actually, this is funny. That was a drunk sickle that was driving by. What's a drunk sickle, do you say? A drunk sickle is a motorized conveyance that is legal for people to drive on the street when they have lost their driver's license. So yes, if you get too many DUIs, your driver's license gets taken away here in North Carolina, and then the state of North Carolina says, oh, that's too bad, you can't drive because you don't have a license. That's okay. We'll let you drive without a license on the same streets. The only catch is you have to be on a moped, and it has to be 50 cc's or smaller. So it's a tiny little moped, and you zip along on the street on this moped, and the problem is you can't get up to speed. And so what do? They take the exhaust, the muffler off, because they think that gives them a little more power. And so you got this like little tiny moped that's roaring down the street at just like with 2 extra horsepower or something. And that's what was driving by. In Austin at the moment, thinking of moving to Houston. That sounds awesome. I've visited Houston and was thoroughly intimidated by the road system there. Although I like the idea that there's like the main road, the main freeway going through, and then there's always like this side road as well, so you can take either one. Like the company I used to work for was based out of Houston as well. Way back in the day, Metal Building Components Incorporated, part of NCI. Hey, Mrs. R.A., Coop says, Mrs. R.A., please feed your husband. We can't stand hangry. What happens when you get a DUI on a moped? Patricia, it's another DUI, but you still get to drive the moped. No matter how many DUIs you get, you're still allowed to drive a moped without a driver's license. We actually had a drunk sickle driver wreck and crash right out here in the corner. So he was drunk and crashed his drunk sickle. I have granola bars. I will survive. What about a lawnmower? Lawnmowers you cannot drive on the street here. I'm in a small town, and so yes, I drive my lawnmower on the street, but the cops aren't going to do anything about it. If you were driving it and trying to like go places, that would be an issue.
Call from Fun and Funky.
Fun and Funky, hello. How are you doing?
I'm good, thanks. How are you?
I'm starving, but I'm about to fix that as I have a chocolate chip granola bar that I'm eyeing hungrily.
I see you've got snacks.
Yep. What's on your mind? I'll take a bite while you talk.
You do that. Probably an unpopular opinion. I absolutely love Judge Newman, but he seems a bit snarky in this trial. Do you agree? Can't say I blame him because Peter Griffin just doesn't shut up. But he does seem a bit snarky. However,
You
that's
call him
not what
Peter
I
Griffin?
found.
You called him Peter Griffin?
Peter Griffin. Phillips. Is it Phillips? Peter Griffin. He looks like Peter Griffin. Anyway, the reason I phoned, just to put my 2 pence in, is I don't think they can be charged with murder. I don't think it was premeditated. But personally, and I don't know the law, I think there was a conspiracy to cover it up. Because when we saw the little bit we saw when they came back from getting the key, it all seemed a little bit staged.
Yes. So maybe, are you saying we could have yes on the murder, or sorry, no on the murder, but yes on conspiracy?
Yes on conspiracy, and yes on, is it neglect or what the other one was? I think they'll go
the grievous
guilty
bodily
with
harm
the
on a
2
child.
charges. Yeah.
Okay.
Personally.
So that would probably be, I'm just guessing, I'd have to look at the actual statute, but I'm guessing less than 20 years each as a maximum sentence.
Yeah, it's a bummer, but, you know, anything's a bonus.
Yeah.
I just don't think murder is strong enough that the prosecution should have brought in an expert from VW, in my opinion. And I don't know if the 911 call was not in their favour, and that's why we didn't hear it. But it's very strange not to hear a 911 call from the number of trials I've watched.
Yep, that was weird that we didn't get to hear that as well. But man, I'm getting nervous the more we talk about this. I'm like, man, look at Tommy from the trial we watched just a little bit ago. He was tried for murder for his second wife. And they went for everything on that one. It was capital punishment. They wanted for the death penalty, and the jury just couldn't quite get there, and he ended up walking. I'm wondering if that's what's going to happen here.
Yeah, I wouldn't like to be on the jury. Put it that way. I wouldn't like to be on any jury because I'm a stubborn cow, and I already make up my mind.
What if you were the jury foreperson, though? Would you like to be in charge of the jury and sort of steer the conversation that way?
No, because my opinions are too strong.
Well, that might be.
I need to be convinced. Well, maybe. I like to hear other people's opinions, don't get me wrong, but, you know, I'm quite hard to budge. So, no, I wouldn't want to be the foreperson, but I might be the one that makes it a hung jury. Put it that way.
Wow. I admire that, first of all. If you are convinced of something, sticking to it is important on a jury. Don't be the one that says, "Oh, I'm the only one who feels that way. I guess I'll change." That's not how the system's supposed to work. But I do agree with you.
Yeah, but talk's cheap, isn't it?
Yeah, Judge.
I've never been on a jury, so talk's cheap.
Judge Newman has been a little bit snippy, a little bit, and maybe it's the pre-trial stuff that's led him to this. That he just really doesn't like these guys, but he has been got a little edge to him. So.
Well, day one proved that, didn't it? When he was like, "I told you to do this before today."
Yeah, he doesn't like you wasting the court's time. Fun and funky, thank you very much.
No, he doesn't like wasting the jury's time either, which I respect. Anyway, I just thought I'd phone in and give my 2 pence. So lovely to speak to you. Have a good long weekend.
Hey, you too. Thank you very much. We'll see you.
See you, bye.
Bye. See, now Fun and Funky has an accent. But oh my goodness, Peter Griffin. I can't wait to see him again. We should do like a side by side with Peter Griffin and this attorney. That would be funny. Let's see. Thank you, Samantha Terry, for serving up videos on request. It's better than YouTube. I don't think the jury heard the 911 call. I don't think they played it in this trial. I think they really thought that they had such an open and shut case because of the video that they went light on it. The caller was not from North Carolina. No, it was a UK number, so that's going to be a UK sound. England. Peter Griffin from The Family Guy. Yes, that's the reference. I I can't wait. I'll have to look at him and see again. Now I've got Peter Griffin's image in my head, but I can't imagine what the lawyer looks like.
All right.
Whoa. Another surprise.
Please be seated.
I understand there's a verdict. You may bring the jury.
We have a verdict. Oh my goodness. There's Peter Griffin right there. Wow, everybody's nervous. Everybody's nervous. This is 2 hours and 40 minutes, and that's a generous time. We started that watch before they really got their paperwork. So I'd be surprised if I would not be surprised if the actual count was somewhere under 2 hours and 30 minutes officially.
Madam Forelady, if you'll stand for me. Have you reached a verdict?
Yes, we have.
Is it unanimous?
Yes, it is.
Okay, if you'll pass it to the clerk, who will pass it to me, and you may be seated.
The bailiffs are standing by behind both defendants.
Okay, if the defendants will rise, and Madam Clerk, if you will publish the verdicts.
State of South Carolina versus Rita M. Pangalagan. Indictments number 2019 GS 15-00781. 2022 GS 15-00710, 2022 GS 15-00814. We, the jury, in the above caption, on the charge of murder of Christina Ann Pangalani, find the defendant guilty.
Oh my God! Oh my God!
We, the jury, in the above caption case, on the charge of great bodily injury of the child, we find the defendant guilty.
Oh my God.
We, the jury, in the above captioned case, on the charge of criminal conspiracy, find the defendant not guilty.
No on the conspiracy.
And it's signed by the foreperson.
This.
Yes. No, you don't need to call the name of the foreperson. Signed by the foreperson. Do
Signed by the foreperson.
Yes.
He may walk. Just wait.
State
Just
of
wait.
South Carolina versus Larry Eugene King. Indictments 2019 GS 15-00780. 2022 GS 15-00709. And 2022 GS 15-00813. We, the jury, in the above captioned case on the charge of murder of Christina Ann Pangalani, find the defendant guilty. We, the jury, in the above captioned case on the charge of great bodily injury on a child, find the defendant guilty. We, the jury, in the above captioned case on the charge of criminal conspiracy, find the defendant not guilty. This is also signed by the foreperson.
Thank you. Madam Lady, and members of the jury, if that is your verdict, please let it be known by raising your right hands. All right, thank you. All hands are raised. The verdict appears to be a unanimous verdict. Any individual polling requested?
No, Your Honor. Yes, Your Honor.
Yeah.
Hey, Madam Clerk, if you will poll the jury as relates to the verdicts involving Miss Panalangin. Just juror numbers stand individually and pose the questions to them. Is this your verdict, and it's still your verdict? Numbers, yes.
Madam Foreperson, jury number 3, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Jury number 147, is this your verdict? Is it still your verdict? Jury number 56, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Jury number 5, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror number 77, is this your verdict?
Yes.
Is it still your verdict? Yes. Juror number 339, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror number 58, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror number 450, is this your verdict? Is it still your verdict? Juror number 32, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror number 12, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror number 422, is this your verdict?
Yes.
Is it still your verdict?
Yes.
And juror number 253, is this your verdict?
Yes.
Is it still your verdict?
Yes.
Your Honor, the jury has been polled.
The jury has been polled. It's a unanimous verdict of guilt. Any post-trial motions?
Yes, Your Honor. We would renew all prior motions, mistrial motions, every other motion I've made, as well as the verdict on pre-trial, mistrial, and I'll go specifically through them at the appropriate time. Renew all motions.
He's throwing everything at the wall.
All right. Yes, sir.
Plus, I renew all my trial motions as well as post-trial, subsequent to the state's motions. All motions.
All right, thank you. Any response by the state?
Yes, sir.
All right, the matters were properly submitted to the jury for the jury's consideration. They studied the evidence carefully. The evidence was appropriately placed before them for their consideration. They have reached a verdict that is unanimous, and the court respectfully denies each motion made by each defendant.
And would require at this time to move for a new trial as well.
Yes, sir. And the court likewise denies a motion for new trial as to each defendant.
He's trying everything. He's got nothing.
Ladies and gentlemen, I want to thank you all. I know you all didn't know what you had in store coming in here Monday, and you might have come in as spectators and all of a sudden got thrown into the mix and realized that the burden was totally on your shoulders to listen to the evidence and stay focused and go back and deliberate to reach a verdict. Quite obviously, it's a heart-wrenching set of facts and circumstances, extremely terrible, almost unimaginable, but yet these are the facts of life that we have to deal with in today's environment. Some things occur that are so extreme you just wouldn't believe or couldn't hardly believe it to be true, but you've realized through listening to this case that these things happen, and it happened in this case. And I want to thank you for responding to the call of duty and serving as jurors played a very important and critical function. Certainly, if you had to find yourself being involved in a trial one way or the other, you'd love to have 12 jurors who listen, who take the job seriously, who deliberated and render a verdict. And I want to thank each and every one of you. Now, Mr. Engineer, what type of engineer are you?
Mechanical.
Mechanical. My daughter's a civil, and I presided in Aiken County, where there are a whole lot of engineers, and I usually tell the lawyers, don't put any engineers on the jury because they have a hard time. They analyze so much that they it's being an engineer. So, but of course, I never tell her that. But that's the way it is, depending on your training and profession and your level of expectation on things, and I appreciate that. And that's what makes for a fair and impartial jury to have people from all walks of life that can come in and deal with things. And our young man, are you the youngest on the jury? I want to thank you for having confidence in yourself that you can be a juror and to do something that you probably didn't think you could do, but you did it. So I want to congratulate you and everyone else on the jury. I know that it wasn't easy for any of you, but that's our system and our system at work. The case was investigated. The case was presented to the grand jury of this county. Then the case was presented to you all, and you all have made a decision. And I support your decision 100%. Now, when you find someone guilty, then it becomes my responsibility to impose a sentence. And are you all, do you need time to prepare for sentencing?
No, I'm ready, but my client may need a minute to speak with me about it.
Pardon?
I'm prepared, but my client may need a minute with me right prior to moving into the sentencing phase.
Okay, very good. And you all,
Understood.
I need to stay in the courtroom at this point, but you certainly can confer with you want to transport people now? You banned him from the courtroom earlier. He's ready to. He's come back.
Well, just need to speak with you, Your Honor.
Okay, sure, absolutely.
He wants to speak with his client before sentencing. It looks like sentencing is going to happen right now.
So, ladies and gentlemen, you have no role in sentencing. That's totally the responsibility of the judge. I have found that jurors typically like to see what happens all the way through the end of the case. I'm certainly in no rush to impose a sentence because this is such a tragic situation. And as people appear in court, they're typically, or quite often not, they don't appear the same as they appear when they commit the crimes. But you're welcome to stay, and you can just be at ease for a moment while Mr. Phillips confers with his client. And I'll say that once you are off the jury, then you're free to talk about the case with anyone that you might want to talk with about it, but you're not obligated to talk with anyone. And if anyone should annoy, harass, or bother you in any way, let me know, and I'll take care of it. Any interference or threatening or bothering jurors is punishable as a serious crime, and we take those things seriously. I don't anticipate that you have anything to worry about, but we keep the identity of jurors private, except for the forelady. And but you're certainly welcome to talk to anyone that you might want to. And, so we're going to take. Are you ready now?
If Your Honor's not dismissing the jury, I guess we will.
Yeah. No, I'm not going to dismiss them. They're free to go or free to stay.
I'm not hearing them go.
We'll just be at ease for just a moment. We'll step out for just a moment. We'll be at ease for a moment.
He just about tripped off the stand. A little late on the all rise part. Okay, so the jury's here. The judge is gone. This is interesting. Normally doesn't happen in that order. The mics are still hot for at least a moment. And now we lose the mics. Okay. So what's happened is everyone's prepared for sentencing. The judge said the state's ready. The Larry King side is ready. Rita's lawyer is ready, but Rita might need a moment, said her lawyer. He gave them as long as it took him to basically dismiss the jury, which they haven't really been dismissed. They're still sitting there. They can leave now if they want to, but I don't think they know they can. And so he's taking just a moment, and then he'll come back in and we'll get the sentencing. And it's quiet all of a sudden without all that background noise. It's one thing that's been pretty painful. I have a headache at the end of each day listening to this with headphones on, especially trying to make the sound as good as I can for you. How many years are you thinking? Well, since they went with murder, I think they'll be 20 plus. He never said you can go, so my butt would be glued to the chair, says not the mama. Not the mama. I would say for sure. Yeah, nobody got up and left when they said they could go. At least we didn't hear anything. Hear them get up and go. 10 years, says Joanne. 20 for Ace King. Life without parole, says listen to learn. I'm not sure if they can get that high. I think they might have needed the conspiracy charge with it to get that high. 35 is reasonable. 15 years. Is there a minimum mandatory? I'm not sure in South Carolina, minimum mandatory for murder. This would be a very difficult poll to do because the options are so vast and we only have 4 available slots for a poll. This is what we're all sitting here for, Samantha. We want to hear Judge Newman let loose on how he really feels. And he might actually let loose a little bit on the lawyers as well. We'll see if that's in there. Sometimes he expresses some thoughts on lawyers. I'm not sure if he'll do it there in this portion or not.
Please be seated.
Oh, that was quick. Here we go.
From the state.
Your Honor, I don't believe that there's anything I can add that you don't already know. You've seen this case, you've seen all the evidence, as has the jury. I don't believe there's anything I can add to that other than just my opinion, which is it is one of the worst things I've seen in my 30 years as a prosecutor. And I think they tortured this child. I think she died by being tortured to death. And I think the appropriate penalty is life in prison for both of these people.
Any victims want to say, do you have any victims here who might want to speak?
We have a
or
few
victims representatives, yeah.
Yes, sir. We have a few family members. We've talked with them, and they do not wish to address. I believe I will check one more time, but I do not believe.
If you want to identify for the record, family members.
There's
some family members here, but they do not want to address you. They don't want to address the board.
Do you want to identify them for the record or no?
I'll ask. Yes, sir.
All right. Very good. For the defense.
Your Honor, I can bring Mr. King forward. We're prepared for sentencing at any time. We prefer to have our own sentencing hearing as opposed to side by side.
You surprised to prefer to do what?
To have an individual hearing in front of the court for sentencing rather than the two of us come forward. Mr. King would rather stand alone.
Yes, sir, that's fine.
Oh, should I bring him now?
We'll bring him forward for sentencing, but you can speak to me now, and I may speak to him as well.
Your Honor, and our presentation is not going to be long. Mr. King has testified, so you know something of his background and his history. What the solicitor says there's not much that he can add is because Mr. King has not lived a life of crime. He doesn't. To my best of my knowledge, he has no general sentence history. There's a couple of maybe drinking in public or something like that, but that is the extent of it. Mr. King is also not the type of person who's not going to accept responsibility. I felt like he made a good impression on the court in his candor. He told things that were both bad for him, arguably, as well as good for him. He put it all out there, and he accepts the judgment of the court of the jurors in the court today. Unlike many folks that I have stood with in the courtrooms, when the verdict came in, and it came in poorly for him, he took it on his feet. He didn't say a word. When he sat down, he turned to me, shook my hand, and said, "Thank you. I know you tried your best for me." And then he turned to Mr. Gatch and shook his hand and said, "Thank you." He doesn't make excuses. He accepts responsibility. I want you to know he has been supported in court by his family. He's not one of those people like you see so many of in court at general sessions who has burned every bridge and just dropped no friends, no family, etc. He has maintained connection. I spoke with him on the phone yesterday talking about this proceeding. He told me don't worry about him. He was having a good day. His grandson was with him, and he got to play with him and hold him, and that was what he wanted to do on that day before he came back to him. I know how terrible this child died, and I felt like I conceded that to the jury at the outset. I also know to a large degree how Mr. King has lived his life up to that point and how he's lived it since. And although he is convicted of murder, I will submit to the court that the overall evidence, the total picture that you should have of Mr. King at this point is just not of an evil man. As you heard from the witness stand, he did go, subsequent to this instance, moved into a halfway house or a treatment facility in Spartanburg. He reconnected with his own religion. Says he's been clean for 2 years and he's clean here today. Judge, I understand and he understands what limited latitude the court really has here today as far as sentencing goes. That is from a 30-year to a life sentence on the murder charge. And obviously the other charges just roll into that, I suspect. You've got unlimited, you've got from now to the end of time with the murder charge. I would submit to you, and I don't know if at 46 years old, which is how old Mr. King is, it'll make a ton of difference in the long run. I think he is worthy of some consideration from the court, and I believe you should come in on the low end with that, and that's a 30-year sentence. I know that Mr. King wants to address you personally. He hasn't reviewed his remarks with me, but he has asked me, can he address the Honor? Is the Honor prepared to hear from me?
Yes, sir.
Your Honor, I just wanted to apologize to the court, to the family, Christina, and I'm truly sorry, and it ain't a day that goes by that I don't live with them. And I want to say too, drugs will poison your mind and ruin your life, and I've learned that. And I've learned too that you got to stand and stick by the ones that love you and want what's best for you, and run from the ones that don't. I'm just grateful for God's undeserved grace. Thank you.
Your Honor, I believe that's our presentation.
All right. Any reply from the state regarding Mr. King?
No, sir.
Mr. Phillips.
Thank you, Your Honor. I'm going to show the state I have a list of character letters I'd like to hand up to Your Honor. A lot of family and friends. She has an incredible family support system, friend system, and many of them have provided letters in support and mitigation. And I'll wait and give Your Honor an opportunity to review this. A lot of letters, so.
First letter, I know this wouldn't have happened if she wasn't with Larry King. She's paid for her mistakes.
This is not oppressing the judge.
She's been working and recently was married.
This is not going to go well for her. Yeah, that was not what you want to say.
She's not a criminal.
He's reading off things that he's not happy about.
She's a good person. She's not a criminal. Please don't let this one stupid mistake define who Rita really is. Please consider leniency, Judge. So that's one of about how many? Kind of number there.
We also have family and friends that are here to speak on her behalf at the appropriate time.
All right. Next one, she made a horrible mistake. There isn't a person in the world she doesn't love that loved Christina more than Rita. I don't feel that Rita deserves to spend the rest of her life in prison. People learn from their mistakes. She made the ultimate mistake that day. I believe she will take that off a day and teach people that the dangers of leaving a child in a hot car. I hope that lapse of judgment could result in the ultimate reality. She's an awesome mom and grandmom to her family, which she wouldn't hurt anyone. I'm asking the courts to find her not guilty and let her be and take care of her rest of her family. Again, I'm asking the court to find Rita not guilty. Next one. I'm writing this letter for Rita, my mother, so we've heard from her, Elizabeth Clyde, already. Okay. And you want me to read this letter as well?
She'll speak. It'll be fine.
Okay.
Yeah, I think this is going to backfire for Rita.
Letter from a cousin. Rita always wanted to be a teacher. And nothing has ever come easy for Rita. When she fell in love with a boy from the Philippines named Wally, my uncle went nuts. After the first grandchild, things settled down. Rita and Wally had 3 girls, the last being Christina. She supported Wally with his endless years in college and supported the family until Wally could open his own medical practice as a chiropractor.
Where's Wally now? Or I guess where's Waldo? I don't understand what that has to do with this.
We met Rita 2 years ago. She's a caring Christian person who loves her family and working 2 jobs to help her husband financially. She cherishes her husband, children, and grandchildren. One of the most caring, supporting persons I know. She's been a flawless as a co-worker and team player. There have been times to date where we would sit and discuss the powerful Word of God, FaceTime, reading the Bible together. She's an amazing woman, influential in her faith and in her life.
30-year minimum. 30 years is the minimum.
And this is one from her husband.
He's here as well.
He'll be speaking.
At the appropriate time, you guys wish to address the board.
Rita sat him down to explain the incident. Early in the relationship, it did not change the way I feel for her. I fell in love with her from inside out. She's humble, inspired me to pursue my lifelong dreams, cries herself to sleep. I know she misses her daughter. Knowing that she will be reunited with her daughter one day, gives her hope and strength. Rita says Larry would never have put Christina in that car if it wasn't running with the AC on. I believe the statement is a testament to her humility. I don't pay attention to the negative, misinformed reports on social media. I have faith in our attorney's ability to present the truth. I plead for leniency. I want my wife to come home, whether it be probation or house arrest. She has problematic kidneys and a history of cancer. The next person met her 3 or 4 years ago. My name was Wanda Clyde, our daughter by choice, Rita's daughter. Shocked when Christina died and shocked to learn the surrounding circumstances. I know she was under tremendous stress being a single parent, taking care of a special needs child. I know this was a horrendous accident and ask for the court's mercy.
Respectfully, Your Honor, I've never seen this done like this before. I just
Yeah. What do you want? You want me to review them or no?
Yes, Your Honor.
Well, yeah, every person has their process of doing things. You want me a special way? You want me to review what you gave me?
No, Your Honor.
He's objecting to how the judge is reading these letters and picking them apart. And at the same time, he wants the judge to read all the letters.
She's always involved with her daughter. She pushed Christina around the track. Welcomed me into her family. This is from a son-in-law. Character reference. Known her almost 4 or 5 years. We met at IHOP. Was honestly the best coworker I've ever had.
Coworker at IHOP wrote a letter? Man, that's going above and beyond.
It was helpful to her when she was pregnant.
I can't do music. It's so hard to hear because of the noise in the courtroom. It would just make it impossible to hear what's going on.
She's a spiritual and godly woman. Goes to church almost every Sunday. She's not a murderer. What happened to Christina was an accident. I've known Rita, and I believe that she thought the air conditioner was on and this was an accident. She does not deserve this when she's been tortured enough herself.
Okay, thinking the air conditioner was on, but how do you account for the 5 hours?
She's punished, give her house arrest. From an elderly retired man that's also disabled, who Rita showed him nothing but kindness. He used a walker to get around. She's paid for his meals. Whatever happened to Christina that day was not on purpose. She does not have an evil or malicious bone in her body. And a letter now from the eldest daughter. Is she here? And she intends to speak.
Yes, Your Honor.
The eldest daughter, is that the one that also had an incident?
Plead for the judge to show her mercy. Never been in trouble before. Pleading for Rita's freedom. I am begging for leniency and understanding, as well as an unbiased, fair trial. House arrest is the ideal discipline.
I think almost
when
every
they try to harm her, she is sent
arrest.
to prison. She's already suffered. Punishing her will not bring my sister back. Someone who has helped translating this letter because her English is not good. Who apparently runs a restaurant where the daughters would come to eat and spend time with their mother. Has so much love for her child. I know in my heart this was an accident.
It wasn't to die, but they did leave her kids in a car.
I've seen Rita cry at work sometimes over Christina. She does not deserve any further punishment. And from a tax advisor, witness her financial struggle in the face of a difficult divorce. Prepared her taxes. She has a heart pure of gold. I'm aware of the charges, and I truly believe it was not intentional. Just not thinking clearly at the time. She is hardly remorseful.
I think a lot of these people are aware of the charges, but not necessarily aware of the video and all the facts.
She's a devoted and caring parent, as a teacher, I was blessed to teach her daughters who are honor roll students. She supported her during her difficult divorce and becoming a single mother. Friend for 25 years. A supervisor since 2023. She can run circles around the associates who are young enough to be her children and grandchildren. She's known as a workhorse. Rita has called on me as her spiritual advisor, a pastor at church in Georgia, and she's given her access to her personal life. She loves children, and she has a great support group with family, friends, co-workers. Encourage this person to go to school and finish their education. She would never commit any other crime. Feels as if she's been sentenced already. This one knows her through her ex-husband, who's this person's third cousin. Always quick on her feet. She has good moral character. She's been under pastoral counseling and care. Has frequently shared stories and moments that she and Christina shared together, cherished moments.
Mrs. R.A. brought me some tilapia and rice.
Has a deep-rooted love for her family and wholeheartedly vouch for her character, integrity, and altruistic nature, her resilience in the face of adversity, her unwavering love for her family, and her readiness to serve those around her. She's an exceptional individual. And finally, school principal for 8 years. She was the school principal for 8 years. She was transferred in 1996. Thrilled when she was allowed to transfer to her school, continued to work as a first grade teacher. A good relationships with her students, parents, co-workers. Worked on morning bus duty, would monitor the students.
This is normal, Judge Newman. I know it's not normal for every other court, but this is normal for him.
She's a math coach. Took her job as an educator very seriously. Volunteered for many things. I had a very loving relationship with her two oldest daughters. Christina was born later. And she saw what was placed on Facebook. She's the person who testified, Mrs. Carter. So this is similar to her testimony. All right, I reviewed the letters.
Yes, Your Honor.
There are people who want to speak on Rita's behalf.
And we'll make all of these letters a part of the record. Yes, ma'am. Tell us your full name.
Ashley Elaine Pangalangan.
Yes, ma'am.
I was going to read my letter, but that's not the best idea here. I just want to tell you a couple of things that would never be known, that I'm not even sure if my mother knows that I know this. But a family friend of ours a couple of years ago told me that one day my mom was at Christina's graveyard, and she was sitting there.
Tell me what you just said.
My mother, Rita Pangalangan, was at Christina's graveyard one day visiting her. I think it was Christina's birthday a couple of years ago, and that she sat in the car and rolled the windows up herself in the heat at the graveyard because of how terrible and awful she felt about what happened to my sister. She tortured herself every day. I have to hear her cry every night when I stay with her. She's not been allowed to visit my babies because of this. She already has suffered so much to the point that she rolled herself up in the car just to see what my sister went through. She's not even aware that I know that.
How long did she stay in the car with the windows rolled up?
I never asked, just the thought of it. She's tortured herself. She's suffering. I know it looks awful, but I know in my heart that she never would have intentionally done it. I love her to death. I wouldn't be here today without her. Her love is very strong. She's a good mom. I know, like I said, that sounds cliche at this point, but from the bottom of my heart, she's a good mom. She raised me good. She made me responsible. She made me the woman I am today. I'm a homeowner because of her. I stand on 2 feet because of her.
When did you leave home? What year?
Well, honestly, I never felt like I left.
No,
I mean, I have my own house, but I stay with her every other weekend. We're very close.
Were you staying with her during this period of time?
Yes, sir. I've been with her every day. I mean, she's lost probably 16 pounds in the past 2 months just because we've been scared to death. I've seen her. I've been going to church with her. I admit I haven't before recently, but I've been starting to go with her now. She's made me more spiritual. She's given me faith that I never had before, and just to watch her in church and raise her hands up and sing and praise God, it's done something for me, because to see her have that strong of faith in her situation means that I can have it too. I just felt like it goes without saying, if everyone in the room could have just hugged her for a couple of seconds, they would know what the verdict should have been. And they just could have held her like she's held me. Thank you, sir. That's all.
Thank you.
Do I need to state my name again?
Yes, ma'am.
My name is Elizabeth Pangalangan Clyde. I am the second daughter, as you already heard. If anything, I hate the word victim because, if anything, my sister and I, we were the closest, besides my mom, to Christina. And we're here standing by her side. We refuse to believe any of the media. We refuse to believe what anyone else has to say because we know her intention. And she loved Christina so much. She made bad mistakes. She got up. She hung out with people she shouldn't have hung out with, but that mistake should not define the rest of her life. We've already lost our sister. Please don't take our mom away. She has worked so hard, and the 4 years she has suffered, and everyone thinks just because she got married and she earns a living and she got back on her 2 feet, that she's outliving her life, but she has lived with regret every single day. She's worked so hard. The 2 jobs that she's had, she's made manager in each of the jobs without people even knowing her background. Her character has pulled her through so much. So we're just asking for mercy and understanding and compassion for my mom, please.
Okay, this is heartfelt, but at the same time, did she just say that her work does not know her background? I guess because there's no conviction. Is that what she's saying?
Good afternoon, Your Honor.
Yes, sir.
My name is Anthony Leisure. I am Rita's husband. Rita has been an inspiration to me, Lord. Sir, he really has. I'm sorry, I'm nervous. She really has. And I pray that you give her leniency and allow her to come home. You know,
when a person is convicted of murder, there's the minimum sentence.
Will you please allow
the minimum
sentence, sir?
Is 30 years. That's the minimum sentence.
Your Honor.
The maximum sentence is life imprisonment.
Yes, sir. Your Honor, when I watched this video, I believed in my heart the car was running and the air conditioner was on. And we hired an attorney, and I watched the second video. And then all of a sudden, I seen a scene that wasn't in the first video. I seen her going to the car.
Yeah.
And I
hope you're not here to try to relitigate the case.
No, sir, I'm not.
Because you didn't testify.
Sir?
So we don't need your analysis of the facts of the case.
Yes, sir. Yes, sir. I asked the court for leniency.
Yes, sir.
Yes, sir. Thank you.
Thank you.
Good afternoon.
Good afternoon.
My name's Taylor Clyde. The woman in the black blazer is my wife. I'm the favorite son-in-law. I don't want to debate or bring any attention to any of the facts that happened on the day of question, but I do want to testify of the character that I've seen in Rita throughout my time of being in her family. It was always lavish Christmas gifts. It was always even with everybody else. Everybody had to have the same amount, the same ridiculous amount that I never got growing up. I always get solid hugs every time we would get together, whether it's at church, whether it's at holidays. There was always food that we would eat together, and I'd always have a ton to bring home. And after the events of the day in question, we got the chance to move her into a property that kind of was adjacent to my parents' home, which I thought was kind of cool. In her bedroom, right above her bed, was wasn't a shrine, but it was a beautiful memorial to Christina, with a blanket that was, I believe, Dora themed, and it had Christina's name on it with a nice poem. There were several pictures of her hung on the wall, and I am not a parent, Your Honor. I don't have children at this time in my life, so I have no idea what it's like to lose one. But I don't know how she was able to deal with the pain of going to bed every night and waking up looking at the wall of pictures and not completely against her will reliving the events that happened and living without her. I don't have children yet, Your Honor, with my wife, but I would very much like to have their grandmother in their life when they come. So I'm asking for leniency as well. Thank you.
That was a well-formed remark. I don't think Taylor knows that Judge Newman has lost a child as well. And bringing that up is possibly making Judge Newman think about that right now.
Good afternoon, Your Honor.
Good afternoon.
My name is Tijuana Tucker. I'm a co-worker of Rita's. I've known her
A co-worker where?
At Walmart Distributions.
Walmart.
Yes, sir. I trained Rita there, and we became friends, work friends, and we break together.
From the Walmart.
Rita moved up very quickly within Walmart. She made a huge impact on a lot of the younger associates. Got a lot of them permanent that came in through temps. She loves her family. We talk about her family a lot. She shared a lot of videos of her and Christina with me on breaks, where she had an in-ground pool put in at home because Christina loved water, and she liked for Rita to throw her into the water. Almost every day we laugh and talk about our families and things, and about the situation at hand. And it was a very tragic situation, and I personally don't think her nor Larry intentionally murdered that baby. They made a bad choice.
Well, you haven't been here listening to the law regarding murder, have you?
Sir?
You haven't been here listening to the testimony and the law regarding what constitutes murder.
I don't know her.
Have you been here?
No, this is my first time here.
Your first time coming here?
Yes, sir. But Rita's a good person, hardworking. I be with her anywhere between 10 to 12 hours, 6 days out the week at work. She's a joy. She's a joy. She's a sweet person.
Okay,
She definitely made a
Walmart
lot
works
of
people
impact
12
on a lot
hours
of
a
the
day,
young ladies
6
at the
days a
job.
week.
A couple ladies was going through some domestic violence, and she helped do that. We all got together and went to HR and got people involved to help a young lady move with her 2 children, and Rita helped with appliances and stuff, and we got groceries for her and stuff like that. So she's been advocating and talking to the younger ones and stuff like that. Again, I just ask for leniency on her. Yeah, thank you.
She deserves leniency if she's been working 72 hours a week at Walmart.
Your Honor, please read and wish to address the court in a second, but in mitigation, obviously, we're not trying to provide any excuse as to what happened that day. That's been the common thread that what we presented in this courtroom. This is an absolute tragic situation, one that unfortunately has us here today. It compounds one tragedy to another. Minimum sentence. She and I have discussed that at length as to what the sentencing ranges are. It's my position that the minimum day-for-day sentence is essentially a de facto life sentence based on the life tables. And given what my position is that we have compelling mitigation for being a loving mother, being a supportive mother, having no prior criminal history. The testament to character, there's a lot of things outside of this one day. We are not defined by the worst thing we've ever done. And in respectfully requesting leniency and mercy, I do believe that this would be appropriate in this case to receive the minimum sentence in this case. And I understand that that's still essentially a life sentence.
How old is she now?
53.
53?
Yes, Your Honor.
And the minimum sentence for murder is 30 years.
That's correct.
So 53 plus 30.
Yes, Your Honor.
If she gets the minimum sentence.
Well, as Your Honor heard, she served this community for 25 years as a teacher, two-time Teacher of the Year. Again, it's just a very, very tragic situation. When I was brought onto this case, she was working as a manager at IHOP, and then because of insurance, took the job at Walmart, and that 8 months received a promotion and became a manager. And we had one of her other supervisors here, potentially as a character witness, that was absolutely wanting, and Your Honor read a letter from him about just how critical she is and how great, not only as a person and an employee and everything in between. Her family, to say she has incredible, overwhelming family support is minimum. She has that. I know there's no words. That was part of what's that. There's no words that we can say other than we believe it's appropriate in this case, giving a compelling mitigation. Not to go into the legal part, because I think that's the next thing for another matter. But
Their appeal.
with that, Your Honor, I just feel, given what we have, this is the sentence that would be appropriate. The minimum day-for-day sentence would be essentially a de facto life sentence.
The max is
Given
life
the
without
fact
parole.
that the biggest punishment in this whole case is not the sentence that can be imposed, is the lifelong sentence she's given herself for the loss of her child. That can't be overstated. None of that was lip service. None of that was courtroom drama or manufactured. She is tortured with the loss of her child. That is real. She has real remorse, and she deserves leniency and mercy and the minimum sentence in this case, Your Honor, specifically.
Your Honor, what happened that day was the worst, most tragic mistake of my life. It was the worst day of my life. I was negligent. I told my attorney, well, I hired him almost a year ago, that a negligent homicide was one of the charges. I would have pleaded guilty, took everything myself, and we wouldn't have been here today. Because I was. When I put my baby, or I married, put that baby in that car, the air conditioner was on. It was on. When I checked her at 12:30, I just got her to teach her medicine before I took her out. She was thinking a nap. She had gone to the school. I should have taken that out and kept her alone. I should have busted out that window when the car was locked. I don't even know what's going on. I should have busted out that window. I should have got my baby out of that car. But it was nothing against her. And I will live with that for the rest of my life. Nobody loved Christina more than I did. I was working 4 jobs to get a wheelchair fit for her. Just had her fitted for a brand new top of the line wheelchair. Had her clothes ready to school. I would have never hurt my baby. I can't believe that I was convicted of murder. Because what happened was not murder. It was negligence and something that whether I'm in prison or home, I will regret for the rest of my life. And I can't wait to be with my baby girl again. Please, Your Honor, if you can consider give me a minimum house arrest, anything. I don't care. I don't have much time left anyway, and I would like to spend as much time with my children and grandchildren as I can. And know that I would have never, ever stood outside that car and watched my baby suffer. tell you what, Larry loved her too. Larry would never have hurt her. We were arguing that day, and we put ourselves in front of her. I lost total track of time, but it was not murder, it was not intentional.
Well, you know, you didn't write the law. And you weren't thinking about the law on that day, were you?
And like I said, I was negligent and I own that. And I have for 4 years. Everyone who I talked to, I told them I should have made better choices. I should have gotten that car like Larry wanted me to, and I should have taken my baby home. And there's not a day that goes by that I don't there's not. I don't. Because she would be here now, and I just taken her home. The home that I just had totally renovated for her. Her bedroom, her bathroom, the whole house was all for Christina. And as soon as I got out of jail, I put on the mortgage because it wasn't a home anymore. I didn't care about it. Because no place is a home without her.
So I can tell you a little bit about what she said there in her statement. Part of it was that if she had been charged with negligence, and like negligent homicide, she would have pled guilty, she said. But she's saying it was not murder. She did lose track of time.
Anything else you want to tell me?
We loved her so much.
All right, response by the state.
Yes.
Now the judge is going to let loose.
The conduct of the defendants in this case, true, is being represented now by the defense. That it's not a traditional murder. It's not where you pull a gun and shoot someone in the head. But your conduct can become so extremely reckless that it constitutes a willful disregard for human life and constitutes murder. To place the child in a burning car, in effect, and walking away is murder. To leave a child in a car for 6 hours under the circumstances that occurred in this case is murder. It's not one of the situations that we see, and there have been studies most recently where people forget about the child, believe that they have dropped the child off for daycare and various things. But that's not this situation, where there's absolute, total disregard for the child. Considering that the two of you were there around the car any number of times without doing anything to save this child's life and contributing to the child's death. And all the good things I've heard today, being a teacher, being a concerned person, being a wonderful friend, a person of faith, that wasn't a person there on that day when you all were on this drug binge, at least as described by Mr. King. And I've said it before, that people we see in court are typically not the people that were out on the streets doing the things that landed them in court. And it doesn't get any worse than this as it relates to a mother and a child and a person with the mother dealing with the child. So the offense that you committed was murder, and that's all there is to it. Of course, you would love the opportunity to turn back the hands of time, but you can't do it. Of course, you will continue to suffer for what happened to your child, but for being strung out on meth. And I've seen it time and time again. Was it methamphetamine we're dealing with? Yeah. But for methamphetamine and dealing with it, neither of the two of you would be here. But those were decisions that you all made. And to the extent your minds were just totally contorted, and I don't know the minds of a person on meth, but I paid close attention to the witness who testified convincingly about the effects of methamphetamine on the brain. It's as if you didn't have a brain on that day at that time. And, we're hearing about this mistake and bad judgment and all, I see it all the time with children, people who we deal with all the time. I call them children, 18-year-olds, 19-year-olds, 20-year-olds, people who do these same types of things, kill people because they're strung out on drugs, high on drugs. And, a life sentence for them is more than the lifespan that you're talking about, because they're going to prison at ages 20, 21, 22, 23 for life. And you don't have the excuse that they might come in here with. Of course, none of it is acceptable, but they will come in strung out on drugs, parents strung out on drugs, all kinds of things that play into them going wayward, going astray. And for you, a person who had a good reputation in the community, to throw it away chasing drugs, and then coming and asking me for leniency? And I'm trying to balance who's more at fault here, really, Mr. King or Ms. Panalangam. I mean, it's almost a toss-up. Mr. King put the child in the car and, per the video, just didn't care anything about the child. Just left the child there to die while they're pursuing each other. It's just so, it's almost unbelievable. How could you all do such a thing? And you could do such a thing because you're hooked on drugs, hooked on meth.
I've always been anti-drugs.
Pardon?
I divorced my first husband because he was an addict.
Mm-hmm.
I do not do drugs. I never did drugs. It was in my brain that weekend, and I have told my lawyer that several times.
She's arguing that drugs were
Yeah,
not.
that makes you having less an excuse, less justification. Your mind wasn't screwed up as you're telling us now. Yeah, a mother who's not under the influence would leave their child in a car under those circumstances for 5-6 hours, who knew the child was in the car and knew the child had been in the car for that period of time, and drive off and leave the child. How could you? Anything further?
No, thank you. Not as an excuse, but to better clarify her position. Her position is that was the first time she'd ever tried it, Your Honor, is what she said. That she didn't have a pattern of conduct of abusing the drugs, but that was the first weekend, and it ultimately led to the worst mistake of her life.
That was her first time using meth.
Yeah.
Your Honor, if any benefit, just
It was his first time as well.
no. He's not testified, and I'm not making light of it.
Yes, sir.
He did say that. No, it was certainly not his first time. He had tolerance. He was an actor, and he told the court that, and he told ladies and gentlemen, jury that. No. If it's any benefit to Mr. King has accepted responsibility from the outset. When I'm talking about the possibilities, he accepted responsibility, and he's accepted responsibility. I know it's going to be imposed on him one way or another. He can do it gracefully or not. He has done it gracefully, accepted the verdict of the court. I think he deserves credit for that. Your Honor disagrees with us.
Mr. King's lawyer says, hey, Mr. King's taking responsibility, so that should, hopefully that helps him out a little bit. Whereas Rita is saying, I never did. This is wrong. Her people.
Doesn't help me clarify in my mind who is the most culpable out of this situation, or are they equally culpable? Are there, whose conduct was the most extreme? The mother who abandons her child in that setting and does nothing to rescue the child, who chooses Mr. King and her own pleasure over the child, or Mr. King, who throws the child, or he didn't throw it, places the child in the back of the car and shows no concern, compassion, or anything for the child, and in effect joins with the mother in the treatment of the child. Though it wasn't his child, he initiated his role in it when he placed the child in the back of the car, and when he did nothing to get the child out of the car.
On behalf of Mr. King, in response to your
Yes,
Honor's
sir.
inquiry,
Yes, sir.
all my dealings with him and all my conversations with him, he doesn't want me to point the finger or some way to minimize his involvement or his culpability by saying, well, she's worse. Your Honor's heard what he's done. He owns the conduct. He was candid on the stand.
Yeah.
He accepted
Yes, sir.
gracefully at the table. He's not.
And I appreciate that. You've said that repeatedly, and I accept it, and I appreciate that.
But when Your Honor asked me who is more culpable,
In my mind, I'm trying to make that determination because I'm going to have to sentence each one of them to a period of years. They might get the same. One might get 30, one might get 40, one might get 50. They might each get the same.
to the extent Your Honor was inviting me to point out the reason she's more culpable, Mr. King does not want to do that. He owns his conduct.
All right, I understand. Thank you. And I'm not attempting to pit one against the other. I'm just,
And I feel
yeah.
that's anyway. That's how remarkable position it is. And we agree.
All right. Mr. Solicitor.
Okay, Mr.
I don't like
King's
people to
lawyer
stay quiet on me.
was saying it's not my fault, not my job, not my child.
They're both here together today because of that. I couldn't make that decision. I could not decide where she worked because the more I looked at the video, which I have done, I assure you, more than just about anybody, even in this courtroom, I just kept getting madder and madder. And honestly, I could not make a determination who I was more angry at. The man who is putting the child in the car and just stands there, or the mother that abandons the child even before we get into that situation. And I've heard the support groups that these people have in their honor. Like you, been in a courtroom for a long time. And we deal with a lot of people that don't have any support group whatsoever. And to have it, and to ignore it, I don't think that's mitigation. I think that's aggravation. Sir, I cannot tell you which one is more culpable. But quite frankly, from my standpoint, I don't feel for either one of them.
What is the penalty for great bodily injury?
20.
Ooh, 20 for great bodily injury.
0 to 20.
Yes, sir.
He wants 20 though.
And I looked it up before. I just wanted to be sure. All right, Mr. King, if you'll come around for sentencing.
They only use microphones for the benefit of the court.
King is sentenced to the court on the offense of murder that you be committed to the State Department of Corrections for a period of 32 years. Great bodily injury, the sentence is 20 years. Sentences will run concurrent with credit for any time that you've already served.
Thank you, Your Honor.
Thank you. Thank you all.
Just got a 32 and a 20-year sentence. They're running concurrently. And he thanked the judge. This is the camera angle that usually shows the jury when they're getting let out.
Ms. Panelangan, a lot of folks have said a lot of good things about you and a lot of positive impacts that you've made on their lives. You're not being sentenced to death. You won't be facing a firing squad or a gas chamber or electric chair. Your life goes on, but it'll go on behind bars. And you'll still have that same opportunity to make a positive impact on the lives of other people who you encounter. And I hope you do that. I simply cannot fathom a mother treating a child the way that you did, and allowing that to happen to a child, to your child, the child that you birthed. Yeah. I don't know if the child at some point became a burden. I don't know what the circumstances were that would lead you to placing the child in that situation. And as if you left and went to Atlanta, Georgia, or maybe we'll say not Charleston, to Myrtle Beach, and went there and got in the beach in the water a few hours, and then came back, and then decided that it's a frantic situation. You did it. You have to live with it. And as bad as the conduct of Mr. King was, yours was worse. in my mind.
There he goes.
And, you know, you can talk about intent where you have rational thinking minds, but extreme recklessness brought upon by drugs and alcohol. As we said, intoxication is not a defense and not an excuse. That's what, in effect, you're asking, and it's not. Sentence of the court is that you be committed to the State Department of Correction for a period of 37 years on murder, 20 years on great bodily injury. Sentences will run concurrent and you'll receive credit for time served. Do we have the number of days of credit that they're entitled to?
39.
You receive credit for 39 days.
They've been out this whole time.
And Mr. King, do we know how many days he gets credit for? Did Mr. Other guy left, the lawyers?
His lawyer left.
Does anyone know? I'll just have that calculated by the Department of Corrections. Yes, sir.
Under the green case that I presented earlier, the one homicide, one punishment rule, that potentially could be triggered, and certainly what we've argued, based on that, there could be only one punishment.
Okay, so concurrent.
Under that case, even the conviction itself is an actual.
Concurrent means they run at the same time. So the shorter one gets eclipsed by the larger one.
Based on that, we've also argued that that applies.
So, and you might be right, and that might pertain to a single incident, not a continuous course of conduct over many hours. What says the state?
I think it is. I think the law is clear on that there are two separate sentences, and you're saying this is it, Your Honor.
All right, well, I want to commend everyone for a good and thorough job in presenting your best case that you could present to the jury, and the jury has spoken, and now the court has spoken. And I want to thank everyone for your participation. And court will be adjourned. And thank you, jurors, and you stick around. You don't get up.
Okay, and they cut the feed. They cut the audio. All right. So, yes, the two sentences, 32 years for Mr. King. He has a 32-year sentence and a 20-year sentence. They run at the same time. So imagine he's running two races at the same time. The longer race, the 32 years, is going to take the longest time to run. He'll finish the 20-year while he's running the 32-year, and then the 20 will be gone. So, yes, it's concurrent at the same time. So the 32-year sentence is really the only one that really matters as far as that concerns. The rest is just for, I don't know how to say that. It's not going to impact whether or not he got any sentence at all on the second one. If they run concurrently, if it's smaller than the first, it won't make a difference. And 37 years for Rita on that one. Wow, that has been a long day. We have a podcast tonight. We have the podcast on this channel. Weather Watch and I will be doing the podcast. It will be a little bit lighter than what we've been dealing with today. I want to thank all of you for being here, those who clicked the subscribe button, those who gifted memberships, because you guys gifted tons of memberships today. Had amazing super chats. Thanks to the mods. I realize we have a lot of people in here that don't understand. We've got like a pretty cool thing going on here where we're pretty respectful. So verdict days, it gets a little bit crazy. Verdict days are not really a good representation of what we normally have on a day-to-day basis. But this is a fun group where we can respectfully disagree, have discussions, and still be friends at the end of the day. So thank you so much for helping make that possible. Let's see. RA, when can they get parole? I don't think they can get, I think that's a minimum. We'll save that for another day. I'll have to research that because I'm not sure if they get parole at all or if they have to serve a certain number of years first. But let's see. What was the last argument about? The last argument, the lawyer was saying basically the the two things they were sentenced for, found guilty of, were sort of jointly. It should have one sentence, not two, which really didn't make a difference. But the state said, no, you did it right. Ignore him. And you did. All right, so yes, 8 p.m. on this channel. We do have a fun-filled podcast. Weather Watch and I will be here. You can join us. It's a fun live podcast where you get to play part in that as well through chat and sometimes on the phone. You never know what's going to happen. But I think that's it. It's been a long day. We've been on for just shy of 10 hours now. But this wraps up this case. It wraps up this weekend. We have a long weekend ahead of us, too. So join us for the podcast as we kick off Labor Day weekend. Then we'll have nothing on Monday. We'll have the day off. Might do something live from, my metal detecting adventures. We'll see. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe until we go live again, which will be at 8 p.m. tonight. Give us, an hour and 15 minutes. That's all you get to prepare. And we'll be back here on this channel. Ring the bell. You'll be notified when we go live. Appreciate it. Hope you guys are all there. We'll see you. Bye.
Because he's the guy.
Is that correct?